main type of things which were laid down in these two ancient texts. First of all, we will try to understand about Kautilya. Who was Kautilya? What was his relevance? Is he important today also? So, to understand that, we will first of all try to look at his personality. Who was he? He had different names. He was called Vishnugupta, he was called Chanakya, and he was also called Kautilya. So, he had different names because he was a son of Chanak, therefore he was called Chanakya. He had the Gotra. You all know that the Gotra system is there in our country. So, the Gotra system meant that a person has ascendant's line, and the Gotra of Kautilya was Kutil, and therefore he was called Kautilya. But otherwise his name was Vishnugupta. He was a professor, he was a great scholar, and he had learned in the University of Taxila, or in Hindi Takshashila, that is now in Pakistan, but there he had gone and he had mastery over different scriptures and different systems of knowledge prevailing in those times. He was a person who was in the times of the 4th century before Christ. We are all knowing about the relevance of the time now, that before Christ, after Christ. So, when the Christ was not born, in our country we had a lot of literature, and which was also laying down some principles relating to law and justice, jurisprudence. So, what was the timing? He was in the 4th century, that was the time, and you might have heard about the great Mauryan Empire. You know what? That who was instrumental in the establishment of Mauryan Empire? It was this person. So, this person had been doing a lot of things, that how this earlier dynasty, which was called Nanda dynasty, how that Nanda dynasty can be overthrown, because the Nanda dynasty was not doing any good thing for the person, for the people, common people, and they had been wasting the treasury of the state, and he had also insulted the scholars, including Vishnugupta. So, what happened? That he had taken a vow that he will destroy the Nanda dynasty, and what he did, that he started looking for it, that how this can be done. He could not do it himself, he knew that, and therefore what he did, that he started wandering about finding a person, suitable person who will do it. And when he was looking for that suitable person, he found a boy who was playing in the field, and what happened, that he looked at him, and what he was doing, that he was looking like a leader, he was playing with different child, and he was acting like a leader, that he will do this, he will do that. He, suppose if he will become a king, what he will do to the common people. So, when Vishnugupta looked at him, he saw that this can be a potential leader tomorrow, and he interviewed him, and he said that, what can you give me? I want to do something for you. What will you give me if I am a scholar, if I am having some knowledge which will help you? He said, okay, you can take the cattle of which are there, those are not mine, but I will give you those cattle. So, that was the interesting episode, that Vishnugupta thought that this person who didn't even possess those cattle, the cows, but still he knew that if someone will give some good learning lessons to me, then I will also reward him, and because I am a leader. So, thereafter, he not only gave shelter to Chandragupta, but also he had given a lot of lessons, and he was saying that let us fight this Nanda dynasty. And then he started attacking the Nanda dynasty, but he was not successful. And then again a lesson was learned by Vishnugupta that no, this is not the right tactic. So what tactic? He was also trying to learn at that moment of time what is the strategy for a state, and later on what will be the strategy for law and justice to be established. So the war tactic that he learned, that no, we will not attack in the center where the capital city was there, but the war tactic was that they will start from the frontier position. So frontier meant that the boundary. So there he went, and with the help of Chandragupta, what he did, that he formed an alliance with the local people, and then they started attacking from the frontier, gradually moving inside and gradually moving further inside, and finally he was successful in the establishment of the Maurya Empire. And the first Maurya emperor was Chandragupta Maurya, and thereafter there was inauguration of the Mauryan Empire. So it is not known that who was Chandragupta, what was the descent of Chandragupta, but many people say that Chandragupta was not a person who was having a royal lineage. However, many scholars, they say that he might be having a royal lineage, but he was not being sheltered, or he was not being loved or cared by the royal people, but he was having his training in the common people, with the common people, and someone from the countryside had adopted him. Whatever might be the story, but what I am trying to tell you is that this was the alliance that Kautilya made with a person who was unknown, and this alliance finally proved so much successful that the Mauryan Empire went on to rule over many part of the modern country India for a long time. That was the first empire in our country. So this whole organization of the state might have been very difficult, and therefore if the state, such a large state which was not seen before, that was the first example of an empire, might be in the whole world. So that was experimental stage, which might have been for Kautilya, which might have been for Vishnugupta, which might have been for Chanakya, and he was having that daunting task to establish a system of law and justice, to try to develop a new jurisprudence. Although before him there had been a tradition of having our own jurisprudence in our country, but this was another kind of challenge, that in that big state like the Mauryan Empire, what could be the basic jurisprudence for the state and for the common people. So therefore he had written text which is called Arth Shastra. Now before him there had been a lot of writings. Those writings were called Dharma Shastra, but he wrote Arth Shastra. Why? Because to run empire, it was not simply necessary that the emperor will only be relying upon Dharma Shastra as a basic text for law and justice, but rather economy would be important. So the jurisprudence will be also having connection not simply with the code of conduct for the people, but it would be also having relationship with the economy, how the treasury, how there would be money in the coffers of the state. This will be also important. So Chanakya had a different challenge, a daunting task, to write a text which will be the basis for the running of an empire. And therefore that text was charismatic, that text was classic. However, after that text was written, Mauryan Empire was also on the verge of its destruction, and thereafter a lot of other empires they came up. But after the Gupta Empire, again, which was a great empire, during the Gupta Empire, what happened, that again there was some interest in the Arthashastra. However, after the Gupta Empire, this text was somewhere lost, and thereafter, many pages, different slokas, different shrutis, those were lost. And finally, in the British period, what happened, that again there was a revival of interest in the work of Vishnugupta. And so you see that nowadays even there is a more interest in the work of Kautilya. Therefore, we must try to understand Kautilya. What was his jurisprudence? Now, as far as his personality is considered, the Britishers said that Kautilya, he is like another Machiavelli. Machiavelli is considered to be a person, a strategic thinker, who would be having character that he will say something or he will do something. He can be instrumental in the diplomacy, and different types of diplomatic art he could develop. So Chanakya is also called as another Machiavelli by the British jurists or by the Western jurists. However, that was not true. He was not only fighting, and he did not only say that you fight with diplomacy or without diplomacy, but he also was instrumental in the establishment of a big empire. So when the Western jurists, they remember Chanakya by saying that he gave the theory, one of the theory was Mandala theory, and Mandala theory was based on the principle that every neighboring state is an enemy and the enemy's enemy is a friend. Now this is the famous theory, Mandala theory, which was considered by the Western jurists as a Machiavellian theory, and that you do alliance with the enemy's enemy but not with neighbor. So many people, they also give a different turn to this theory. However, apart from this theory, he was having lot of other things to say. The depth and the range of Kautilya's work is immense. He did a pioneer work on the statecraft. What is a statecraft? Productive enterprises, taxation, revenue collection, budget, accounts, and he also wrote something about institutions. How are they relating to law and justice? How the criminals can be detected, how there will be punishment of criminals, and removal of anti-social elements. He also talked about relation between husband and wife. He also laid down provisions relating to inheritance, contracts, and such other similar civil matters. So you see the depth and range of Kautilya's work, and you will find that his work was a great work. Let us try to understand little bit about the text itself. In the text of Arthashastra, you will find 15 chapters, and those chapters are called adhikarans. So adhikaran, you might have heard there in Sanskrit that in adhikaran means the chapter, and in this book there are how many chapters? 15 chapters. And you will find also prakaran on a specific topic. This prakaran, that prakaran, and prakaran meant that a specific topic was dealt in that very prakaran. Further, in the book you will find shlokas and also sutras. So sutras were in a different form and the shlokas were in a different form. Shlokas, it will be a two-liners, and the sutras, that will be in a maxim form, so maybe that in a small story form, so that will be kind of sutras, and there will be shlokas. There are few shlokas, only 380 shlokas are there, but more than 4,000 sutras are there. Now those all sutras and shlokas, they compose Arthashastra. It was a treatise, it was a science of statecraft, it was a science of law, and therefore it was also kind of jurisprudence. In this text you will find that Vishnugupta had referred to the works of Manu, Parashar and Brihaspati. These were the earlier jurists and the sages, the seers, who had written many voluminous treatises on the statecraft and also on law and justice, how to run the state, etc. So he had referred to all the books. You know, this is called scholarly work, when you refer to the work which has already been done. So Kautilya was not different. He also tried to refer to all the works of the earlier times, and then he wrote his own book, Arthashastra. The integral part of Arthashastra is Dand Niti. Now Dand means punishment and Niti means policy, and therefore many people call it the science of law enforcement by the state. So this Dand Niti is the integral part of Arthashastra. How the laws will be enforced, how will be the fines system, punishment system, and therefore the fine system is punishment. The kind of, giving punishment of different kinds, physical punishment, will also be very important in Dand. So Dand Niti was very important. In every chapter you will find that suppose if the code is written that this will be the conduct, then after that you will find punishments are also mentioned. What will be the punishment if the violation of the rule which is given, that is not there? If the violation will be made, then this punishment will be meted out. So Dand Niti, and Dand Niti has also a lot of good significance from a very long time. He was writing this book in the 4th century BC, but even before that Dand Niti has been also told by various other scholars, including in Mahabharata, that we will also try to understand that how in Mahabharata Dand was an integral part. But in Arthashastra you will not find only Dand, but also politics, economics and law and justice, that those are also dealt with. What is the difference between Dharma Shastras and Arthashastra? I told you that Dharma Shastras were different in the way that Dharma Shastra addressed to the individual, teaching the individuals what was his dharma, and if there would be any deviation from the dharma, that you have to do this, you have not to do this, if there was a deviation, then there will be commission of a sin, and that sin, you can expiate that sin. How? By way of penances, by performing rituals or by undergoing penances. But Arthashastra is not only directed to the individuals, rather it is addressed to the rulers, and it regards the transgression of laws as crimes which will be punished by the state itself. So you see, Dharma Shastra, the role of the state is not that important, but in the Arthashastra the role of the state becomes important, and Dand by the state becomes important. Earlier in Dharma Shastra, Dand will not be by external agency, but Dand, it was thought that there would be concept of Swarg and Narak, and in Narak there will be Dand. So there will be different kinds of punishments in the hell, that is Narak. So this kind of thing was there in Dharma Shastra, but in Artha Shastra the responsibility was given on the state, that state will help the poor and punish the person who is the violator of the law. So it is having some different meaning than in the Dharma Shastra. So Dharma Shastra and Artha Shastra both are different. As far as the state is concerned, because you see, for the first time new kind of a state had been born, and therefore what he was saying, that the state is having the 7 constituents, and what are those 7 constituents, that we will see also. And this 7, we have 7 days in the week, we have the concept of 7 chariots of the sun, we have also the concept of Saptarishi, 7 sages. So this 7 is also very important. 7 constituents of the state. Chanakya was saying that which is the first constituent? The king himself. King was called Swami. So Swami was the king, and thereafter came the ministers. Ministers of the government, and ministers were called Amatya. So the ministers would be having the role to advise the king. Swamis were advised by Amatyas, and thereafter Purohit was there. Purohit was the chief priest. So the role of the priest was also important in those times. Nowadays there is no such importance given to the priest, but in those times the priest had also been given important role, because he will tell that what rituals can be performed, what rituals are important if a person has deviated from his code of conduct. Thereafter came the 4th wing of the state. The constituent wing of the state was Rashtra, the territory, and it was very important for the king, for the Swami, to have control, full control over the Rashtra, which is the landed territory. And if there will be any invasion, if there will be attack by the foreign powers, then there was the duty of the king to protect the Rashtra from the invaders. So Rashtra was also a very important wing of the state. Then there was Durg. Durg meant fort, the place of the capital or such other towns where the commerce was going on, lot of commercial activity was going on, might be that there also a fort might have been built. So to protect the fort also, this was one of the important constituent of the state itself. So it was the kind of, today we can say cities, like we have you can see that in cities how much business and commerce goes on, and likewise in those days it was the fortified areas. So Durg areas where there were Durgs, and the largest Durg was the capital where the Mauryan emperors they resided. And then there was the next element was Bal, force, and that force was a wing of the state, and this force, as far as jurisprudence is concerned, this Bal was kind of organized Bal, and that organized Bal was in the form of king and the police personnel and those defense personnel, and then the courts, judges, and the other officers of the court. And the last was Kosh. Kosh meant treasury. It was very important. All other things could not be done if there would be drain in the Kosh. So how this Kosh should be protected. It was important that course should not be always going withering away, it would not be draining, but it should be also the coffers, the state coffers, that should be having lot of pun. At that time the coin was called pun, and lot of puns and karshapans you might have heard. You might have watched the series, tele-series that was on Chanakya. You might have heard about karshapan. So that was the system of coins. So it was, the treasury would have lot of coins, lot of karshapans in it. Thereafter we will also look at the law and justice during the Mauryan times and how the Arthashastra dealt with the law and justice. You know that law and justice delivery, that depends upon the people, who are the judges, who are the magistrates, and here also in Arthashastra also we will find that the judges and the magistrates played an important role. How was the court composed? The court was composed of judges and magistrates, and in those times also there was a bench system. No one can say that the bench system only came after the British came to India. There was the bench system. 3 judges, they constituted a bench. Now in the modern times the court system allows even to have a bench of 1 judge, single judge bench, but in those times bench of 3 judges, that was essential. Now 3 judges will be called full bench, but in those times even a bench smaller, the smallest bench would be having 3 judges. And as far as the courts are concerned, the courts will be at different places. It will not be only in the capital city. The courts will also be, because that was the empire, and in the empire the courts should be located at those places where the chances of disputes are high. So the courts were established at the frontier areas and also in the sub-district headquarters and at the level of provincial headquarters. So there was a tier system of courts. It was like, frontier posts, the border posts, the border courts, and then at the sub-divisional level, and there was also courts at the provincial level. Who were the judges? You might be also interested in knowing that in those times whether there was a necessity to obtain an LLB degree. The answer was no. There was no such LLB degree in those times. But in those times the learning was in the dharma. You must know the dharma shastras and the vyavhar. What was the dispute, how the dispute can be resolved. So this vyavhar also must be known to the judges. Dharma shastras as well as the vyavhar shastra was important for the judges. They must know that, and they must have the qualifications to become the minister, amatya of the kings. So the qualification was very high. It was not that anyone could become a judge of the courts. The conduct of the judges, that was also very important, because they are sitting at the higher pedestal, therefore their conduct should not be mean. What was the conduct? Conduct of judges in the court should be most dignified. Otherwise, if that dignity will not be maintained by the judges, then there was a possibility that judge could also be punished. Now this was a different era of time when the judges could also be punished if there would be such undignified behavior. And what was the undignified behavior? Suppose if a judge would always chide the litigants, if the judge will scold the litigants, this will not be a dignified behavior, because the litigants have already been exploited litigants should not be exploited further. They should not be scolded because they have come to your court, and therefore you should patiently hear, you should look at the problems of the people who have come to your court, and that you should cool them down, and then hear them, try to apply the rules which are there in the Dharma Shastras and Vyavahar Shastra, and then finally decide it. Then only they will also think that this is the place where I got justice. Otherwise, if you will not behave in a good way, if you will not be decency, you will not maintain decency and dignity in the court, then there will be a possibility it will be called misconduct and you can be punished. But judges were empowered also to resolve the dispute, and judges and magistrates, they could determine whether to levy the highest penalty or the middle penalty or the lower penalty. So even today you will find that this is the discretion of the judges, that suppose if the penalty is prescribed, then what penalty can be given. However, in those times you could notice here that the penalty was also a middle level penalty. So middle penalty, the lower penalty and the highest penalty. There were three types of penalty which were prescribed, and the judge and magistrates had the power to inflict such kind of penalties. How this penalty will be inflicted? It will be some elements must be taken into account. The nature, the gravity of the offense, the motive, the circumstances prevailing at the time of the commission of the offense, as well as maintaining a balance between the interest of the king and also the individual. So here you could find that even sometimes, balancing. What is balancing? You might have heard about the sociological school of jurisprudence. I had taken a lecture on sociological school of jurisprudence, Roscoe Pound, you remember. So here comes that how this will be done, the penalty, what will be the important considerations while inflicting a penalty, that is also important. So in the Arthashastra you will find that a kind of positivist jurisprudence, that a state has a role, the state can punish, the state appoints the judges and magistrates, and there is a dandaniti, there is a possibility of handling the situation with dand, that is iron, and this is the positivist school. However, there is also a kind of trickle of sociological school, where the balancing of interest of the king and the individual, and the king's interest will be a social interest and the individual's interest may be a private interest. So the balancing will be done by the judges and the magistrates. Coming on to the next portion of the jurisprudence which was laid down in Arthashastra, you will find that how the civil matters would be decided and what will be the procedure to be followed in the civil matters. That was also written by Chanakya. So there has been a tradition before him. I told you that he referred to the work of Manu, Brihaspati, Parashar. They had also referred to the settling of disputes, but I told you that Chanakya's method was little bit different. And what he said, that the judges themselves shall take charge of some affairs. And which affairs? The affairs of gods. Who will protect the gods? Now you might have heard that there is a lot of discussion going on that now there will be public interest litigation. Sometimes the judges, they also take suo motu notice that this god should be given the status of legal entity. But in those times also, now how much is the problem that sometimes the argument will be that God is not a legal person, and therefore there is no locus standi if someone will say that okay, how God has been injured. So who will take care of that? Now in those times, what Arthashastra laid down, that the judges themselves shall take charge of the affairs of gods. So the judges had to protect the gods, the interest of the gods, the interest of the temples where the gods are there, and then the Brahmins, the ascetics, and the women. Now women, who will protect the women? Suppose if the women are not coming directly, it was a duty of the judges to take charge of the affairs of women. Minors, if a minor is suffering, who will do something for him? And suppose if the guardian is not doing, then the judge has to do. Old people, so this was very different, and that jurisprudence which was laid down by Kautilya was that even the old people's interests, the sick people's interests, and those people who are helpless, those people who are orphans, you see that kind of empathy was shown by Kautilya, that this will be the duty of the judge to provide legal aid. In another lecture we were trying to understand about the need of legal aid, the need of access to justice for all the people. Now here comes Kautilya, who said in those times that the judges, they should take charge of the interest of the helpless. And he said even when they do not approach the court, then also the judge can do something. So this was the kind of jurisprudence which was there in such situations. And in the normal civil cases, the procedure was that no suit of such persons, that orphans, the women or the minors, if they will file a suit, then what will happen, that no suit of those people will be dismissed for want of jurisdiction or delay, passage of time, or adverse possession. So the court must take it that very seriously. And then in the normal matters, the procedure was that the plaintiff and the defendant shall both be the persons who will be fit to sue and to be sued. And thus the whole thing about sureties, that what will be the sureties in the civil matters, that Chanakya provided about sureties. It said that they shall provide sureties to cover fines and payments for the loss of suits. So if there is a fear that the suit will be lost, then there would be also the possibility that the surety will be taken. The same case shall not be filed against a defendant twice. So kind of, you see, double jeopardy, that will not be there. So all these things, some sort of, you can remember that this is also present in today's times. Rejoinders, plaintiffs can file a reply to the statement, but on the same day it has to be filed. Counter statement has to be filed by the defendant. The maximum time was also prescribed for the defendant to file his defense, and the maximum time was 45 days. After that, the suit will be decreed against him with costs. So this was also kind of security or a deterrent to the defendant, that if he will not be filing the defense or appearing in the court, then he will lose it. As far as witnesses were concerned, it was also laid down that witnesses must be trustworthy. Any witness, or you find a witness in the market, that will not be helpful. Witnesses must be trustworthy, and then the number of witnesses must be 3. It will not be sufficient if there will be 1 witness. So normally the standard was that if witnesses were 3, then it is fine. And you will be again wondering that did he refer something, did he lay down some jurisprudence on the social life, although his treatise is on Arthashastra, but I told you that social life, economic life, he made lot of rules. So he made rules on the marital life. He says that 8 types of marriage will be recognized by the state. you see, in those times, thousands of years back, marriages were performed in different ways. People had different practices of marrying each other. And in those times also, 8 forms of marriage were recognized by the state, and this treatise also recognized this thing. What were those? Just I will tell you in, I will just name it. Like the first form of marriage was Brahma marriage, another was Prajapatya, third was Arsh, fourth was Daiv, fifth was Gandharv, sixth was Asur, seventh was Rakshas, and the eighth was Paisach. Now all these words you might have heard, but some of the words which you might not have heard, I will just tell you the meaning. Like Brahma marriage meant the whole traditional kind of marriage where a father gave away the bride in a well adorned place, and the daughter would be also well adorned, and then the father will give away the bride. Prajapatya marriage will be different, where the joint performance of sacred duties will be performed by a man and woman, but without the prior consent of the woman's father. So here the consent of woman's father to perform the sacred duties jointly, that will not be taken. So if that happened, that was called Prajapatya marriage. Arsh marriage was also a different marriage, where the marriage was subsequently regularized. Initially it was not regularized because initially it was not recognized, but later on it was regularized by the husband presenting 2 cows to the father of the wife. So there were different types of marriages, and you will be thinking that, you see, in those times also what was the scene, what was the cases. But in all these forms of marriage, giving gifts voluntarily to please the bride shall not be forbidden. This was the rule made. So you could give the gifts to the bride, to the potential bride, and this will not be called illegal. Giving the gift is not illegal. So even today you like the gift, and you can also, to marry a girl, you could have given a lot of gifts, and this was not punishable. However, under no circumstances can an agreement of marriage be revoked if the girl conceives a child by the man. Suppose if the girl conceives a child with a man, then there will be no chance that marriage will be revoked. There will be definitely, the marriage will go on, and you can't say that now I want to revoke. One party can't say that I want to revoke it. So this was the kind of jurisprudence in those times. And as far as the fraud relating to marriage was concerned, he also laid down the rule that it will be an offense to show one girl and substitute another at the time of marriage. So this is a fraud. So at the time of marriage another girl was there, and when you went to see the girl with the possibility that you can marry, another girl was there. So this was considered fraud at that time also, and it was punishable. So that was also in those times the law on marriages. And next thing was that breakdown of marriage. The marriages could be broken down also in those times. You see, thousands of years back, marriages could be broken down. And what were the situations? Many people say that divorce was not possible in those days, but there was the possibility of divorce. And there were situations that if a wife abandoned her husband, and why the wife abandoned her husband? Because the husband had bad character. Now in that case there was a possibility of breakdown of marriage. If the husband went away from home to a foreign country for a very long time, that was also a case in which the possibility of breakdown of marriage could happen. If a husband is a traitor to the king, that is also a situation when the marriages will be broken down. If the husband threatens the life of his wife, domestic violence, then also what may happen, that marriage can be broken down. If the husband is declared an outcast, in those times. Different world was there. So this was a situation of breakdown of marriage. If the husband becomes impotent, that was also a ground. Cruelty to wife and cruelty to husband, both were punishable. Misconduct of wife and husband was also punishable, and it was a ground of divorce. So we see that in those times also, today we talk about family laws. In those times also there was a family law. There was a code of conduct for the members of the family, and how the people in a married life they will behave, and what will happen if there will be incompatibility, if there will be a breakdown of marriage. Apart from that, there were provisions on loans, deposits, pledges, mortgages. In Arthashastra, you will find terms which were our own, in our own language, like Upanidhi. We are all knowing about deposits. It was called Upanidhi. Pledges, today we call pledges. In those times it was called Adhi. And then mortgages was called Adhan, and entrusting articles to artisans was called Ch-26, and all these were regulated. So deposits were regulated, Upanidhi was regulated, Adhi was regulated, Adhan was regulated, Ch-26 was also regulated, and you would find that all such agreements will be arrived at openly in the presence of witnesses and with all details such as time, place, quality, quantity. These things will be also written down. The law of evidence was indeed formulated primarily in connection with the debts. So whole jurisprudence on evidence law that developed. And it was also said that no one will recover interest without agreeing on the rate of interest at the time of making the loan. It will not be changed thereafter. For normal transaction, the rate of interest was also provided. It could go up to 15% per annum. So at that moment of time, interest was higher. There were laws on pledges, whereof two kinds, usufructuary and non-usufructuary. Usufructuary means that a pledge which is in which the goods which you pledge to the creditor can use it. Now there was a rule on how to use it, when to use it. So the rule was that a pledge shall not be used by the person entrusted with it for his own benefit without the prior agreement of the owner. So that was the rule laid down in Arthashastra, because maybe that there might have been so many instances in which it was used without any agreement by the creditor. And the rule further said that if the creditor did so, he will pay the owner the profit earned minus any interest due, and maybe that he will have to pay the fine also. So this was interesting, because in those times also you would wonder that in those times also the rules were framed in that manner. Further, if an item which is pledged is useful, for example a cow whose milk can be used by the creditor, in such situation no interest shall be payable on the money which is lent against it, and the debtor shall never lose his right to redeem it. Interest may be charged only with prior agreement. And finally, if an item pledged yields no benefit, in that case interest may be charged on the amount lent, and the pledge may be forfeited if not redeemed within the stipulated period. I wonder that such detailed law was there in those times. Law of contracts was also there. I will just tell you some of the main things about the law of contract written in Arthashastra. It said that any contract entered into in person by anyone with others of his own class, community or group shall be valid, provided that the contract is concluded in a suitable place and at a suitable time, observing all formalities including presence of witnesses. So you will find that the rules on contract was also laid down. So how was the Arthashastra? Arthashastra had lot of rules and it had laid a different new jurisprudence in those times. Now we will come on to Mahabharata. What was the jurisprudence in Mahabharata? I will be very brief here, because you see that Mahabharata was even older than the Arthashastra. And in Mahabharata you will find that there is a famous episode of the conversation between Arjun and Lord Krishna, and Arjun explains the meaning of dand in those times. So dand in Mahabharata time also, it was an important element of statecraft, and Arjun explains that the laws which were meant to keep the people civilized are called dand. And there is a line in Shanti Parv which says that dando hi Bhagwan Vishnu, dando Narayan Prabhu. It meant that what is the relevance of dand in those days? Punishment was very important. Dand was Bhagwan, dand was God, and dand was Narayan Prabhu. So there are lot of references that when the king rules according to dand niti, then the golden age flourishes, Kirti age is flourishing. The dand niti it is considered to be the Magna Carta of liberties in the times of Mahabharata. And Shanti Parv of Mahabharata, whenever you have time, you can refer to Shanti Parv of Mahabharata, because that is the place where jurisprudence in those times was laid down. There were certain nitis, the jurisprudence in those times, like Gandhari Niti. You might have heard about the peace proposal which was given by Lord Krishna to avoid the war, and when that proposal was discussed in the court of the king, at that time Duryodhan, then what happened? When the peace proposal given by Krishna failed and Duryodhan with his men left the hall, Dhritarashtra asked Vidur to bring Gandhari in the hall. And you know what? Gandhari came. Dhritarashtra asked Gandhari that you persuade Duryodhan. But then Gandhari said that you have done it, and therefore it will be very difficult. Duryodhan is not controlling his behavior himself. So you will find that Gandhari Niti was to avoid the war. About the monarchy also, Mahabharata had certain jurisprudence that there was a need of having a king. Monarchy was very important. It should not be left to the people, that people will regulate everything themselves. There was the need of having an organized state, and the monarchy was also very important. On the war, Mahabharata said Dharma Kshetre Kurukshetre, meant war was allowed, but war should not be unjust, war should be just. And therefore he says that jurisprudence, that you have to choose between two evils. One will be the lesser evil, that which is the just war, that you can choose, because sometimes wars become essential to protect the interest of the country. The Krishna's advice to choose the lesser evil, that is akin to the heart-fuller debate, that the choice of lesser evil could be in certain circumstances be preferable. In Mahabharata you will also find the use of weapons, how the weapons can be regulated. The famous weapons in Mahabharata times like Brahmastra, how that can be used, those weapons could not be left unregulated. You might have heard about the instance of Ashwathama, that how during the times of war,
Swayam Prabha, Digital India, Educated India.
The third requirement for determining patentability is that the invention should be capable of industrial application. Capable of industrial application is defined under 2(1) AC. It states that in relation to an invention means that the invention is capable of being made or used in an industry. So if it is capable of being made or used in an industry, it is understood that it is capable of industrial application. Now, the alternative word for capable of industrial application is utility, that the invention is useful. Usefulness is tied to industrial application. There's a reason for this, because the industry as we understand it is a place where things are mass produced. You can replicate things in a large number, and duplication of things in an industrial scale means there is an assembly line of production and things can be duplicated in great number. Intellectual property rights, especially when we talk about patents are granted for things that you can repeat in big numbers. So if an invention is patented and a patent is granted, it is granted with the promise that you have disclosed something which will be useful. So the usefulness can be demonstrated when a person is able to create large numbers of it in an industrial setup, or he is able to use it in an industry, again for mass production. So the mass production is something which is tied to intellectual property rights in general and more specifically to patent law. Patents were granted with the promise that what was patented could be repeated in the same manner by creating multiple copies of it. So the utility requirement, which is also regarded as the invention should be capable of industrial application, requires the invention to be useful in producing mass copies of the same. Now, the capable of industrial application could also bring in an element that an invention, when it is patented, need not be immediately capable of industrial application. It could also be that a person who has filed a patent could make a working model or could make a working version of his invention sometime in the future. So patents are also filed for, there is a prospect theory which says that patents can also cover prospects even before the prospect actually ends up in a working version.
Swayam Prabha. Digital India. Educated India.
Person skilled in the art. We had seen that in the definition of inventive step, we had seen that the invention, to involve an inventive step, it should not be obvious to a person skilled in the art. The person skilled in the art is not defined in the Patents Act. The word person is defined, a person interested is defined, but a person skilled in the art is not defined under the Act. In fact, there are various other phrases in patent law which do not find a definition in the Patents Act. For instance, infringement is not defined under the Act. Now, the phrases or the words that are not defined under the Act will take the meaning of what is generally understood. And if there is a specific meaning, then we will ascertain that meaning from case laws, and we know that patent law has a rich case law history which pertains to cases that were decided not only in this country but also in England, because we inherited the 1911 Act was a British Act. So all the cases decided under the 1911 Act will also form a part of the patent law of this country. So a person skilled in the art is a concept in patent law, which we had already explained when we had dealt with the inventive step requirement. A person skilled in the art is a notional person or a hypothetical construct who is construed or who is created to construe the invention to see whether the invention would be obvious or not. So it is the standard by which the inventiveness of an invention is ascertained. It is a notional construct. It is created by the court in cases where there are multiple technologies interfacing together. Then the person skilled in the art will be a person who is attributed with all the knowledge in that particular domains. A person skilled in the art need not be a person, it could be a group of persons, and in modern times we understand a person skilled in the art as a person who is attributable with the knowledge of the invention and all the fields of technology that converged to form an invention. As we had mentioned, art refers to technology, and art can change from invention to invention. So if an invention has three different types of technology coming together, say technology on organic chemistry, technology on biotechnology, and technology pertaining to nanotechnology, then the person skilled in the art will be attributed knowledge of all these three technologies. A person skilled in the art will be attributed of all the knowledge in the public domain and all the knowledge that he is entitled to know. In patent law, we use the phrase common general knowledge. So the person skilled in the art will not only know every published material that is there in his domain, but he will also have common general knowledge, knowledge that is general to his field. For in some cases, tacit knowledge will be a knowledge a skilled person has which is not codified or which need not be codified or documented. A person skilled in the art will also be attributed this knowledge which need not necessarily be in a documented manner. So an inventive step analysis, because it brings in a person skilled in the art, it is different from a novelty analysis because the person skilled in the art brings the mental component. He is able to read documents together, so mosaicing is permitted because the person skilled in the art is the person from whose viewpoint inventive step is determined, whereas in novelty analysis it is not permissible to do mosaicing. A person skilled in the art is attributed the common general knowledge, which could be knowledge beyond what is in published document. So to that extent, an analysis of inventive step will have the mental element what is attributable to a person skilled in the art.
Swayam Prabha. Digital India. Educated India.
Patent specification. Patent specification is the document that encompasses the invention. But the patent specification is the written document in which the invention is described. Under the various forms that have to be filed for getting a patent. Form 1 is the form that is used for filing the patent application itself, where you have details about inventors, about the applicant, about the filing requirements, the capacity in which the applicant is filing, so on and so forth. Form 2 is a separate form which will contain the patent specification. The specification will encompass the details of the invention, whereas Form 1 will have details about the inventor, about the type of application, the mode in which the application is filed, and the fees that is to be paid. The Form 1 will have all the administrative details about the invention, whereas Form 2 will have the substantive details about what the invention is. So Form 2, the structure of Form 2 is different. So when we say a patent specification, we are talking about the document that is encompassed in Form 2 of the patent rules. Patent specifications are broadly of two types. Section 9 talks about two types of patent specification, provisional and complete. And you use the same form for provisional and for complete. So when you look at Form 2, Form 2 is titled provisional/complete specification. Now the only difference between Form 2, which is filed for provisional and complete, is that when it is filed for a complete, you have claims in it. The claim column is filled in the case of a complete specification, and if you see the entry number 5 in Form 2, you will find that claims not applicable for provisional specification. So the claims are that part of Form 2 which distinguishes a provisional from a complete. In a provisional, there is no need to file a claim, whereas in a complete, for us to regard something as a complete, there has to be the claim, and the claim is the concluding part of the specification. Section 9, Provisional and Complete Specification. The Patents Act makes a distinction between a provisional and a complete specification, though both these specifications can be filed using the same form. So the form that has to be used for filing a provisional or a complete specification is Form 2. The distinction between a provisional and a complete specification may not be clear upon reading of the Section 9, but the form makes it clear as to what could be the possible distinction between the provisional and a complete specification. And the provisional and complete specification are not terms that have been defined under the Act. There's no definition. So as we mentioned in the earlier lecture, if there is no definition in the Act, then we go by the normal common meaning. Provisional is something that is being done as a temporary measure, and provisional also means that it will be followed up by something which is complete. So the provisional is something that is a time bound specification which has a short life, and by its nature the provisional has to be followed by something that is complete. Now for those who have graduated will know that soon after graduation you get a provisional degree certificates, and the original or the degree certificate will follow through later. We don't call it the complete degree certificate. It's the understanding that provisional is meant for a short period till the original is issued. In patent law, a provisional specification does a similar function. The provisional specification can be filed, but you have to follow up with a complete specification within 1 year. So that is the time period that has been given for you to file a complete. So as soon as you file a provisional, you have to follow it up anytime. It can be much before the 1 year period, but the maximum time period allowed for filing or following it up with a complete is 1 year. In case you don't follow a provisional with a complete, then the provisional will lapse. Now Section 9(1) tells that where an application for a patent, not being a convention application or a PCT application, those are international applications, so this provision excludes international application, is accompanied by a provisional specification, a complete specification shall be filed within 12 months from the date of filing the application. So it says if a provisional is filed within 12 months, a complete has to be filed. And if the complete is not filed, the application shall be deemed to be abandoned. Now, this is a phrase which you need to understand, because this phrase appears in other parts of the Act, and there is also a parallel phrase which is called deemed to be withdrawn. Deemed to be abandoned is a phrase which we will understand as the patent application expiring because of the inaction of the applicant. Something was required to be done by the applicant did not do it, which led to the cancellation or the expiry of that application. That cancellation or that inaction is deemed as an abandonment by the applicant. So this is a fiction. The law uses a fiction, a legal fiction, that the inaction of the applicant is treated as though he had abandoned the application. And you will find that the patent system is structured with legal fictions where inactions will be treated as something else. So the fact that you didn't file a renewal fee on a timely basis will lead to the rejection of your patent itself. Your patent will lapse if you don't file that's again a fiction. You don't file the fee, the patent will lapse. You don't reply to the controller's objections, your patent will be deemed to have been abandoned. You don't file a request for examination, your patent application will be deemed to have been withdrawn. So all these fictions are done in such a way that the patent office is always interested in shifting the burden onto the applicant. It is the task of the applicant to ensure that he does everything within the timeline to get the application granted. So the patent system itself is structured in such a way that there are timelines for doing things. If you fail to do those things during those timelines, your application will be treated as abandoned or withdrawn. So this is something which will appear in other parts of the Act and the rules as well. So 9(1) tells us if provisional application is filed, it has to be followed by a complete specification. 9(1) tells us that if a provisional specification is filed, it has to be followed by a complete specification within 1 year. If it is not followed by a complete specification, then the application will be treated as abandoned, deemed to be abandoned. 9(2) says where two or more applications in the name of the same applicant are accompanied by provisional specifications in respect of inventions which are cognate or of which one is a modification of other, and the controller is of the opinion that the whole of such invention are such as to constitute a single invention and may properly be included in one patent, he may allow one complete specification to be filed in respect of all such provisional specifications, provided that the period of time specified in subsection 1 shall be reckoned from the date of filing the earliest provisional specification. There has to be a cross reference to this to section 10(5). 10(5) again talks about the concept of the single inventive concept, or the fact that the inventions constitute a single invention. 10(5). This provision tells us that there could be, if there are many provisional specifications filed by the same applicant covering a related aspect of an invention. Say there is a mechanical device which is a combination of many devices and it can do a particular function, a provisional is filed for that. There is another functionality. After a few months, the applicant files another provisional for the same device or a same combination of devices, another functionality. And after a few months, the applicant again files another provisional covering yet another functionality of that device. Now, if the controller feels that all these three provisional applications cover the same invention but different aspects of it, and if the controller is of the opinion that they all constitute a single invention, then the controller can allow the applicant to file one complete to cover the three provisionals. So this provision tells you that there could be multiple provisional specifications filed covering various aspects of one invention. You can follow multiple provisional specifications with one complete. So The disclosure made in a provisional, as far as it relates to a single invention, can be followed up by one complete. So it's not necessary that every provisional should be followed up by one complete specification. You can club provisional specifications provided they relate to the same invention. The section 9.2 uses the language cognate, provided they are cognate or one is a modification of the other. In such cases, the controller can allow one complete to be filed based on multiple provisional specification. The catch is complete specification has to be filed within 12 months from the date of the first filed provisional specification. The Act calls it the earliest provisional specification. So the timeline, so there could be a hypothetical instance where a person files a provisional specification in the month of January. On the first of every month, he follows it up with a provisional covering another aspect, a modification or a related aspect of the same invention. So in February you have one, in March 1st you have another provisional filed, in April 1st, so on till December. Before December 31st, the applicant can file one complete specification covering all the aspects covered in the provisionals filed over the period of 12 months, and it will be allowed by the controller, provided they are all cognate, they are all related. Now this gives the flexibility for the applicant to file multiple provisionals as and when he comes up with his invention or he discovers that there is a new aspect to his invention, and follow it up with a single complete. The advantage of this provision is that as and when you come up with a discovery, you can disclose it, and your priority, and this is a concept which we will discuss in great detail later, the priority will be ascribed to the date on which the particular provisional was filed. So if an aspect of the invention was disclosed on January 1st by a provisional specification, then that disclosure, when it becomes a claim, and soon we will mention in detail the difference between claiming and a disclosure, that claim in the complete specification will get the priority from the January 1st provisional specification. Another aspect of the invention which was disclosed on February 1st by another provisional specification, if there is a claim that comes through that, then that claim will have the priority from February 1st, because that was when that aspect of the invention was first disclosed. So the priority is based on the first disclosure, and the priority can result in the disclosure being formulated as a claim. So when we look at this scheme in 9.2 allows the applicant to file multiple provisional specifications with different disclosures, but within the period of 12 months from his earliest provisional specification, he has to file a complete, and the complete will have probably 12 claims if there have been 12 disclosures, different disclosures, and each claim will have a different priority, because each claim is based on a disclosure made in a provisional specification at a particular point in time. 9.3, so 9.1 was a simple case of provisional following one complete, that has to be done within 12 months. 9.2 is a case of multiple provisionals being followed by one complete, that again has to be done within 12 months, but from the date of the earliest specification, earliest provisional specification. 9.3 deals with a case where an application for a patent, not being an international application, is accompanied by a specification purporting to be a complete specification. The controller may, if the applicant so requests at the time within 12 months from the date of filing the application, direct such specification to be treated for the purposes of this Act as a provisional specification and proceed with the application accordingly. Now, this provision allows the applicant to file a specification which looks like a complete, a purported complete. The Act uses the word purporting to be a complete specification. Once this is filed, I understand that you should be having this doubt as to what is the difference between a provisional and a complete. Now, to give you a very quick answer, the complete should have claims. Provisional need not have claims. It could also have claims, but if you file an application under Form 2 without drafting the claims, it will automatically be deemed as a provisional specification. If the claims are there, it could be considered as a provisional or a complete. It depends on how you prosecute it. So assume, for the purposes of 9.3, assume that you file a complete specification with the claims. It's a complete specification. But 6 months down the line, you write to the controller and request him to downgrade your complete, because you understood it as complete, and for all practical purposes you are going to use the same form, and you want the controller now to downgrade your so-called complete, or what you purported to be a complete, into a provisional. The controller can do that, provided you do that within the 12-month period. The controller can do that and downgrade your complete as a provisional, and it proceeds as a provisional. So what you have done in this case is you had filed something that looked like a complete, and you had asked the controller to treat it as a provisional, which would give you time, but the time is again computed from the first disclosure, which would give you some time, but which will also give you an opportunity to file more claims when you eventually follow it up with a complete. So in this scenario, you have a purported complete that is filed, that becomes a provisional because you requested the patent office to treat it as a provisional, and that provisional should be followed up by another complete, and all this should happen within the 12-month time. Now 9.3 should not be understood as a cheeky method to get more time to file the complete. It is not so. It is just a provision which allows the controller to treat a complete that is not really ready as a provisional and allow the applicant to move forward. 9.4 states that where a complete specification has been filed in pursuance of an application for a patent accompanied by a provisional specification or by provisional specification treated by virtue of a direction under subsection 3 as a provisional, that is the purported converted into a provisional, what we saw in the earlier subsection, the controller may, if the applicant so requests, at any time before grant of a patent, cancel the provisional specification and post date the application to the date of filing the complete specification. Now, post dating, there is also a concept called anti-dating. Post dating is where you change the date of priority to another date. You filed an application. Normally the date of filing is regarded as the date of priority, but if for some reason you want to post date it, the law allows you to do that given certain conditions. 9.4 talks about an instance where a provisional is filed for the first time, and within the close of 12 months when you have to file the complete, you realize that there are certain things, disclosures made in the provisional, which you don't want to come out in the public domain for whatever reason. You could write to the controller and ask the controller to cancel the provisional, because once the provisional is cancelled, it is not shared, it does not become a part of the patent documentation. So at a later point, if somebody makes a request for the information regarding to the patent, this cancel provision will not be there. Cancel the provision specification and post date the application. So now let us assume a case where a provisional is filed on January 1st, and in June 1st a complete is filed, because complete could be filed any time before December 31st, the 12-month period. Say on June 1st and complete is filed based on the provisional. The applicant feels that the disclosure made in the provisional should not be available to the public for whatever reason. Maybe the provisional was badly worded, or there was some confidential data that got into the provisional, because most of the time provisional specifications are filed in a hurry. For whatever reason, the applicant feels that the provisional should not become a part of the patent documentation. So the applicant can write to the controller requesting the provisional to be cancelled. So once you cancel, then automatically the priority of Jan 1st is not available for you. with the cancellation of the provisional, the application now has to be post dated. So the date of priority moves from January 1st to June 1st, which is the date on which the complete was filed. So the advantage or the lead time in preserving the priority which the applicant had is now lost because of post dating. So post dating is done for some very specific reasons. There could be strategic reasons for post dating things, but when post dating is done, the applicant loses the priority that he initially claimed through his provisional specification.
Swayam Prabha. Digital India. Educated India.
The third requirement for determining patentability is that the invention should be capable of industrial application. Capable of industrial application is defined under 2(1) AC. It states that in relation to an invention means that the invention is capable of being made or used in an industry. So if it is capable of being made or used in an industry, it is understood that it is capable of industrial application. Now, the alternative word for capable of industrial application is utility, that the invention is useful. Usefulness is tied to industrial application. There's a reason for this, because the industry, as we understand it, is a place where things are mass produced. You can replicate things in a large number, and duplication of things in an industrial scale means there is an assembly line of production and things can be duplicated in great number. Intellectual property rights, especially when we talk about patents are granted for things that you can repeat in big numbers. So if an invention is patented and a patent is granted, it is granted with the promise that you have disclosed something which will be useful. So the usefulness can be demonstrated when a person is able to create large numbers of it in an industrial setup, or he is able to use it in an industry, again for mass production. So the mass production is something which is tied to intellectual property rights in general and more specifically to patent law. Patents were granted with the promise that what was patented could be repeated in the same manner by creating multiple copies of it. So the utility requirement, which is also regarded as the invention should be capable of industrial application, requires the invention to be useful in producing mass copies of the same. Now the capable of industrial application could also bring in an element that an invention, when it is patented, need not be immediately capable of industrial application. It could also be that a person who has filed a patent could make a working model or could make a working version of his invention sometime in the future. So patents are also filed for, there is a prospect theory which says that patents can also cover prospects even before the prospect actually ends up in a working version.
Swayam Prabha. Digital India. Educated India.
Person skilled in the art. We had seen that in the definition of inventive step, we had seen that the invention, to involve an inventive step, it should not be obvious to a person skilled in the art. The person skilled in the art is not defined in the Patents Act. The word person is defined, a person interested is defined, but a person skilled in the art is not defined under the Act. In fact, there are various other phrases in patent law which do not find a definition in the Patents Act. For instance, infringement is not defined under the Act. Now, the phrases or the words that are not defined under the Act will take the meaning of what is generally understood. And if there is a specific meaning, then we will ascertain that meaning from case laws. And we know that patent law has a rich case law history which pertains to cases that were decided not only in this country but also in England, because we inherited the 1911 Act was a British Act. So all the cases decided under the 1911 Act will also form a part of the patent law of this country. So a person skilled in the art is a concept in patent law which we had already explained when we had dealt with the inventive step requirement. A person skilled in the art is a notional person or a hypothetical construct who is construed or who is created to construe the invention to see whether the invention would be obvious or not. So it is the standard by which the inventiveness of an invention is ascertained. It is a notional construct. It is created by the court in cases where there are multiple technologies interfacing together. Then the person skilled in the art will be a person who is attributed with all the knowledge in that particular domains. A person skilled in the art need not be a person, it could be a group of persons, and in modern times we understand a person skilled in the art as a person who is attributable with the knowledge of the invention and all the fields of technology that converged to form an invention. As we had mentioned, art refers to technology, and art can change from invention to invention. So if an invention has three different types of technology coming together, say technology on organic chemistry, technology on biotechnology, and technology pertaining to nanotechnology, then the person skilled in the art will be attributed knowledge of all these three technologies. A person skilled in the art will be attributed of all the knowledge in the public domain and all the knowledge that he is entitled to know. In patent law, we use the phrase common general knowledge. So the person skilled in the art will not only know every published material that is there in his domain, but he will also have common general knowledge, knowledge that is general to his field. For in some cases, tacit knowledge will be a knowledge a skilled person has which is not codified or which need not be codified or documented. A person skilled in the art will also be attributed this knowledge which need not necessarily be in a documented manner. So an inventive step analysis, because it brings in a person skilled in the art, it is different from a novelty analysis because the person skilled in the art brings the mental component. He is able to read documents together, so mosaicing is permitted because the person skilled in the art is the person from whose viewpoint inventive step is determined, whereas in novelty analysis it is not permissible to do mosaicing. a person skilled in the art is attributed the common general knowledge, which could be knowledge beyond what is in published document. So to that extent, an analysis of inventive step will have the mental element what is attributable to a person skilled in the art.
Swayam Prabha. Digital India. Educated India.
Patent specification. Patent specification is the document that encompasses the invention. But the patent specification is the written document in which the invention is described. Under the various forms that have to be filed for getting a patent, Form 1 is the form that is used for filing the patent application itself, where you have details about inventors, about the applicant, about the filing requirements, the capacity in which the applicant is filing, so on and so forth. Form 2 is a separate form which will contain the patent specification. The specification will encompass the details of the invention, whereas Form 1 will have details about the inventor, about the type of application, the mode in which the application is filed, and the fees that is to be paid. The Form 1 will have all the administrative details about the invention, whereas Form 2 will have the substantive details about what the invention is. So Form 2, the structure of Form 2 is different. So when we say a patent specification, we are talking about the document that is encompassed in Form 2 of the patent rules. Patent specifications are broadly of two types. Section 9 talks about two types of patent specification, provisional and complete. And you use the same form for provisional and for complete. So when you look at Form 2, Form 2 is titled provisional/complete specification. Now the only difference between Form 2, which is filed for provisional and complete, is that when it is filed for a complete, you have claims in it. The claim column is filled in the case of a complete specification, and if you see the entry number 5 in Form 2, you will find that claims not applicable for provisional specification. So the claims are that part of Form 2 which distinguishes a provisional from a complete. In a provisional, there is no need to file a claim, whereas in a complete, for us to regard something as a complete, there has to be the claim, and the claim is the concluding part of the specification. Section 9, Provisional and Complete Specification. The Patents Act makes a distinction between a provisional and a complete specification, though both these specifications can be filed using the same form. So the form that has to be used for filing a provisional or a complete specification is Form 2. The distinction between a provisional and a complete specification may not be clear upon reading of the Section 9, but the form makes it clear as to what could be the possible distinction between the provisional and a complete specification. And the provisional and complete specification are not terms that have been defined under the Act. There's no definition. So as we mentioned in the earlier lecture, if there is no definition in the Act, then we go by the normal common meaning. Provisional is something that is being done as a temporary measure, and provisional also means that it will be followed up by something which is complete. So the provisional is something that is a time bound specification which has a short life, and by its nature the provisional has to be followed by something that is complete. Now for those who have graduated will know that soon after graduation you get a provisional degree certificates, and the original or the degree certificate will follow through later. We don't call it the complete degree certificate. It's the understanding that provisional is meant for a short period till the original is issued. In patent law, a provisional specification does a similar function. The provisional specification can be filed, but you have to follow up with a complete specification within 1 year. So that is the time period that has been given for you to file a complete. So as soon as you file a provisional, you have to follow it up anytime. It can be much before the 1 year period, but the maximum time period allowed for filing or following it up with a complete is 1 year. In case you don't follow a provisional with a complete, then the provisional will lapse. Now section 9(1) tells that where an application for a patent, not being a convention application or a PCT application, those are international applications, so this provision excludes international application, is accompanied by a provisional specification, a complete specification shall be filed within 12 months from the date of filing the application. So it says if a provisional is filed, within 12 months a complete has to be filed, and if the complete is not filed, the application shall be deemed to be abandoned. Now this is a phrase which you need to understand, because this phrase appears in other parts of the Act, and there is also a parallel phrase which is called deemed to be withdrawn. Deemed to be abandoned is a phrase which we will understand as the patent application expiring because of the inaction of the applicant. Something was required to be done by the applicant did not do it, which led to the cancellation or the expiry of that application. That cancellation or that inaction is deemed as an abandonment by the applicant. So this is a fiction. The law uses a fiction, a legal fiction, that the inaction of the applicant is treated as though he had abandoned the application. And you will find that the patent system is structured with legal fictions where inactions will be treated as something else. So the fact that you didn't file a renewal fee on a timely basis will lead to the rejection of your patent itself. Your patent will lapse if you don't file that's again a fiction. You don't file the fee, the patent will lapse. You don't reply to the controller's objections, your patent will be deemed to have been abandoned. You don't file a request for examination, your patent application will be deemed to have been withdrawn. So all these fictions are done in such a way that the patent office is always interested in shifting the burden onto the applicant. It is the task of the applicant to ensure that he does everything within the timeline to get the application granted. So the patent system itself is structured in such a way that there are timelines for doing things. If you fail to do those things during those timelines, your application will be treated as abandoned or withdrawn. So this is something which will appear in other parts of the Act and the rules as well. So 9(1) tells us if provisional application is filed, it has to be followed by a complete specification. 9(1) tells us that if a provisional specification is filed, it has to be followed by a complete specification within 1 year. If it is not followed by a complete specification, then the application will be treated as abandoned, deemed to be abandoned. 9(2) says where two or more applications in the name of the same applicant are accompanied by provisional specifications in respect of inventions which are cognate or of which one is a modification of other, and the controller is of the opinion that the whole of such invention are such as to constitute a single invention and may properly be included in one patent, he may allow one complete specification to be filed in respect of all such provisional specifications, provided that the period of time specified in subsection 1 shall be reckoned from the date of filing the earliest provisional specification. There has to be a cross reference to this to section 10.5. 10.5 again talks about the concept of the single inventive concept, or the fact that the inventions constitute a single invention. 10.5. This provision tells us that there could be, if there are many provisional specifications filed by the same applicant covering a related aspect of an invention. Say there is a mechanical device which is a combination of many devices and it can do a particular function, a provisional is filed for that. There is another functionality. After a few months, the applicant files another provisional for the same device or a same combination of devices, another functionality. And after a few months, the applicant again files another provisional covering yet another functionality of that device. Now, if the controller feels that all these three provisional applications cover the same invention but different aspects of it, and if the controller is of the opinion that they all constitute a single invention, then the controller can allow the applicant to file one complete to cover the three provisionals. So this provision tells you that there could be multiple provisional specifications filed covering various aspects of one invention. You can follow multiple provisional specifications with one complete. So the disclosure made in a provisional, as far as it relates to a single invention, can be followed up by one complete. So it's not necessary that every provisional should be followed up by one complete specification. You can club provisional specifications provided they relate to the same invention. The section 9.2 uses the language cognate, provided they are cognate or one is a modification of the other. In such cases, the controller can allow one complete to be filed based on multiple provisional specification. The catch is complete specification has to be filed within 12 months from the date of the first filed provisional specification. The Act calls it the earliest provisional specification. So the timeline, so there could be a hypothetical instance where a person files a provisional specification in the month of January. On the first of every month, he follows it up with a provisional covering another aspect, a modification or a related aspect of the same invention. So in February you have one, in March 1st you have another provisional filed, in April 1st, so on till December. Before December 31st, the applicant can file one complete specification covering all the aspects covered in the provisionals filed over the period of 12 months, and it will be allowed by the controller, provided they are all cognate, they are all related. Now this gives the flexibility for the applicant to file multiple provisionals as and when he comes up with his invention or he discovers that there is a new aspect to his invention, and follow it up with a single complete. The advantage of this provision is that as and when you come up with a discovery, you can disclose it, and your priority, and this is a concept which we will discuss in great detail later, the priority will be ascribed to the date on which the particular provisional was filed. So if an aspect of the invention was disclosed on January 1st by a provisional specification, then that disclosure, when it becomes a claim, and soon we will mention in detail the difference between claiming and a disclosure, that claim in the complete specification will get the priority from the January 1st provisional specification. Another aspect of the invention which was disclosed on February 1st by another provisional specification, if there is a claim that comes through that, then that claim will have the priority from February 1st, because that was when that aspect of the invention was first disclosed. So the priority is based on the first disclosure, and the priority can result in the disclosure being formulated as a claim. So when we look at this scheme in 9.2, 9.2 allows the applicant to file multiple provisional specifications with different disclosures, but within the period of 12 months from his earliest provisional specification, he has to file a complete. and the complete will have probably 12 claims if there have been 12 disclosures, different disclosures, and each claim will have a different priority because each claim is based on a disclosure made in a provisional specification at a particular point in time. 9.3, so 9.1 was a simple case of provisional following one complete that has to be done within 12 months. 9.2 is a case of multiple provisionals being followed by one complete that again has to be done within 12 months but from the date of the earliest specification, earliest provisional specification. 9.3 deals with a case where an application for a patent, not being an international application, is accompanied by a specification purporting to be a complete specification. The controller may, if the applicant so requests at the time within 12 months from the date of filing the application, direct such specification to be treated for the purposes of this act as a provisional specification and proceed with the application accordingly. Now, this provision allows the applicant to file a specification which looks like a complete, a purported complete. The act uses the word purporting to be a complete specification. Once this is filed, I understand that you should be having this doubt as to what is the difference between a provisional and a complete. Now, to give you a very quick answer, the complete should have claims. Provisional need not have claims. It could also have claims, but if you file an application under Form 2 without drafting the claims, it will automatically be deemed as a provisional specification. If the claims are there, it could be considered as a provisional or a complete. It depends on how you prosecute it. So, assume for the purposes of 9.3, assume that you file a complete specification with the claims. It's a complete specification. But 6 months down the line, you write to the controller and request him to downgrade your complete because you understood it as complete, and for all practical purposes you are going to use the same form, and you want the controller now to downgrade your so-called complete or what you purported to be a complete into a provisional. The controller can do that provided you do that within the 12-month period. The controller can do that and downgrade your complete as a provisional, and it proceeds as a provisional. So what you have done in this case is you had filed something that looked like a complete and you had asked the controller to treat it as a provisional, which would give you time, but the time is again computed from the first disclosure, which would give you some time, but which will also give you an opportunity to file more claims when you eventually follow it up with a complete. So in this scenario, you have a purported complete that is filed, that becomes a provisional because you requested the patent office to treat it as a provisional, and that provisional should be followed up by another complete, and all this should happen within the 12-month time. Now 9.3 should not be understood as a cheeky method to get more time to file the complete. It is not so. It is just a provision which allows the controller to treat a complete that is not really ready as a provisional and allow the applicant to move forward. 9.4 states that where a complete specification has been filed in pursuance of an application for a patent accompanied by a provisional specification or by provisional specification treated by virtue of a direction under subsection 3 as a provisional, that is the purported converted into a provisional, what we saw in the earlier subsection, the controller may, if the applicant so requests at any time before grant of a patent, cancel the provisional specification and post date the application to the date of filing the complete specification. Now, post dating, there is also a concept called antedating. Post dating is where you change the date of priority to another date. You filed an application, normally the date of filing is regarded as the date of priority, but if for some reason you want to post date it, the law allows you to do that given certain conditions. 9.4 talks about an instance where a provisional is filed for the first time, and within the close of 12 months when you have to file the complete, you realize that there are certain things, disclosures made in the provisional, which you don't want to come out in the public domain for whatever reason. You could write to the controller and ask the controller to cancel the provisional, because once the provisional is cancelled, it is not shared, it does not become a part of the patent documentation. So at a later point, if somebody makes a request for the information regarding to the patent, this cancel provision will not be there. Cancel the provision specification and post date the application. So now let us assume a case where a provisional is filed on January 1st, and in June 1st a complete is filed, because complete could be filed any time before December 31st, the 12-month period. Say on June 1st and complete is filed based on the provisional. The applicant feels that the disclosure made in the provisional should not be available to the public for whatever reason. Maybe the provisional was badly worded, or there was some confidential data that got into the provisional, because most of the time provisional specifications are filed in a hurry. For whatever reason, the applicant feels that the provisional should not become a part of the patent documentation. So the applicant can write to the controller requesting the provisional to be cancelled. So once you cancel, then automatically the priority of Jan 1st is not available for you. With the cancellation of the provisional, the application now has to be post dated. So the date of priority moves from January 1st to June 1st, which is the date on which the complete was filed. So the advantage or the lead time in preserving the priority which the applicant had is now lost because of post dating. So post dating is done for some very specific reasons. There could be strategic reasons for post dating things, but when post dating is done, the applicant loses the priority that he initially claimed through his provisional specification.
Swayam Prabha. Digital India. Educated India.
Hello everyone, this is Dr. Shabnam, Associate Professor from the Faculty of Law, University of Delhi. This is my lecture number 12 and I will be talking about the forest laws in India. I have taken this topic as a lecture number 12 for the reason that this was the first law which was brought in India with respect to environment. We did not have any other law even in our ancient societies, but the forest and the respect for the forest persisted even in the ancient societies. So these laws in India, when they are framed, these hold importance as the first environmental laws framed either in an ancient manner or during the British rule or during the current rule, which are to be implemented for protection of environment. Forests have been defined in different ways in accordance to the kinds that exist in the world. These definitions are related to human interactions and approach to kinds of forests in different regions. As defined under the Convention on Biological Diversity 1992, a forest area is a land area of more than 0.5 hectares with tree canopy cover of more than 10%, which is not primarily under agriculture or other specific non-forest land use. In the case of young forests or regions where tree growth is climatically suppressed, the trees should be capable of reaching a height of 5 meters in situ and of meeting the canopy cover requirements. The forests are a large area of land dominated by trees. The forests are defined by the Food and Agricultural Organization as all lands bearing vegetative association, demarcated by any trees of any size, exploited or not, capable of producing wood or other food products. According to the data of the Food and Agricultural Organization, or the FAO as it is in brief referred to, forests cover 4 billion hectares, or approximately 30% of the world's land area in the year 2006. They are pivotal to preserve the ecosystems. They provide humans with various essential commodities such as air to breathe, wood, vegetables, etc., which are a must for survival. The forests are a blessings for human beings from the nature, and therefore it becomes our duty to preserve and protect these forests. They constitute a large part of the ecosystem and a part of the Earth's biosphere. Preservation of forests. The United Nations Strategic Plan for Forests 2017 to 2030 provides a global framework for actions at all levels to sustainably manage all types of forests and trees outside forests and halt deforestation and forest degradation. The strategic plan has 6 goals to achieve by 2030 as enumerated thereunder. The sustainable forest management provides the key to recovering forest cover losses and afforestation and reforestation for prevention of further degradation. The livelihoods of forest dwellers to get improved by providing forest-based benefits, the world to have more areas of protected forests and manage them sustainably, to have partnerships and cooperations for providing finances and scientific technologies for sustainable forest management, providing frameworks for governance for sustainable forest management with the help of United Nations Forest Instrument, thereby enhancing the contribution of forests to the 2030 agenda. To enhance cooperation, coordination, coherence and synergies on forest-related issues at all levels, including within the UN system and across collaborative partnerships on forests, member organizations, as well as across sectors and relevant stakeholders. The history of the forest laws in India. We have a very interesting history because the forest and the trees were worshipped in our ancient societies and they were not asked to be overexploited, for they represented our religious sentiments during those times. So in ancient India, Yajna Valkya Smriti, an ancient text, called for punishment for cutting down trees. Then it was the British period which came in and which brought in the formal laws in our country. They, for the purpose of exploitation and taking away the riches or the rich biodiversity reserves in our country, they drafted specific laws in relation to forests. It was in 1850 that the first Inspector General of Forests was appointed, and 1860 first Forest Department was established. In 1865, the Forest Act was drafted and made, and in 1878, the Forest Act took away the community rights of forests from the local people, from the community people and from the tribals. It was in 1894 that the first forest policy with focus on agriculture than forests was drafted and brought into force. It was finally the Act of 1927 which repealed all the previous laws and took away more rights of the people living in these areas. It was in 1952 that the first forest policy of independent India, taking rights from the princely states and zamindars, was brought into force. This was after India gained independence, and India drafted its own policy to deal with the forest areas. Then in 1976, there was the National Commission on Agriculture for Production of Industrial Wood. In 1976, there was a 42nd Amendment which was made, where forest laws went from state list to the concurrent list. In 1980, the Forest Conservation Act was brought into force and was amended in 1988. It was in the year 2006 that the Forest Dwellers Act came out, which gave more rights to the forest dwellers than what was previously done during the previous years. And in 2022, forest rules have been brought and which have come into force. So the current position of forests in India is the recorded forest area in India is about 76.5 million hectares, which is only 23% of the total land mass. During the last 2 decades, India has witnessed annual depletion of forest cover at the rate of 235 kilometers. According to the government data, 14,000 square kilometers of forests were cleared to accommodate 23,716 industrial projects across India for the last 30 years. These figures are certainly not good and are not in the interests of our nation. Thus, it becomes pivotal to improve the situation and to ensure the protection of forests. Protection of forests comes within the ambit of the directive principles of the state policy in the Constitution of India, where it seeks the duty of the citizen and the duty of the state to work towards the protection of natural resources and specifically the forests. Section 48A of the Constitution deals with that the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of our country. The Constitution also entrusts the duty of protection of forests on citizens as a fundamental duty. And under Article 51A, subclause G of the Constitution, in 1950 embodied that it is the fundamental duty of every citizen to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures. This law is placed in the concurrent list. Until before 1976, forests and wildlife were the state subjects in the Indian Constitution. The forest departments are regulated forests in accordance with the Forest Act of 1927. Recognizing the significance of forests and wildlife, the 42nd Amendment to the Constitution deleted both from the state list and placed them in the concurrent list, bringing them under the purview of both the central and the state governments. Now, both the center and the states may legislate on issues pertaining to forests and protection of wildlife. The reasons for drafting. Now, I will again take up the history of the forest law since they started during British India. In 1856, that Lord Dalhousie emphasized the need for a definite forest policy. Railways was first introduced in India in the year 1853 from Bombay to Thane. Increasing difficulty of obtaining adequate supplies of timber needed for the great extension of railway lines then being undertaken was one of the main reasons for this cognizance. Another reason was the Indian teak, which was suitable for shipbuilding, saved England during the war with Napoleon. In 1865, the Indian Forest Act of 1865 extended the British colonial claims over forests in India. In the year 1878, the Forest Act was introduced and it truncated the centuries-old traditional use by the communities of their forests and secured the colonial government's control over the forestry. The provision of this act established a virtual state monopoly over the forests in a legal sense on one hand and attempted to establish on the other the customary use of forests by the villagers was not a right but a privilege that could be withdrawn at will by the government. The Indian Forest Act of 1865, it was a significant piece of legislation during the British colonial period. The historical context and implications are that Lord Dalhousie, the then Governor General of India, recognized the need for a definite forest policy. It introduced railways in India, highlighted the difficulty of obtaining adequate timber supplies for railway expansion, the Indian teak, which was crucial. The Indian Forest Act extended British colonial claims over forests in India. It empowered the British to declare any land covered with trees as a government forest and establish rules for its management. The Act aimed to address the timber scarcity issue by asserting control over the forests. The impact on traditional use. The Forest Act truncated centuries-old traditional forests used by the local communities. It established a virtual state monopoly over the forests, emphasizing that villagers' customary use was a privilege rather than a right over these people. The forest laws in India. The directive principles of the state policy and the fundamental duties enshrine these specific provisions. As I have previously stated, this was established for the first time in India by the British in 1865, and it was amended, and Indian Forest Act 1878 was passed. This classified the forests into reserve forests, protected forests, and village forests. Under this act, the government was empowered to exercise control over the forests. The Indian Forest Act of 1878, it was exploitation under this act was extensive by the British as they gained control over the various lands, forest cover of the country with colonial interests at heart. They achieved this by exploiting local resources as the local people as well as the forest dwellers who conducted all their daily activities and practices such as agriculture, shifting agriculture, grazing cattle, etc. These, for the purpose of exploitation, were considered harmful to give more control to forest officers and indirectly to the British rule in India. The commercial interest in timber and other produce led to the framing of this law to deprive the people and gain economic benefits for the same. The Indian Forest Act 1878 and the case examples were in the Kumaon and the Garhwal hills of the present-day Uttar Pradesh and Uttarakhand, the softwood reserves of Deodar and Cheer pine trees had the economic potential to fulfill the demands of the expanding railway network and the military endeavors. Exploitation of locals by depriving them of ancestral rights for revenue generation led to the encroachment on indigenous lands of teak forests in the Dang district and the Deodar forests in the upper Yamuna valley. To maintain control over the forests and suppress tribal rights, the British established indigenous ruling class as an intermediary between themselves and the tribal communities. The freedom movement gained momentum because of these rights being taken away, and the revolt took place in Chota Nagpur in 1893, Bastar in 1910, Godam Rampa in 1879 to 1880 and 1922 to 23, Midnapur in 1920 and Adilabad in 1940. The Indian Forest Act was then passed in 1927. It was passed with the objective of improving forest laws in India. This act repealed all the previous laws pertaining to forests. It emphasized upon consolidating the forest laws pertaining to forests and ensure regulation and transit of the forest produce. It consolidated the law relating to forests, the transit, and the duty leviable on the timber and other forest produce. It is expedient to consolidate the law relating to forests because of the following reasons. The Indian Forest Act 1927 and its applicability. It is a consolidated law which related to transit of forest produce and the duty to be levied on the timber and other forest produce. This act came to be known as the Indian Forest Act of 1927. It extended to the whole of British India or the rule of British India, except the territories which immediately before 1st November 1956 were comprised in the Part B states. It applied to the territories immediately before 1st November 1956 and comprised of the states of Bihar, Bombay, Coorg, Delhi, Madhya Pradesh, Orissa, Punjab, Uttar Pradesh and West Bengal. But the government of any state may by notification in the official gazette bring this act into force in the whole or any specified part of that state to which the act extends where it is not in force. The reserved forests. The provisions related to the procedure which was established for exploiting the local people and their rights by providing compensation and declaring the lands as reserve forests, thereby relinquishing their rights in their own lands. This was basically a deliberate attempt of the British government to firstly ask for the claims which were made by the local people involving their rights on their land, to settle for a monetary compensation and to give up their rights over their personal lands which they had made use of in the past centuries for their daily lives. This was the power to reserve forests, notification by the state government, bar of accrual of forest rights, proclamation by forest settlement officer. Officers were appointed to settle claims of the local people or of the indigenous people who claimed rights over their own lands. inquiry by the forest settlement officer, powers of the officer, extinction of rights, treatment of claims relating to practice of shifting cultivation, treatment of claims relating to practice of shifting cultivation, power to acquire land over which right is claimed, orders on claims to rights of pasture or the forest produce, records made by forest settlement officers, records where they admitted the claims, exercise of the rights admitted, commutation of rights, appeals from the orders passed under section 12, appeals under section 17, pleaders to be appointed, notifications declaring forests as reserved areas, publication of translation of such notification in neighborhood of the forests, the power to revise arrangements made under section 15. No rights after that would be acquired over the forest lands which were declared to be reserved forests, except those rights which are not to be alienated without sanction. Then there was the power to stop ways and water courses in the reserved forests. Acts prohibited in such forests were not to allow entry and exit of those people who own those lands after once compensation claims have been made. Then the power to declare forests are no longer reserved. Then came the category of the village forests and the protected forests. Provisions related to village and protected forests were covered under sections 28 to 34. Under section 28, the provision of declaration of lands as formation of village forests. This act brought the law to allow certain lands to be the village forest for community, but the rights remained with the government to change their status any time. The law also went to establish the procedure for declaration of wastelands or no ownership lands to be the property of the government. Then came the protected forests. The protected forests under Chapter 4 provided the power to issue notification reserving trees, publication of translation of such notifications in the neighborhoods, power to make rules with respect to these protected forests, penalties for acts in contravention of the notification issued under section 30 or rules made under section 32, nothing in this chapter to prohibit the acts done in certain cases. Then comes protection of forests, control over forests and lands not being the property of the government. There was protection of forests for specific and special purposes. Where these forests provided a specific reason for their protection, they were asked to be protected. The power to assume the management of these forests, management of the forest, the entry, the exit, the right to make use of the produce, not to fell down trees or to fell down only those trees which are no longer in use, are the decisions which will be assumed to be made with respect to the management of forests. Exploitation of forests in certain cases, and there were certain then requests made by certain private people for the protection of the forests at their requests. Then comes the duty and control on timber and other forest produce, that there were taxes to be paid and duty to be levied on any forest produce which is likely to be taken or purchased from the forest lands which are so declared as such. The power to impose duty on timber and forest and the limit not to apply to purchase money or royalty only. It could be more, it could be less depending on the case-to-case basis. The collection of drift and stranded timber. Under section 45, certain kinds of timber were deemed to be the property of the government until title thereto was proved by the person or the collector and may be collected accordingly according to the procedure. The notice to claimants of drift timber. Drift timber means the timber which has been left aside and where rights could not be claimed because of the flow of timber or they are left unattended and they are taken into custody by the government where the person has to prove special ownership over that timber to claim his rights. Procedure on claims preferred on such timber, disposal of unclaimed timber, and government and its officers not liable for damage to such timber, payments to be made by the claimant before timber is delivered to him, payment in the form of taxes, payment in the form of duty which might be levied, and then the power to make rules and prescribe penalties. What are the penalties and the procedure which has to be adopted? Seizure of property is liable to be confiscated. Power to release property seized under section 52. The procedure which is followed thereafter. The forest produce when liable to confiscation, that is when they are left unattended, drift timber when they are flowing down the river and the claims are not there, are likely to be confiscated. Disposal on conclusion of trial for forest offence of produce in respect to which it was committed. Procedure when the offender is not known and cannot be found. Procedure when it is a perishable property seized under section 52. Appeal lies under section 55, section 56 and section 57 in case the decisions have been taken. Then the property went to vest in the government is after no claims have been made or claims have been denied of the persons who claim to be the owner. Saving of power to release property seized, punishment for wrongful seizure, penalties for countering or defacing marks on trees and timber or altering boundary marks, power to arrest without warrant, power to release on a bond a person who may be arrested, the power to prevent commission of an offence, and power to try offences summarily, which means in a quick manner or in a short summary manner where they are not compoundable or they are offences which are not of grave in nature. Power to compound offences and presumption that forest produce then belongs to the government. They were all British policies by which it went on to gain more control of the government over the forest and the produce which might be coming along. Then comes the rights of the cattle trespass, the forest officers and the subsidiary rules. The Cattle Trespass Act 1871 was to apply. The power to alter fines fixed under the Act. The forest officers, the state government may invest forest officers with certain powers, and in 1927 they were again asked to pay the claims made by the government over their lands. The forest officers were deemed to be public servants and indemnity for acts which were done in good faith. Forest officers were not to conduct trade, and the subsidiary rules went for making additional power to make rules, penalty for breach of rules, and rules when they are to come into force. So it went on to display an absolute power in the then government to dispose of, to take into custody any forest produce, timber or anything which is of a commercial value when it relates to a produce which is coming out of those forests, and then laying claims over the lands which are covered in forest areas. The persons who are bound to assist forest officers and police officers, they were bound to be helping hands and they are not to be punished in any kind of procedure. The management of the forest, it will be the joint property of the government and other persons. Then there is failure to perform the service for which a share in produce of the government forest is enjoyed. There is recovery of the money which might be due to the government. There is lien on the forest produce for such money. The land required under these acts are deemed to be needed for a public purpose under the Land Acquisition Act 1894, and the recovery of penalties due are made under bonds. Saving of rights of the central government. The forest policy. After the forest law has been passed, which still till date follows certain laws which were made during the British at that time, although they were arbitrary laws and policies, still they defined the areas as to what are forests and what are the kinds of forests which existed in India, to which the rules and policies amendments were made and new policies came out from time to time. So the first policy which was enacted was in the year 1952, immediately after the India gained independence. In 1988, the policy was revised by the Parliament to revise the previous enacted policy of 1952. The objective was to ensure that the management of forests is undertaken in a sustainable manner and the local tribal communities are empowered and involved in their protection and development. A direct outcomes of the policy was establishment of a joint forest management system. This policy aimed at maintaining environmental sustainability and stability, recovering ecological balance, protecting natural heritage with flora and fauna, preventing soil erosion, floods, droughts, as well as increasing forest cover through afforestation programs. The forest policy also sought to promote efficient utilization of forest resources for meeting basic human needs such as fuel, wood, fodder, and small timber, while ensuring that these activities do not lead to deforestation or degradation. It emphasized the need for conservation of biological diversity by protecting endangered species and preserving genetic diversity. It further suggested measures for improving productivity through scientific management practices such as silviculture and agroforestry. The National Forest Policy 1952, the Government of India in the Department of Revenue and Agriculture in broad outlines gave out a general policy to be followed with the management of the state forests in the country. The interval that had since lapsed, development of far-reaching importance had taken place in the economic and political fields. India had gained independence, as I stated previously. The part played by forests in maintaining the physical conditions of the country had come to be better understood. The country had passed through the two world wars, disclosed unsuspected dependence of defense in the forests, reconstruction schemes such as the river valley projects, development of industries and communications, leaned heavily on the produce of forests. While the fundamental concepts underlying the existing forest policy still hold good, the Government of India considered that the need has now arisen for a reorientation of the forest policy in the light of changes which have taken place since it was enunciated. The needs of the forest policy of 1952, the need for evolving a system which was balanced and complementary land use, under which type of land is allocated to that form of use under which it would produce most and deteriorate least, need for checking for denudation in mountainous regions, in which depends on the perennial water supply of the river systems whose basins constitute the fertile core of the country, erosion which progress space along the treeless banks of the great rivers leading to ravine formations, stretches of undulating wastelands depriving the adjoining fields of their fertility. The invasion of the sea sands on coastal tracts and shifting of sand dunes, more particularly in the Rajputana desert. The need for establishing tree lands wherever possible for the amelioration of the people and climatic conditions promoting the general well-being of the people. The need for ensuring progressively increasing supplies of grazing, small wood for agricultural implements, particularly of firewood to release the cattle during dung for manure to step up food production, need for sustained supply of timber and other produce required for defense, communications and the industry, and the need for realization of the maximum annual revenue in perpetuity consistent with the fulfillment of the needs enumerated above. The necessity and classification of forests. It is the functional classification of these forests. The forests of India, whether state or privately owned, may be conveniently classified into the protection forests, which are preserved or created for physical and climatic considerations, national forests, which are managed to meet the needs of the defense, communications and other purpose of public importance, the village forests, which have been maintained to provide firewood, to release cow dung for manure, to yield small timber for agricultural implements and produce for local requirements to provide grazing for the cattle. The tree lands, which outside the scope of the forest management are essential for the amelioration of the physical conditions of the country. This collaboration is illustrative and it is not mutually exclusive. The forest performs more than one function where it is managed to achieve the highest efficiency in respect of the chief functions, and the classification has no bearing on the classification of the forest distinguished under the Indian Forest Act, which was based on degree of control exercisable by them. The necessity of the classification. The classification is necessary to focus attention on the kind and object of management necessary in each case. Every sizable forest, where whatever its composition, location, category, because of protective and productive purpose and the utility which may be local, regional, national significance, it must be realized that the country as a whole must stake claim in the conservation of all forests, irrespective of their functions and ownerships, and all of them should be administered from the point of view of the national well-being. Balancing the rights and the protective measures. There are claims of the neighboring communities, that is, village communities in the neighborhood would make greater use of its products for the satisfaction of their domestic and agricultural needs. No event is to be permitted at the cost of national interests. Accident of a village being situated close to the forest does not prejudice the right of the country to receive the whole benefit of a national asset. Scientific consideration for forests inevitably involves regulation of rights and restrictions on the privilege of the user. The relinquishment of forest lands for agricultural purposes, the indiscriminate extension of agriculture with the destruction of forests not only deprives the local population of fuel and timber, but also strips the land of its natural defenses against dust storms, hot winds and erosion. The old policy which envisaged the relinquishment subject to certain safeguards, honored only in their breach every valuable forest and permanent cultivation, has resulted in the general deterioration of physical conditions to the detriment of national interests. Then comes the land use. The correct solution of land problem is to involve a balanced and a complementary land use, where each type of land is allotted to a form of use under which what produces most and deteriorates least. A detailed survey of lands to their proper utilization is highly desirable. The protection forest denotes forests found or required on hill slopes, riverbanks, seashores or other erodible localities. In such sites, the forest covers is dictated purely protective physical considerations. The role is to save the soil from being washed away, maintain the catchment areas, prevention of floods and maintenance of the stream of flow, and it cannot be overemphasized. So these measures they should provide an immediate and speedy program for the reconditioning of these regions wherever they are required for protective and preserving the forests. The reconditioning of the hills and the dales. The progressive denudation of hillsides with serious repercussions on the fertility of the land, and the growing erosion along the bases of the river Yamuna, the Chambal, the Mahi, the Narmada, the Kosi and Damodar are notorious examples which constitute the major considerations demanding immediate action. The immobilization of the desert of Rajputana, attention has to be drawn to our desert region, where fixation of shifting sand dunes, the strong winds that develop in the region during the summer, which arrive from the sea, and the run of Kutch, whipping the desert into dust storms, the fury which is felt out in the northwestern India, desert area spreads through the ages because the westering of Indus and mothering of the Satluj, meeting an obstruction of sorts not only on its eastern confines in the Aravalis. The immobilization of the desert and protection of the remaining fertile belts constitutes one of the planks of the national forest policy. The kinds of forests and scope of increase of tree lands. National forests constitute the basis of India's strength and wealth, and they comprise valuable timber which bears regions the produce which is indispensable for defense, communication and other vital industries. The village forests, they provide fuel forests. They are popularly termed as fuel forests, and they serve needs of the surrounding villages with respect to small timber, housing and agricultural implements and other small uses, including cattle grazing. The supply of these requirements are at non-competitive rates, and they are used by the villagers themselves, and it is not for the trading purposes. These meet the needs of the local population. Removal of the produce in excess to its annual growth should not be permitted, where they should be guarded against and also guarded against hazardous activities. The tree lands. The tree lands are not a part of the regular forests in a country like India, where their increase, management and development are vital to the needs of the people. They cannot well be left out of any considered policy. The land transformation program of the government envisages the planting of 30 crore trees in 10 years, but this is far from the 2,000 crore of trees which will be necessary to restore the hydrological, nutritional balance of the country. The scope for increasing tree lands. It is a vast scope for increase in tree lands for the purpose which have been defined here, and to lend a helping hand by converting these lands at their disposal into tree lands. The new forest policy envisaged a concerted and a supreme effort on the part of various governments and other agencies to promote planned afforestation, a systematic program for extending existing tree lands, and the new one should be framed by the government. This was to awaken the interest of the authorities for the protectionist policies for these tree lands, to draw plans for the same, to establish nurseries and seed stores to supply saplings, plants and seeds, supervising the planting and render technical assistance wherever it is necessary, to arouse the consciousness of the people by celebrating one Mahotsav. Utilization of forest areas for different purposes. The proportion of forest areas as they are, proportion is to be kept in mind under forests are different in different regions. They shall maintain 1/3 of its land under forests. An insurance against denudation, a much larger percentage of land above 60% should be kept for forests for protective functions in the Himalayas, the Deccan region and other mountainous tracts. Then the wildlife. The National Forest Policy emphasizes the need of protection of the animal kingdom and the rare species like the lion, the horned rhinoceros and which is fast disappearing. The other species of animals which without the creation of forests would not be in their natural habitats. The purpose of grazing. The state forest calls for a definite clear policy. Formulation of a grazing policy was based on the following principle. Continuous grazing on the same land by large herds would be destructive. Chief forest grazing has a demoralizing effect. The grazing should not be looked upon as a primary source of revenue. It must be allowed in regeneration areas and young plantations, and grazing incidents should be kept at the minimum level in protected forests. Sheep and goats. Experience gained in India elsewhere points to the imposition of restrictions on sheep grazing in the forests and exclusion of goats therefrom. The damage of young plants caused by browsing of these animals is often irreparable, and their admission into the forest is incompatible. Then shifting cultivation. Shifting cultivation in certain areas must be guarded. To wean the aboriginals who eke out of a precarious shifting from axe cultivation, moving from area to area, away from the age-old and wasteful practices, this needs to be explored. Sustained yields. Forest resources should be conserved till perpetuity. Forest policy requires scrupulous regard for sustained yield in the management of all classes of forests. The fluctuations in the annual turnout of forests upsets the state budgets, industries and other national enterprises. All working plans therefore should aim at confining them within the narrow limits. And the forest administration, which depends directly on the adequacy of the forest laws, the training and the caliber of these forest services, the forest legislation. Absence of a legislation or a half-hearted legislation is detrimental for certain areas which relate to the forests. State without a proper Forest Act should enact a legislation at an early date in the lines of the Indian Forest Act and validate the act for their territories. Forest education should be provided to not only the people but also the forest rangers and forest officers at research institutes and colleges. The training of the field staff, the services which are there, the idea that Since forests grow by themselves, they need no technical management is based on ignorance. Inadequacy of technical personnel and weakening of the standards called upon to manage forests would not be followed, but would only be followed by a loss of revenue, which by a general degradation of the forest, resulting in reduced forest produce. Forest research should be carried out in various areas, and then there should be the liaison with the industry. It is a considerable scope for improvement in securing the utilization of results of research on forest products by commercial and industrial interests, for ensuring closer interactions between the Forest Research Institute and the interests utilizing timber and forest produce, liaison and publicity arrangement of the institutes needs to be strengthened. The miscellaneous provisions talk about the popular goodwill of cooperation and forest workers. The forest budgets, where a steady flow of funds is indispensable for a sustained forest operation, such as replacement of what is removed annually, improving remaining crops, development of communications, and likewise and protective measures. They are based on phase schemes which cannot be set aside lightly. The forest budget cuts made from year to year meet the exigencies of the state finances can only be made at the expense of continuity in forest management. Creation of a sinking fund by investing a portion in government securities. Immediate profit motive should be rigidly ruled out, for this urge may endanger the supply of large and special timber for defense and industry and other uses. Adoption of rotation to produce large-sized timber is of great importance to the general economy of the country, and that rotation which yields the maximum rate of interest in forest investments. Policy and enunciation of the general principles. Discretion of the state government to regulate the details of the forest administration in their respective territories is unfettered. The general principles of the forest policy should paramount be of national interest, be observed by them in framing policies and legislations for forest resources. Objects and reasons. It was published in the Gazette of India 1926, which was considered repeal in relation to Assam. The scheme of the law, the scope of the Act, the construction of the Act, the jurisdiction of the civil courts, procedure for trial of forest offences. The Forest Conservation Act of 1980. Now, this was the main act. A policy only was framed in 1952. Till 1980, they continued to follow the Forest Act of 1927 with its various provisions which apply to all forest lands in India. The Forest Conservation Act 1980 was passed to ensure the conservation of forests. It required it was to be made it compulsory to obtain the prior approval of the central government for diversion of forest lands for non-forest purposes. It was mandatory to have a clearance from the central government for re-reservation of reserved forests and for use of forest land for non-forest purposes. This was under Section 22 of the Forest Conservation Act of 1980, that there were restrictions on de-reservation of forests or use of forest land for non-forest purposes. So this made the prior approval from the central government mandatory. If you reserve any forest also, it required the approval of the central government. This required the constitution of an advisory committee, which would constitute such a number of people who may be fit to advise the government with regard to grant of approval with regard to any matter connected with conservation of forests. Then the central government had the power to make rules to be notified in the official gazette for carrying out the provisions of this act. Every rule made under the act was to be laid before each house of the parliament, which within 60 days would be comprised of 1 or 2 or 3 sessions before its expiry, and they should have been agreed by both the houses for the rules to take effect. The amendment was made in 1988. An act to provide for conservation of forests was amended. This act was called the Forest Act of 1980. It extends to the whole of India except for the state of Jammu and Kashmir. There was de-reservation of forests or use of forest land for forest purposes, and then there were the defining aspects of the law. The reserved forests or any portion shall cease to be reserved. Land or any portion may be used for non-forest purposes. Forest land or portion may be assigned by way of a lease to any private person or authority, a corporation, agency or organization which are not owned, managed or controlled by the government. Forest land or any portion may be cleared of trees which have grown naturally in the land or portion. And then the non-forest purpose means the breaking up, clearing of any forest land or portion thereof for the cultivation of any of the following activities, which is of tea, coffee, spices, rubber palms, oil bearing plants, horticulture crops or medicinal plants, or any other purpose other than reforestation, but does not include any work which is related to conservation, development, management of forests and wildlife, and establishment of certain other aspects like fire lines, wireless communications, fencing, bridges, culverts, dams, etc. There should be a constitution of an advisory committee, and then the penalty for contravention of the provisions of the Act. That it says whoever contravenes or abets the contravention of any provisions, it will be punished with a simple imprisonment for 15 days. Where offence has been committed by authorities or the government departments, then the person who is directly in charge of that activity will be made responsible. So due diligence should be used to prevent the commission of such offences, and it is proved that offence once committed with consent or connivance will not be forgiven. The power to make rules, the central government shall have the power to make rules under the said amendment, and it would be placed before the houses of the parliament. If they are to be, the Forest Ordinance 1980 was replaced by the amendment made in 1988. 1992 amendment in the Forest Act, some amendments were made which made provisions for allowing some non-forest activities in these forests which did not include cutting of trees or limiting cutting with the prior approval of the central government. These activities were setting up of transmission lines, seismic surveys, exploration, drilling and hydroelectric projects which were to be undertaken in these lands. It involved large-scale destruction of forests for which prior approval of the central government was necessary. Then the forest conservation rules after that in 2022. These are a set of rules which are established by the Ministry of Environment and Forests and the Climate Change to ensure that forest conservation is properly managed. It is formulation of an advisory committee and a project screening committee in each state, union territory to advise or recommend matters related to forest conservation. The committees have been given specific timelines for reviewing non-mining projects between 5 to 40 hectares and mining projects within 75 days. For larger projects, the committee gets more time to review, and the rules allow private developers to clear forests without seeking the permission of the forest dwellers, to permit the clearance of a forest without informing their authentic residents. Tribal rights are not violated. State government have been given responsibility of protecting the scheduled tribes' traditional forest lands. Applicants for diverting forest land in hilly or mountainous regions with green cover covering more than 2/3 of its geographical area with forest cover covering more than 1/3 of it can take up compensatory afforestation in other states. Now, the cases which are related to the forest laws in India are the case of T.N. Godavarman Tirumulpur versus Union of India, where the Supreme Court has directed to close down all wood-based industries and embargo was imposed on the exploitation of forest and forest produce. The case of Tarun Bhagat Sangh versus Union of India, where the court where mining activities in the reserves of Sariska area was prohibited by the court, where it stated it is detrimental to the forest areas and the land within the Sariska reserve. The state of Bihar versus Bansi Ram Modi, who is Honorable Supreme Court has held that the use of forest land for non-forest purposes is impermissible, where the court held that contribution to the development of forest laws to a great extent, judicial precedents ensured proper compliance of legislation and interpretation of legislation in the best interests of environment and society by the judiciary. The case of Environmental Law WWF versus Union of India, where the court through its judgment took power of the central government and the state governments with respect to forests, sanctuaries, national parks concerning denotification, dereservation. The Godavarman case had made major changes in forest management. The important conditions it laid down in the case was no national park, sanctuary or forest can be de-reserved without the permission from the Supreme Court. The non-forest activities are permitted only if they are approved under the Forest Conservation Act of 1980. New authorities such as compensatory afforestation management, planning agency and central empowered committee are to be set up. So these decisions were for the protection of forests where degradation and various illegal activities in contravention to the forest laws was taking place. Then came the case of Orissa Mining Corporation versus Ministry of Environment and Forests in the year 2013, where mining was being done indiscriminately and the people who were there felt the adverse impacts of the mining activities, went to the court and found justice through the ways of the court. In the case of Sansar Chand versus State of Rajasthan, the depletion of forest cover, thereby affecting the wildlife, was questioned and answered that it should be done for the protection of environment. Banvasi Seva Ashram was one of the first cases in India where they talked about the protection of the Adivasi rights in these forest areas who were dependent on of their livelihoods on these areas for not only their produce but also their natural habitats. In the case of Union of India versus Kamath Holidays, that they only produced the provisions of Indian Forest Conservation Act of 1980 and stated that where forest lands are diverted for non-forest purposes, compensatory money should be taken up front. The non-forest activity finishes, then it is that time that fund should be used for restoration of those forest areas which have been covered. So overall, our law has made efforts for the protection of forests. It depends now on the government and the people's action and a collective action for protecting the forests, not allowing deforestation to take place, and protecting and producing more planting more trees for the purpose of having more forest lands for the survival of mankind and other associated activities. That is the law. It is in relation to the forest in India, and which is improving but is continuously bringing out policies by the government. Thank you.
Hello everybody, welcome back, and here I am to give a preview, very short obviously, in the area of what we mean by operation research and optimizations. So we know operation research and optimization is used generally where you have some resources and you want to utilize them in the best possible way considering what your main objective is. Now if we stop here and go back in the past, so the obvious question comes, from where did this technique of operation research and optimization, which is an area of mathematical techniques, come into the existence? So generally, even though the work has started from areas of mathematics, economics, but generally it is considered that operation research and optimizations were very heavily used and it became popular during World War II in trying to schedule different resources, manpower, armaments, considering there were resource constraints, time constraints and space constraints and so on and so forth. Now for the general public, it should be aware that we consider from the academic point of view, there are different people, very famous people who have worked, but George Danzig is considered the father who really proposed the technique of linear programming as a very nice tool where you can use operation research techniques in order to optimize the resources which are there depending on different constraints which you have. And after that, things have really moved very fast. They have been developing throughout the world. They have been usage. They are different type of societies, so on and so forth. And in course of time, we see and we still find exciting areas of application. But theoretically, there has been a growth in techniques like robust optimization, stochastic optimization, dynamic programming, parametric programming, nonlinear programming, so on and so forth, and they are used depending on the concept and the areas of application which we see for either finance, for marketing, for scheduling, for engineering field, and so on and so forth. Now, application of OR and optimization, if somebody asks, is a very difficult question to answer, because if I start now, it will almost take about 1 hour to give you all the areas of application of optimization and operation research are. But to keep it very brief, considering that you are all ready and eager to take that as a subject, I will just highlight the areas of applications, some of which are in scheduling, in assignment problem, in facility location, like you want to build up a factory, you want to build up some storehouse, so on and so forth. It is used in network flows, like you want to transport some goods, transport manpower from one area to another area. So, how we will try to basically do it in the best possible way. What is best would obviously depend on how you are trying to use optimization as a tool in different areas. It can be used, operation research and optimization can be used in health services, in financial portfolio management, asset liability management, game theory, and so on and so forth. Now, in the recent past, even though it is very well known, but still I would like to highlight the point that the computing powers and the techniques of operation research and obviously in statistics has exponentially grown. And with very sophisticated programming being available, like we know that there is MATLAB, there is R, there is SAS, which are different type of optimization tools. We see nowadays that operation research and optimization is also used in health sciences, in gene replication theory, in area of, say for example, prediction of weather, in the area of, say for example, prediction of earthquake, how you find out the best possible way to take actions such that it meets your overall demand. Say for example, in prediction of earthquakes, you would like to basically build up your houses, build up the dams, build up the overall locations of people staying in different localities in such a way that the minimization of the losses are sustained. Furthermore, after the advent of computing and advent of different techniques, we see many meta heuristic and heuristic techniques are very heavily used in parlance of operation research and optimization by joining them together such that you get the best benefit. So, if the question arises what are the meta heuristic techniques, I would again be very brief, because again there is a huge amount of literature, huge amount of application areas, huge amount of research which are being done in the area of genetic algorithm, taboo search, ant colony optimization, simulated annealing, then in the area of particle swarm optimization, in the area of artificial immune system, and so on and so forth. In the coming years, it is thought, and definitely with some positive viewpoint, that the area of multi-criteria decision making and multi-objective programming, where you use different type of tools and use the different advancement of optimization which has been made in such a way that you can basically optimize two different objective functions which are there in front of you, such that either considering the area of finance, you can either maximize your return for the portfolio or minimize the risk also, or say for example you want to basically have a layout such that minimization of cost is one factor and the maximization of, say for example, benefit which accrues to different type of users in this overall layout can be attained at the same time. So, obviously it means that what we are seeing is a huge application of optimization along with different type of computing and heuristic techniques, such that in years to come this area of optimization would become one of the best tools where you accrue and get the benefits in the best possible way. And I am sure that the students or the participants who will take this course will find it an exciting add-on to their CVs and to their curriculum vitae, such that they can understand the techniques, how they can be used in the best possible practical sense. Thank you.
Swayam Prabha. Digital India. Educated India.
Hello friends, you all are welcome in session number 8 to the course Law Relating to Women and Children. In the present session, I have come with the topic Care and Protection of Juveniles in India. This is the topic relating to the care and protection of juveniles, and therefore at very outset of our discussion, we must know about two terms. Number one, the juveniles, and number two, the juvenile justice. The term juvenile refers to a person who has not achieved the maturity or who cannot be said to be an adult. So, any person who is below the age of majority or who is minor, he is known as juvenile. The other names for juvenile may be the youngster, the young people, the child, or the minor. Juvenile justice refers to the system of law or any process or any procedure which is intended or which is aimed at taking care of the protection of juveniles or the treatment of the juvenile offenders. When any juvenile violates the law, for violations of the law by the juveniles, the juvenile justice system makes the treatment. So, the treatment of juvenile offenders, and in addition to the treatment of juvenile offenders, the care, protection, rehabilitation, all are aspects of care and protection of such young people who are either in conflict of law or who are neglected persons. This whole aspect is covered by the juvenile justice system. So, the juvenile justice system refers to the care and protection of juveniles. Either the juveniles are the violators of law or they are in conflict with the law, or the juveniles may also be the neglected persons or neglected children. And therefore, the topic or the subject of juveniles or the care and protection of juveniles is as important or significant as the care and protection of early childhood. And therefore, each system of law or each country or each nation should be very cautious about developing the precise system, an effective system, a sound system to make the treatment with the juveniles. In India also, this system has been evolved as per the mandate of Indian Constitution or as per the international obligations of Indian state in various international agreements or conventions relating to children. And therefore, in this lecture, we will discuss all these aspects. What is the meaning of juvenile? What is the juvenile system? what is the objective of juvenile system, and then what are the international initiatives with regard to the care and protection of juveniles, then what is the constitutional mandate for the protection of juveniles in India, then what is the legal framework or what laws are enacted in India to take care of the juveniles or to treat the juvenile offenders or for the care and protection of juveniles, either these are in conflict of law or these are the neglected persons. We can start with the statement of Professor Colin in his book Criminal Law, which was published by Law Book Company in its 4th edition at page number 343. He states that no civilized society regards children as accountable for their actions to the same extent as adults. The wisdom of protecting young children against the full rigor of the law is beyond argument. The difficulty lies in determining when and under what circumstances should it be removed. So, the justification behind having the juvenile justice system, justification behind treating the juveniles with some distinctive measures or with the distinctive law, that justification lies in the statement of Professor Colin Hubbard. He says that no civilized society regards children as accountable for their actions to the same extent as adults. And it is certainly true, it is correct that the children cannot, a child cannot be treated equally with an adult even for the violation of law, even for any action or any offense being done by such a child. And in this statement, the justification be, as I told you, that the justification to have the distinctive procedure, to have the distinctive laws, to have the distinctive system to treat with the juveniles lies. And therefore, the juveniles must have or they are entitled for the distinctive treatment on the part of states, even if they are making any crime or they are violating any law. For the violation, for any incidence of violation of law or for any crime on the part of juveniles or children or youngsters, they cannot be treated equally with the adults, and therefore the law needs some different system, and this system is known as juvenile justice system. Friends, the law relating to juvenile protection is an extremely contentious area and sensitive issue also. Therefore, it should be treated with maximum caution and care. Earlier, the law relating to the commission of crimes by the juveniles was under a predicament, but nowadays, with the evolution and development of the law at international and national both the levels, it has become more detailed, clear and precise. Juvenile justice system is a more delicate and sensitive area of law because it deals with the rights, care and protection of children, and several legislations and legal instruments have been adopted at national or international both the levels. Juvenile justice system is a jurisdiction which deals with various issues including the rights, freedoms, care, protection of adolescents and the social, interactive, collaborative and behavioral aspect of the life of youngsters. So, this is also one important objective of juvenile justice system, to make the social reintegration of those children who for any reason are violators of law or who for any reason have committed the crime, have committed the offense, and social integration of or social reform of such children is very necessary for the society itself and for the nation also, because children are the future assets and they cannot be, the care and protection of such children cannot be compromised, they cannot be left for their own fate. certainly the state should intervene for the social integration of, because many times we see that it may not be possible for the society or the family alone to make the social integration of or social reintegration of such children who for any reason have involved in any crimes, offences, or who are the violators of law. So social integration is also one aspect of juvenile justice system. The term juvenile refers to any person who has not reached to the age of majority. It means that a person or a child who is not as old as to be considered as a mature or an adult may be called as juvenile. This is because the law fixes the criteria for determining a juvenile varies from jurisdiction to jurisdiction. The general consideration for determining the age of the juvenile or majority is 18 years. But in countries like Japan and Taiwan, the consideration is 20 years. So it differs from jurisdiction to jurisdiction what age of majority should be fixed by law. It is very important to say that when the juvenile is a person who has not achieved the age of majority or who cannot be considered, who cannot be said to be a mature person, an adult person, then again the justification lies in this meaning of juvenile that they should be given some relaxations, they should be given some exemptions for any punishment or for any treatment when they violate the law. In the criminal law area, we all know that even in Indian Penal Code and in the criminal law of other jurisdictions like US, like UK, there are the exemptions for the children or for the persons who are not major or who have not achieved the majority. For any crime, the punishments are being prescribed at different footing for both for an adult and for a child. And therefore, again the justification lies behind the separate system of justice for the juveniles, and therefore the concept of juvenile justice was evolved. When the child is given the exemption, when the child is given the relaxations in the law, then certainly it is because of the reason that in the area of criminal law we know that the mens rea or the intention, the intent of a person is very determinative factor whether the person has committed the crime or not. Whether any person can be punished under the criminal law or not, whether any person can be said to have committed the offence or the crime or not, it depends on the very precise factor or the element of crime, that is the mens rea. If all the actions have been done by a person which constitute that crime, but his intent is not existent, or the intent or the intention of that person is not found, then that person cannot be punished with the same degree of punishment with which the other person would be punished who have the intent to commit the crime. And therefore the intention is, which is called in the language of criminal law as mens rea, that mens rea or the intention of a person is the determinative factor or very fundamental element of crime, and therefore we cannot say that a child who is not major, who is not adult, who has not the proper understanding what he is going to do, how can he punished at par with the other persons who are mature, who have the understanding when they are going to commit any crime, they are committing the crime with intention. And therefore the juveniles or the children are, for this reason also, they are entitled for having the different system for their treatment. Friends, according to the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, these are also called as Beijing Rules. A juvenile is a child or young person who, under the respective legal system, may be dealt with or an offence in a manner which is different from an adult. So, according to the Beijing rules also, a juvenile is a child or young person who, under the respective legal system in a country, in a legal system, in a jurisdiction, may be dealt with for an offence in a manner which is different from an adult. As discussed earlier, the juvenile justice is within the domain of criminal law, which deals with the offences committed by juveniles, and it is also provided for their behavioral aspect, liberty, rehabilitation and penal implications. These are the different aspects of juvenile justice system. The aspects relating to the behavior of the juvenile, the child, the liberty or the freedoms of the juvenile, the rights of the juveniles, the rehabilitation and the penal implications. These are the different aspects to be dealt with by the juvenile justice system. Prior to the introduction of juvenile justice system, youngsters were tried and punished for the offence committed by them in the like manner as the adults. When this juvenile justice system was not discovered, the juvenile justice system was not evolved, or it was not thought that the juveniles must be treated with some distinction with the adults for the crimes or for the offences or in the field of criminal law. So, prior to the introduction of juvenile justice system, prior to the introduction of distinctive system of law to treat the juveniles were also being treated at par with the adults. But with the evolution of legal system based on juvenile justice, a distinction was drawn between the offences committed by adults and the juveniles. Another term used in the area, that is juvenile delinquency, juvenile justice and the juvenile delinquency. This juvenile delinquency, which refers to the commission of an offence by a juvenile. With the development of law concerning juveniles, the method in which a juvenile is treated is different from that of an adult. So, juvenile delinquency means the commission of an offence by a juvenile. According to James Werfend and Don Jeglum Peters, juvenile delinquency means actions that violate the law committed by a person under the legal age of majority. So, juvenile delinquency refers to the crimes or the offences or the violations of law being committed by a person who is below the age of or who is under the age of majority. The distinctive treatment with juveniles and adults with reference to the commission of an offence is made because of the fixation of minimum age of criminal responsibility in the area of criminal law and the doctrine of Dolly in caps. These are two important aspects. In all the jurisdictions in the area of criminal law, the certain age has been fixed for making any person responsible to commit the crime. The age has been fixed that on such a age, on the achievement of such age, a person would become capable of understanding the nature of the act which he is going to commit. And unless and until a person is not capable of understanding the nature of the act which he is going to commit, how that person can be held responsible at par with those persons who are capable of understanding the nature of the act which they are going to commit or which they are committing. This is the justification, or this is the reasonable classification between two groups. One group belongs to those persons who are not having the understanding or who are not having the capability to understand the nature of the act, and others who properly, sufficiently know the nature of the act which they are committing. And therefore, the age has been fixed, that this is the certain age on which, when the person acquires such age, then the law will presume that he or she understands the nature of crime. So, this is one aspect on which the distinction is made for any crime being made or for any violation of law being made by a juvenile and by an adult person, that there is always the fixation of a certain age for the criminal responsibility. And another doctrine regarding this is doli in capax. The doctrine of doli in capax is a Latin phrase, and it means incapable of causing harm or committing a crime. The doctrine supposes that a child is not capable of forming the required criminal intent to commit an offence. The doctrine supposes that a child is not capable of forming the required criminal intent to commit an offence, and therefore we see that in criminal law, the persons having mental incapability or who are mentally incapable to understand the things, they are exempted from the liability of crime, and likewise the children also. The age of criminal responsibility differs from country to country. For example, it is 12 years in Canada and Netherlands, whereas it is 7 years in UAE and in India also. It is also not necessary to specify a specific age for criminal responsibility, and therefore, in some jurisdictions, it has been left for the prosecution to prove the existence of criminal intent. If the age has not been fixed, then it is the responsibility of the prosecution to prove the intention of that person. It is the responsibility of the prosecution to prove that, or to establish that that person was knowing the consequences of the act which he committed. And therefore, the Beijing rules provide for taking suitable initiatives to make it reasonable, rational and even-handed. Because there is the discretion of the jurisdictions or legal systems, they may have any certain or precise age limit for the criminal intent, for assuming or presuming the criminal intent, or they may not have such, or they may not prescribe the age limit for presuming the criminal intent. They may leave this for the prosecution to determine whether the person was capable of understanding the nature of or the consequences of the act which he committed. This is the reason for which the Beijing rules directs that, or Beijing rules advocated that in all the jurisdictions that should be made on the ground of reasonability, on the ground of rationality, because this is very sensitive issue on the basis of which even a child can be punished at par with the adults if there is any flaw in the law or in the process, in the procedure to determine the age of the criminal intent. And therefore, the Beijing rules were of the opinion, or Beijing rules provided that determination of the age must be reasonable, rational and even-handed. The most critical and difficult element in the area of criminal justice system, as I told you, is to constitute and interpret mens rea, the criminal intent or the criminal intention. to commit an offence. Juvenile and an adult are treated on different footings as to judicial procedures mainly due to this conception. This is also the reason that most of the legal systems follow the doctrine of doli in capax, and the juveniles below the particular age are excluded from the liability to some extent for the commission of an offence. Though the area of juvenile justice system could not become the area of focus, attention and much significance until the late 19th century, but now it has become an area of priority and significance in the field of law. It contains number of national legislations and international legal instruments across the globe. The international law on juvenile justice focuses on different issues of juveniles and offers the measures to protect the interest of the juveniles against the abuse of law. With the increase in concerns relating to child protection and their rights, many countries have adopted measures within their legal framework to safeguard the interest of juveniles. In 2005, in the case of Roper versus Simmons, the American Supreme Court found the accused guilty and punished with death penalty. In this case, a person naming Simmons, aged 17 years, decided to break and enter a lady's home and murder her. He, along with two of his friends, prepared a plan for the commission of this crime, but one of his companions left the plan before a day. Simmons and one of his friends broke into the victim's home, bound her hands and threw her over the bridge. That was the crime committed by the person aged 17 years. The Supreme Court of US found the accused guilty, but in 2015, the Supreme Court of United Nations held that it is unconstitutional to impose the death penalty on the person under the age of 18 years, and accordingly overruled its earlier judgment made in the case of Stanford versus Kentucky. This Roper versus Simmons case was decided on the basis of the judgment in Stanford versus Kentucky. The Supreme Court of United States in 2015 decided that below the 18 years, the death penalty cannot be imposed or the death penalty cannot be given to a person. The person below the age of 18 years cannot be punished with the death penalty. This was the decision of the Supreme Court of US, whereas in earlier case, the person aged 17 years was found guilty by the American Supreme Court. So after 2015, after this decision by the Supreme Court of US, now it is established in America that a person below the age of 18 years cannot be punished with death penalty. If we see the development of international law with regard to the care and protection of juveniles, we will find several international initiatives on the part of international community, on the part of the United Nations, on the part of different commissions or the committees under the supervision of the United Nations. In this regard, we can refer to Article 6(5) of International Covenant on Civil and Political Rights 1966. The first document which we see with regard to the care and protection of juveniles seems to be the International Covenant on Civil and Political Rights. See Article 6, Clause 5 of this covenant. It says the sentence of death shall not be imposed for crimes committed by persons below 18 years of age and shall not be carried out on pregnant women. So death penalty cannot be imposed on the persons below 18 years age and on pregnant women, Article 6, Clause 5 of International Covenant on Civil and Political Rights. You can see that in 1966, when the ICCPR was agreed to by the international community, by different countries of the globe, then they decided that, or all the jurisdictions, they were agreed to on the point that the persons below the 18 years should not be given or should not be imposed or should not be punished with the punishment of death penalty, and the pregnant women should also not be. Here at this point of discussion or in this lecture, we are concerned only to the juveniles or the persons below the age of majority, and therefore this aspect of or this portion of Article 6, Clause 5 of ICCPR is relevant to make the distinction between the juveniles and the adult offenders or adult criminals. Then Article 14, Clause 4, in the case of juvenile person, the procedure shall be such as will take account of their age and desirability of promoting their rehabilitation. It means that the juveniles cannot be only punished by the law. In addition to the punishment, the concerns about their rights, concerns about their rehabilitation, concerns about their development, concerns about their social integration or social reintegration, and concerns about their future life, the concerns about their role in the society in future should also be taken into consideration at the time of prescribing the punishment, at the time of prescribing for the procedures to treat with the juveniles or to treat with the offenders below the age of majority or the youngsters or young persons. This social integration or this care and protection aspect of the juvenile justice system is also very relevant or significant with respect to the theory of social reform in the criminal law, in area of criminology, or in the area of criminal law where the different theories of punishment have been evolved. Within those theories of punishment, there is one theory, that is deterrent theory, where the very stringent punishments are given. Death penalty is the example of that. The application of that deterrent theory of punishment. And in addition to deterrent theory or other theories, one theory is known as social reform theory. And the persons who are contained in the jails, the reformative procedures are adopted for making the reforms of those persons who are for any reason have been found involved in any crime, so that by making the reforms or by reforming those persons, they can be made capable of participating in the society, capable of playing their role as the responsible person in the society. So it is being done with the adults also, and therefore the children or the juveniles who don't have criminal intent, they are certainly entitled for any such rehabilitation process or any such initiatives for their care, protection, rehabilitation and social integration. Then Article 24, it is also important. Article 24 say that every child shall have, without any discrimination as to the race, color, sex, language, religion, national or social origin, property, worth, right to such measures of protection as are required by his status as a minor on the part of his family, society and the state. So being the minor, they have the right. Every child shall be registered immediately after birth and shall have a name. Every child has the right to acquire a nationality. So these are the important aspects of the ICCPR. Then the next instrument which is very relevant for this purpose is the United Nations Standard Minimum Rules for Administration of Juvenile Justice 1985. This is the international initiative, this is the international procedure or the rules which have been adopted to deal with exclusively with the juvenile justice, and therefore these are very relevant for our discussion. The United Nations Standard Minimum Rules for the Administration of Juvenile Justice 1985. These rules were adopted as a means to fortify the juvenile justice system across the globe. According to the Rule 5, the main objectives of these rules are as follows. See the objectives. The juvenile justice system shall emphasize the well-being of the juveniles and shall ensure that any reaction to juvenile offenders shall always be in proportion to the circumstances of both the offenders and the offence. The fundamental principles of this international instrument are stated in Article 1 as fundamental perspective, which are as follows. So, objective is found in Rule 5 and the fundamental principles are found in Article 1. The well-being of the juvenile and his or her family is the fundamental principle of these rules. A juvenile must get suitable conditions to lead a meaningful life in a community that is free of crime and delinquency. Positive measures to be taken to give full access to resources to the juvenile to promote his well-being by dealing with the case in a humanely, fairly and effective manner. Juvenile justice must be an integral part of country's national development. The member states should ensure the implementation of these rules concerning the economic, social and cultural conditions prevailing in their nations. Juvenile justice services shall be systematically developed and coordinated to improve and sustain the competence of personnel involved in the services, including their methods, approaches and attitudes. It has been provided by Rule 7 and Rule 8 that following rights shall be guaranteed to the juveniles at every stage of proceedings. Number 1, basic procedural safeguards such as presumption of innocence. This is the basic or fundamental principle in the area of criminal law, that criminal law always presupposes, criminal law always presumes, the criminal law always assumes the innocence of the accused. The presumption of innocence is the fundamental policy, fundamental law of criminal law. Whole the system of criminal law is based on this fundamental principle, that there is a presumption of the innocence. When presumption of innocence is there, it means in other procedures we find that if any suit is filed in the area of civil law against any person, then that person or the respondent himself or herself is required to establish the allegations made by the plaintiff as negative or to disprove those allegations. But in the area of criminal law, if the prosecution prosecutes any person, then it is not the responsibility of accused to prove his or her innocence. This is the presumption. The law presumes the innocence of that person or the innocence of accused, and the prosecution is to prove the person as guilty. Prosecution is to prove the allegations made by it, and that person is not to contradict those allegations. There is always the presumption of innocence, and therefore the right to presumption of innocence has also been given by these rules to the juveniles. Number 2, the right to be notified of the charges. This is also the basic of the procedural law, or it is also the part of principles of natural justice. that right to notice should be there, or the person must be given the notice. Without giving the notice, nobody can be punished. So, right to notice is also one aspect of procedural law, and the juveniles are also entitled to this basic rule according to the Beijing rules. Then, right to remain silent. Right to remain silent is also the right of the juvenile during the procedure of the court. Then, right to counsel, right to legal representation, right to be represented through lawyer. This right has also been recognized by these rules. Right to the presence of parent or guardian, because the juvenile is not the mature person, and therefore, at the time of any such procedures, there is the right of the juveniles to have the presence of their guardian or to have the presence of their parents. Right to appeal to the higher authority or to the higher court is also given to the juveniles. Right to comfort has also been recognized by these rules. Right to privacy has also been recognized by these rules. Then under Rule 4, the guidance was given for fixing minimum age of criminal responsibility, and according to it, the beginning of that age shall not be fixed at too low an age level, bearing in mind the facts of the emotional, mental and intellectual maturity. So, very low age should not be fixed as the age of criminal responsibility, and these aspects, the emotional, mental and intellectual maturity of the child, should be taken into consideration. Rule 10 provides for the guidelines as to the prosecution of the juveniles. Then Rule 12 provides for that in order to best fulfill their functions, police officers who deal with the juveniles or who are engaged in the prevention of juveniles criminality shall have special knowledge, skill, expertise and training in juvenile matters. In addition to this, in big cities, special units of police and administration should be established for that purpose, and this is also very important initiative on the part of Beijing rules. Rule 13 enunciates that the detention pending trial shall be opted as the last option. The detention of juveniles should be the last option, because if they are mixed up with the other offenders or habitual offenders or the adult offenders, then the criminality may develop in their mind, and therefore the detention should be the last resort. And if the detention is necessary, then it is also the recommendation of Beijing rules that that detention must be separate from the detention homes or the jails where the adult offenders or where the habitual offenders are contained, and therefore the separate detention should be there. Rule 14 provides that the competent adjudicatory authority shall deal with the juvenile in according to the principles of a fair and just trial, and the proceedings shall be conducive to the best interest of the juvenile and shall be conducted in an atmosphere of understanding which shall allow the juvenile to participate therein and to express herself or himself freely. Rule 17, the reaction taken shall always be in proportion not only to the circumstances and the gravity of the offence, but also to the circumstances and the needs of the juveniles as well. So, the doctrine of proportionality has been included within the rules by Rule 17. According to doctrine of proportionality, the punishment must always be in proportion to the nature of crime, in proportion to the amount of crime, in proportion to the nature and circumstances of crime. So, it has been provided or recognized by the Beijing rules that the doctrine of proportionality should be accepted or adopted at the time of awarding the punishment to the juveniles. Each case shall from the outset be handled expeditiously without any unnecessary delay according to Rule 19. Records of juvenile offenders shall be kept strictly confidential. Rule 21. And then professional education in service training, refresher courses and other appropriate modes of instruction shall be given to all personnel to make them competent in dealing with the juvenile cases. Juvenile justice personnel should be from diverse areas and efforts shall be made to ensure the fair representation of women and minorities in juvenile justice agencies. Then the United Nations Guidelines for the Prevention of Juvenile Delinquency 1990. It is also known as Riyadh Guidelines. These also provides for certain measures to be taken into account for the prevention of juvenile delinquency so that the juveniles may not be punished or may not be treated with the criminal law. You can see the fundamental principles of this international instrument. The United Nations Secretariat plays a significant role to coordinate or cooperate the interested institutions and assist them in conducting research, bringing about the scientific collaboration for formulation of policy, the review and monitoring of the implementation of policies based on the Riyadh Guidelines. United Nations Guidelines for Action on Children in the Criminal Justice System is also one international initiative. The International Juvenile Justice Observatory was established in 2002 and it focuses on the rights of children and adolescents at risk of social exclusion. Then the Indian law, that is Juvenile Justice Care and Protection of Children Act 2015, is the union legislation in India to deal with the juveniles. We have discussed the international aspect, international initiatives and some constitutional aspect also, wherein in different cases the Supreme Court talks about the ways or the procedures which should be there in the juvenile justice system and what are the rights of the juveniles or the children which were to be taken into consideration at the time of treating the juveniles. Now see the provisions of the Juvenile Justice Act. By the name of this act, in short it is called as Juvenile Justice Act, but at the time of giving the title to the enactment, the Parliament or the legislature made it clear that this Juvenile Justice Act is aimed at the care, protection of the children. According to the objective clause of Juvenile Justice Care and Protection Act 2015, the act is to provide for proper care, protection and handling of the children in need of care and protection. The children in need of care and protection are defined in section 214 by serving the basic needs for their development and espousing a child-friendly perspective. This is the objective of the act. For this purpose, the section 213 and section 214 of the act distinguishes between two groups of children: children in need of care and protection 1 and the children in conflict with the law. These are the two groups of juveniles or the children or youngsters we are to be treated by this enactment. The former, the children in need of care and protection, the former comprises the children who are in adverse conditions and are in need of state support to become responsible citizens, whereas later are the children who are involved in criminal activities. The state is obliged to constitute for each district one or more child welfare committees to exercise the powers conferred and to discharge the duties assigned by the Act under section 27 subsection 1. The committee is the final authority to determine the cases relating to care, protection, treatment, development and rehabilitation of the children. It is also obliged to provide for their basic needs and protection of human rights under section 29(1). Then section 31 clause 1. According to this provision, a child who is in need of care and protection is to be produced before a committee by any person designated by the Act within the period of 24 hours, and a report shall be prepared and sent to the police and to the committee. So, any person designated under the Act should produce such a child who is in need of care and protection before the committee, and committee shall prepare a report, and that report shall be sent to the police and the committee. The report shall also be made by the person concerned. On the production of child or the receipt of report, when the committee receives the report or the child is produced before the committee shall make an inquiry and issue an order to send the child to the children's home or a fit facility or a fit person to stay pending the inquiry. During inquiry, that child will be sent to the children home or to any fit facility or to any fit person, or to stay for his or her stay pending the inquiry. This is provided in section 36(1). On the basis of conclusions drawn in the inquiry, if the committee finds that the child has no family or support or is in need of continued care and protection and is below the age of 6 years, the child shall be sent to a specialized adoption agency. If he is or she is below the 6th year, then he shall be sent to SAA, Specialized Adoption Agency, according to section 36 subsection 3. This specialized adoption agency helps to facilitate the process of adoption for the children in its institution and children in the child care institutions linked to the SAA. It also has the responsibility to provide care and protection to every child in its institution. Chapter 7 of the Act is devoted to the matters of adoption, which provide for complete and efficient mechanism to streamline adoption of orphan, abandoned and surrendered children. Orphans, abandoned children and surrendered children. Under section 68 of the chapter 7, the Act constitutes the Central Adoption Resource Authority, that is CARA. For replacing earlier Central Adoption Resource Agency, in place of this agency, the CARA has been established. The Act also provides for establishment of State Adoption Resource Authority, that is agency, that is SARA. So, at central level, the Central Adoption Resource Authority would be there. At state level, the State Adoption Resource Agency would be there to deal with the matters relating to the adoption in the state under the supervision of CARA. The CARA has been constituted with an objective to promote in-country adoptions and to facilitate inter-state adoptions in coordination with the state agency, to regulate inter-country adoptions, to frame regulations on adoptions and related matters, to take care of its responsibilities arising from Hague Convention on protection of children and cooperation in respect of their inter-country adoption. It has been made mandatory that all inter-country adoptions shall be made exclusively in accordance with the provisions of the Act and the regulations of CARA. The Act shall not apply to the adoption of children under Hindu Adoption and Maintenance Act. So, all these are the provisions relating to the adoption. Section 56(3) and 56(4) leads to the conclusion that if we read these two sections together, then we lead to the conclusion that all inter-country adoptions, irrespective of their religion, are required to be made in accordance with the procedure of the Act. Though it is not applicable to the Hindu Adoption and Maintenance Act, but for international adoptions, it is applicable to all adoptions, irrespective of religion of the person. Unlike earlier Act, the present Act makes the registration of child care institutions as mandatory requirement. It is very important initiative. Proper inspection of the institutions established under the Act is also stipulated by the inspection committee appointed by the state government. It has been made mandatory. Then the Juvenile Justice Care, Protection and Children Act, where all these initiatives have been taken, and for proper care protection of juveniles is made for both the procedure as to the treatment of juveniles and the care and protection by way of the children's home, by way of the fit facility, by way of fit persons, by way of the Kara and Sara relating to the adoption of such persons. It is also important to know that the Act lays down criteria for prospective parents for adoption, which was lacking in earlier Act. This provision may help in speeding the adoption process. Monthly visit by Child Welfare Committee to foster family has been included in the Act, and therefore it seems that the Act adopts all those standards and norms, or all those principles and perspectives which have been recognized by the international community through different international initiatives. If the proper implementation of this Act is made, that may be very good initiative on the part of government to take care and protection of the juveniles in India. Thank you very much.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. they are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.
Swayam Prabha. Digital India. Educated India.
Hello students, we are again discussing jurisprudence and Indian legal system. In that series, today we will learn lesson number 10, which is Amartya Sen's concept of justice. Why would we learn this? What would we understand from this lesson? We will understand about the different theories of justice. What are the approaches to justice? Then what is the concept of justice? And then we will go on to see what is Amartya Sen's approach to justice. Also we will see application of Sen's justice in our own country, and further we will look at some of the criticisms, and then we will conclude with the lessons learned. First of all, we will see different theories of justice. There are some of the basic theories of justice. You see, we have learnt about the legal system, we have learnt about the jurisprudence, and what is all these? These are all telling us that what would be better, what system, which school is better, which school is the best, and likewise, what would be the sense of justice? What would be justice that we should say that this will be the best form of justice? So that is the exercise that we are doing, and we will try to learn some of the basic theories of justice. The first is the natural law theory. Now, the natural law theory is of the view that justice is based upon universal moral principles, which is inherent in the nature and is derived from a higher power. Those laws which are violated are considered unjust. So there is a just, and from just there is justice. What is just, what is unjust? From there this natural law theory has been developing. Now, what is just and what is unjust? That implies that who will say that what is just and what is unjust? It is the human being. So in the human being, every human being possesses the mind, and in the mind there is rationality, the reason, the ability of every human being to understand what is good, what is just and what is unjust. From there, this universal phenomenon of having such analytical ability to understand the good and bad, to differentiate between just and unjust, from there natural law theory has evolved. And this is also the approach to justice, that if a legal system is just, then it is having a very good society where there will be justice to every member of the society. Likewise, we have another theory which is called utilitarianism, and you might have heard about Bentham, John Locke. These were the people who had advocated for utilitarianism approach. The most just system in this approach will be that maximizes overall happiness and minimizes suffering within the society. Laws are evaluated based on their utility in achieving this goal, that how to maximize the overall happiness and how to minimize the suffering within the society. So this approach is also very much widespread in the 17th, 18th and 19th centuries. So every law would be evaluated on the basis that how much good, how much more happiness that would be generated from that particular law. What is the utility of that law? And utility was measured in the sense of material utility, that whether this particular objective, economic objective and political objective would be achieved or not. Likewise, there is another theory which is also providing some idea about justice, is called social contract theory of justice, in which people, the jurists, they have tried to give their views that the whole origin of the state was made after an agreement made between the individual and the state, and that agreement is not the current agreement. The agreement must have been very old, and during those times when that agreement was reached between the individuals and the kings or the persons who wanted to establish the state, the agreement was that individuals would give away some of their liberties, and in return of those liberties which were given up by the individuals, the state will also grant protection to them, and from there emerged the development of the state and then organized the state. And there was a contract. This was a contract, and if this contract is broken, the person who is at the helm of the state, that person will not be having the right to be there. So this will be on the basis of the contract, and during that time when the contract was reached, at that moment of time both parties were having equal status. There was no inequality. There was no such thing that the state is standing at a higher pedestal and the individuals are standing at a lower pedestal. Both were having the same platform and they agreed. There was a mutual agreement. So that is called social contract theory of justice. So the individuals, in return of their protection, they would give away some liberties. Likewise, another theory which is also important to understand is called Rawlsian theory of justice. A person, a professor of law who was there in US, his name was John Rawls, and John Rawls had written a book named The Theory of Justice, and in that book he had written that fairness is very important. Every law must be fair. So fairness as a principle, he had propounded this principle of the theory of justice, that every law must be fair to promote justice. And then in elaborating the fairness principle, he says that there would be two principles of that. One will be equal liberty for all and fair equality of opportunity. And further he says that a just system would be chosen by rational individuals behind a veil of ignorance, and those people will be unaware of their own social position. Students, you might not understand the Rawlsian theory, but I will explain you a little bit more, and I will tell you that the Rawlsian theory is again deriving its cue from the social contract theory. The social contract theory, again you go back, and I told you that in the social contract theory there was a kind of consensus among those jurists who thought that there was an agreement between the state and the individuals. Now, elaborating further upon this theory, John Rawls said that if there would have been an agreement, and that agreement would have been in a veil of ignorance, that nobody knows who am I, no one knows that who is who, and then there is an agreement. This is called veil of ignorance. You are ignorant of your own position. Who are you? You do not know. You just think that I am also a human being, and others who are with me, who will be agreeing, and there would be an agreement. They are all human beings, and on that basis there will be an agreement. So people will not consider that who belongs to which race, who belongs to which caste, who belongs to which religion, who belongs to which nationality. All these things will be just not clearly known, and there would be called a veil. A veil will be there, and that veil of ignorance is very important in the Rawlsian theory. What he says, that when this situation, although it might be an imagined situation, when this imagined situation is there and then a contract would have been entered, then he was sure that the principles that would emerge, those principles would be definitely fair and they would be just. And on that he further says that there would be two more principles which will emerge, that we will also try to understand when we will try to understand Sen's approach to justice. Moving further, we will also try to understand the kinds of justice. What are the different kinds of justice? There are 4 or 5 kinds of justice. One is called retributive justice, another is called restorative justice, another is called distributive justice, and another is called procedural justice, and last may be social justice. Retributive justice is that justice where it deals with the punishment and deterrence. It says that crimes deserve a proportionate penalty to achieve justice and discourage future offenses. So retributive justice is a kind of justice in which there will be tit for tat. If a person is taking away some property, then it may say that punishment will be proportionate to the kind of act which was a criminal act that might have been there. Likewise, if a person kills someone, the punishment will be even more serious and the person may be given maybe capital punishment. So it all depends. This is the example of, and it says that justice will be achieved because only then unless there is not retribution, there will not be deterrence. So this theory works on deterrence. Another theory is restorative justice, which is an advancement over such kind of traditional understanding of justice. This restorative justice is about repairing the harm and reintegration. When the harm is done, when the injury is done, there are two ways. One is that the punishment would be given, and the other would be that punishment can be given, but also there will be effort to reform the person who has done some wrong, who has done some crimes. There can be also possibility of reforms because ultimately the person will come back to the society, ultimately the person will be reintegrated into the society, and therefore if he will not be reformed, what will happen? The society will not be good. So this is called restorative justice, and justice is therefore served by focusing upon repairing the damage caused by the crime and reintegration of the person who has done an offense, and that reintegration will be into the society, and when this is done, then the society will also grow. The next kind of justice is called distributive justice. Now that is a justice, the philosophy of justice, which was developed after the Marxian times, Marxism and socialism, when the call was that everyone should be equal. There was more focus upon equality. There should not be the unequal society, and people should not be divided on the basis of their economic status. Some people will be very rich, it will not be allowed, and some people will be very poor, this will also not be allowed. So the sense of justice was that there would be redistribution of wealth, there would be redistribution of the resources of the country. So this kind of justice, which is called distributive justice, where the resources would be redistributed. Suppose if there is a landless person and if there would be a landlord, then what will be the justice approach? In the distributive sense, that the landlord's land may be taken by the state, and then it will be redistributed amongst the landless people, so that there will be no landless people, there should be a land to every people. So this has been done in our country also. You might have heard about Bhudan Andolan, and that Bhudan Andolan was like the landlords, they would voluntarily donate their land, or sometimes if they are not willing to donate, then the state will give compensation to them and take the land from them and redistribute the land to the poor, to the landless. Likewise, another type of justice is called procedural justice, and I told you just about John Rawls, and he was also focusing upon this procedural justice, where he was saying that fairness of the legal process, that is very important. Any legal process would not be sufficient. A legal process which is fair, that will promote a society where there will be justice. And he says that justice requires fair and impartial legal procedures. Now, impartiality is also important. To have a society which is based upon justice, in that society what will happen, that unless there will not be impartiality in law, if the law will become partial, or if the people who are in the administration of justice, if they will be partial, then what will happen? There will be no justice. Therefore, this is another approach to justice, and which is called procedural justice. The procedure must be fair, and it should be reasonable, and there should be impartiality in the law and in the legal institutions and amongst the people who are administering the law. The last is the social justice, and social justice is a system in which it addresses systemic inequalities and it promotes social goods. In this, justice goes beyond individual cases, and it requires the tackling of broader issues of oppression and marginalization in the society. So this social justice means that if the people who are marginalized for a very long years or a very long number of time, then what will happen? That social justice will say that yes, we have to make such laws by which those people who are on the margins, they will also be in the mainstream. So this is called social justice, and it deals with the issues of oppression, exploitation on the basis of the status in the society, social status in the society. Now this needs to be adjusted and this needs to be changed, and therefore the concept of social justice has also been developed. Once you understand these basic things about justice, then we will also talk of the concept of justice. And as I had told you, that the study of law, the study of jurisprudence will not be complete unless we will also understand the concept of justice, which is a complex idea, which is a multifaceted idea, and there are various schools of thought which offer different perspectives. However, there would be some core values of justice, and I have already told you that fairness is very important. There will be no legal system which is a just system if there will be no fairness, and if there will be no treatment of individuals equally and impartially. A legal system would not be just if the laws will be applied not consistently and which discriminates amongst the people. There will be also another core value of equality. If equality will not be there, then there will be no justice. Individuals should have equal rights and opportunities under the law, regardless of social status, background, or other factors. Likewise, another important thing is about the proportionality of the punishments. The punishments or remedies should be proportionate to the offense or the harm caused. So these are some of the basic values, the core values of justice, and after that we will now come on to Amartya Sen, how he dealt with this complex and different ideas of justice, because he had written a book, Idea of Justice, in the 21st century, in the first decade of 21st century. He finally wrote a book, Idea of Justice. Although he was an economist, although he was not but a very trained lawyer and a skilled person of law, but he was having lot of broader ideas by which he wanted to have a just society, and he had published a book in 2006 where he wrote about idea of justice. In that book he talks about the method how to reduce injustice, and while doing so he tried to understand John Rawls. And when he was in Harvard, then John Rawls was also there, and he tried to interact with John Rawls, and he tried to understand his views, and both were friends, both were having a critical approach towards each other. So Amartya Sen, what he did, that he relied upon John Rawls as far as the basic theory was concerned. However, he was criticizing John Rawls because John Rawls had said that the fairness principle can be further moving on if the right institutions are created. John Rawls had favored the creation of institutions. And what is the meaning of institution? Like parliament. If the parliament is created which makes laws, and parliament making of laws, this is an institution. Likewise, the making of Supreme Court, making of high courts, making of the laws which are empowering the high courts and the Supreme Court. So this is called institution, developing the institution, developing the tribunals. So what John Rawls was saying, that if institutions are created in the veil of ignorance, then those institutions will continue, and because those institutions are fairly doing everything without partiality, and therefore what he was saying, that there will be justice in the society. However, Amartya Sen was different. He was saying that can you leave everything on the institution? Can you say that once you have created the institution and then your role is not there and you will be in the background? It is not like that. He was trying to examine, critically examine this thing, that whether just making the institution, that will be the solution to the problem. Just you say that okay, fairness will be there because there is a neutral person, there is a person who has a rational mind, and therefore there would be no inequality, or there would be promotion of liberty, because John Rawls, the first principle that John Rawls gave was the principle of liberty, because he was a person who was in the tradition of libertarian approach. He was saying that liberty is most important. So while giving liberty, maximum liberty to everyone, what he said, that if you create institutions, if you create right institutions, the liberty can be given to all the individuals, maximum liberty can be given to all the individuals, and people will grow and develop. And therefore he had given, John Rawls had given justice as fairness. This approach was given by John Rawls. Justice meant fairness. Justice as fairness Justice means fair rules, fair procedures, fair institutions. So this was also criticized by John Rawls. He says that what will be the fairness in the original position? Can there be impartiality in decision making? How will you ensure that there will be impartiality in decision making? Because decision makers may not be impartial. The institution might have been impartial, but the person who are deciding, those will not be impartial. And he gives an example of 3 children. Those children were just imaginary: Annie, Bob and Carla. These 3 children, he gives the example that these 3 children were quarreling for a flute. So what was the basis of this quarrel? Because Annie was claiming that flute, because she was saying that she is only one of the 3 who knows how to play it. Whereas Bob, another child, he says that he is so poor that he has no toys of his own, so he should be given the flute. So there is one flute, but Annie has a different ground, Bob has a different ground, and another child, Carla, she says that she has been working on making the flute for such a long time. She has been working on it diligently, and therefore her labor was involved. Therefore the flute should be given to her. Amartya Sen gave this situation of 3 children, and he was saying that who will be rightfully claimant of the flute? What will be just? Whether this will be right or wrong, that who will be given the flute, but what is just? That is also important. And he was saying that the libertarians, the utilitarians and the economists, they will differ on this theory. They will differ that whom the flute should be given, and you see that he was saying that everyone may be right, but what will be just? That is the question. And therefore he was trying to understand, ponder over this aspect, that if this is a situation, that a flute is one, it is a material, it is a good, it is one of the several goods which are there, and suppose if it has to be claimed by 3 different set of people, one who has given labor, and another who has no toys, poor, poverty, and another who says that he understands, he is skillful, he knows how to play the flute, so he should be given. So in all these situations, it appears that everyone has a rightful claim over the flute, but what will be just? That is the question. That is the whole perplexity of the saint's mind. And therefore what he was saying, that allocation of resources is a crucial question. There is a limited resource. In our country also there are limited resources, but how to allocate the resources, that is very crucial, because that will make a just society. And therefore the question will depend on the fact that how the social institutions are chosen, which social institutions are chosen to allocate the limited resources. Now that is important, because otherwise the jurisprudence, the normal, the traditional jurisprudence that was dealing with the laws, the existing laws, and what would be the kind of laws, where should the law be derived. But here is the approach where you will find that he is talking in a macro sense, and what he says that there should be the allocation of resources, reallocation of resources, and it will not be just left on the any institution. There will be social institutions, and which social institution should be chosen, that is also important. Which social realization will come about from the choosing of a particular social institution, that is also very important. So you will have to also look at the result. what result you want to achieve from which institution. Both these things are important to have a just society. So he was even a kind of more prudent, more different thinker on the approach to justice. And further he was saying that we should move from fairness towards justice. And while elaborating on this concept, that it's not justice as fairness, but from fairness to justice, that he was saying. And therefore what he was saying, that when Rawls said that fairness exercise is very important, then Amartya Sen was saying that Rawls was aiming at identifying appropriate principles which would determine the choice of just institutions which are needed for the basic structure of the society. So as I have told you, that John Rawls focused upon the making of institutions, and in the original position, if those institutions are made, then he was saying that there will be the basic structure of the society which will be created, and from there will be development. And then John Rawls said that some principles may be chosen in the original position, and in that original position, because everyone was equal, so everyone will choose a kind of good social system, and that governance will be a just governance. So what are those institutions? He gave the examples that even the legislation is an institution. The laws are institutions. Can we leave everything to the laws passed by the parliament? Just we will make the laws and then we will say that okay, we have done it, we have created the institution, and thereafter we will leave everything on the society and we will say that this is the just society. No. Amartya Sen was saying that this will not be happening just by leaving the institutions on their own. Further, he talked about John Rawls' theory, two theories, two principles of justice, and John Rawls, as I told you, he gave priority to liberty, and thereafter he was focusing upon the equality. So the first important thing for John Rawls was liberty. He was saying that we are in a libertarian country, and therefore we should have libertarian approach. So first thing which was important in the Rawlsian approach was that there should be liberty, maximum liberty to every individual, and thereafter equality. He thought of equality thereafter. It is not that equality will come first, and this is what is the difference between the Marxist or socialist theory of justice and the other libertarian theory of justice, where the Marxist or socialist theory of justice will say no, equality is important. However, the libertarian approach will say no, liberty is important, and if you give the liberty, only then there will be a possibility of equality. So Rawlsian approach of liberty was also like that. The first principle was maximum liberty, and thereafter he talked about equality. And when someone said that okay, but there are differences, people are not equal, then he gave the differential principle, and then he says that opportunity should be given equally to everyone, and even thereafter if someone is worst off, who is left behind, then what should be done? There should be distributive justice, so that resource can be reallocated. It should be taken away from the well off and it should be given to the worst off, so that there can be possibility of making an equal society and a just society. So this was the kind of principles which were laid down by John Rawls. But Sen was arguing that why should one regard hunger, starvation and medical neglect to be invariably less important? than the violation of any kind of personal liberty. So personal liberty means that if someone will harm you, like if you are going and someone will injure you, then you have the liberty not to be injured. You have the freedom that you will go anywhere. However, if there will be hunger, people are dying of hunger, if there will be starvation, and then whether the question is that whether this will be allowed to happen. So a person will be interested in his own thing and other person is starving. So Sen argues that whether this can be allowed at the in comparison to the individual liberty. He further gives the example of disability. He says that a disabled person can do far less with the same level of income. If a disabled person is there and he is also earning the same income and another person who is also earning the same income, then Amartya Sen says that the person who is disabled, he will have less opportunity, and therefore what will be happening, that you redistribute the income. You have redistributed the primary goods, but what we did not look, that a person who is disabled, how can we do something for him, what should be given to him or her who is a disabled person, so that he can also enjoy the rights, equal rights, and then the society will be just. He further gives example of a pregnant woman, and he says that a pregnant woman needs more nutritional support compared to others, compared to those women who are not bearing a child also. So who will care? The same situation may be there. She is also earning, and maybe that another woman is also working, but a pregnant woman's need is different. So who will look at the capability? What is the capability of a pregnant person? What is the capability of a disabled person? So Amartya Sen was also trying to explore that it is not just important to leave everything on institution, you just make the laws and then forget what will happen, but rather we should also look at what much capability is given to someone to enjoy the rights. Like the constitution, in our constitution there are fundamental rights, but what will happen to a poor person? Can a poor person avail the fundamental rights? Can a poor person go to the High Court and Supreme Court to avail the fundamental rights? And suppose if it is violated, what will happen? Therefore it is important that capability, if a poor person is there, what will be his agency, whether he can stand for the court even if he is a human being. So the human rights, according to Amartya Sen, the human rights approach to justice is very important. That we will also come to learn in just a bit of time. But therefore what he was saying, that there is a strong case for moving, and we should not focus on primary goods. We should also try to understand the assessment, actual assessment of freedoms and capabilities. How much freedom is given and how much capability is there, and we will have to assess this linkage. Only then there will be a just society. Further, Amartya Sen refers to our own jurisprudence from this country, and while he was in Harvard, he did not forget our own country and the jurisprudence of our country. He says that in the ancient jurisprudence, Niti and Nyaya were mentioned, and he said that both stand for justice. Niti refers to organizational propriety and behavioral correctness, and Nyaya stands for a comprehensive concept of realized justice. Now this realized justice is different from simply having a law institution based thing. Realized justice means what you achieve, what justice have you achieved. So Nyaya is a broader concept, it is a comprehensive concept. Rather, Nyaya is a very updated and a very progressive and a very modern kind of concept. Niti refers to the organization, the propriety of organization, and how the organizations behave. The roles of institutions, rules, and organizations have to be assessed in the broader and more inclusive perspective of Nyaya. So Nyaya, when we have the Nyaya based society, then the assessment of roles of the laws, institutions, organizations will be also made. This assessment is only possible in a Nyaya based society. In the institution based society, in simply having a justice as fairness society, there cannot be Nyaya because there will be no assessment. And therefore what he says, that Nyaya is linked with the world that finally emerges, and not just the institutions or rules we happen to have. He further gives the example of Matsya Nyaya. What was Matsya Nyaya? That the justice of the fish, big fishes, they will eat the small fishes. This is justice. Is this the justice in the modern times, that a rich person will devour the poor person, or a strong person will cut the weak person, or the king will not save the weak person? Whether this is justice? Then this concept of Matsya Nyaya, which has been there in our country jurisprudence, he says that it should be avoided. We must avoid Matsya Nyaya because that is essential part of justice. And further what he says, that no matter how proper the established organizations might be, if a big fish could still devour a small fish at will, then that must be a patent violation of human justice as Nyaya. So he was trying to understand the concept of Nyaya in a very significant way. Therefore he says that the understanding of justice as Nyaya cannot neglect the actual social realization. Now this might not have been very clear in the times when just Nyaya word was coined in our own jurisprudence, but Amartya Sen tries to link Nyaya with his own theory of justice when he says that Nyaya should look at the actual social realization that may be expected to emerge from any choice of institutions, given the actual behavior patterns of the society. And therefore what he says, that what really happens to people cannot but be a central concern of a theory of justice. So actually the laws, the impact of laws, that is very important to know. Just making laws are not enough, but also assessing, evaluating that ultimately what is the impact of those laws. The institutions which will be chosen will not only be in line with the nature of the society in question, but they will be also codependent on the actual behavior pattern that can be expected. So if the actual behavior pattern is not changed by making of laws, then the society will not be a just society. The justice will not be there. Ultimately, laws are made by the institutions, but if the actual behavior has not changed, that will be not enough, that will be nothing significant, because laws must be based upon the objective, what is the actual realization, actual social realization. While exploring the whole idea of justice, he also referred to the great Mauryan king Ashoka the Great, and you all know that Ashoka the Great was great ruler in the 3rd century BC, and he was the author of many inscriptions on good behavior, on just behavior, and therefore he had carved these inscriptions on durable stone tablets and pillars across the country and even abroad. And on that pillars, what he had written, that okay, what would be the good behavior of the people? What would be the just behavior of the people? So this is kind of manifestation of the king's will, that this will be the good behavior. And the emperor was saying that we should not be intolerant. He was saying that you should all be tolerant. And what he says, that even when one social or religious sect of people find themselves opposed to other ones, other sects should not be saying that no, then I will not tolerate you. So he was saying that because if you will say this, other sect will also say this. What will happen? So this was the advice of the great Mauryan emperor Ashoka. And you know what he was saying, that Ashoka's thinking on social justice included not only his conviction that advancing the welfare and freedom of people in general is an important role for the state as well as of the individuals in society, but he said that this social enrichment could be achieved through the voluntary good behavior of the citizens themselves. It is the voluntary good behavior. So Ashoka in those times, thousands of years back, he just not relied upon making the institution, but actually he tried to change the actual behavior pattern of his own people, and the people showed that good behavior without being compelled through force. Ashoka, you might have heard, Ashoka later on, he had left, he had said that no, I don't want war, although he had fought Kalinga war, but after Kalinga war he said that no, I am going to change. Ashoka had spent a good bit of his life trying to promote good behavior, spontaneous behavior in people towards each other, and the inscriptions that he erected across the country were a part of that effort. Because you see, Ashoka had renounced war also, Ashoka disbanded his army also, Ashoka liberated the slaves also and the indentured laborers. You could imagine that then only the people changed their behavior. So Sen's approach to justice was not simply lawmaking, but actual assessment of the impact, the actual realization in the society, and how the behavior pattern would be changed. He also gives reference to Kautilya. We have learnt about Kautilya's jurisprudence, and Sen argues that in contrast with Ashoka's focus on human behavior, what Kautilya did, Kautilya put his emphasis on building up and making use of social institutions. You remember that Kautilya had said that what will be the code of conduct on marital life, what will be the code of conduct for the contract, what laws will be there on contract, pledges, loans, and what will be the law on the property. So Kautilya had given more focus upon use of the social institutions. Kautilya's political economy was based on his understanding of the role of institutions, both in successful politics and in efficient economic performance. And he saw institutional features including restrictions, you remember, prohibitions, as major contributors to the good conduct and necessary restraints on behavioral license. So what Sen was thinking, that Kautilya was a no-nonsense institutional view of advancing justice. He was clearly like that, and Kautilya did not give any concession to people's capacity. He did not rely upon the people's capacity for doing good things voluntarily, without being led there by well-devised material incentives. What Rawls had said, that you give material incentives to the worst of, or in the fair society there will be incentives for the primary goods. So finally, after giving reference and after trying to understand different theories and John Rawls and Kautilya and Ashoka and you see Niti and Nyaya, what finally he says that social choice is very important. He is trying to propagate social choice theory, where he gives 7 components of social choice theory. The choice, it should be the choice of the society, that which institution are actually relevant. So what are those things? What he is saying that let us focus on the comparative and not just the transcendental, not anything which will be universal. We should not be universalizing everything, that we will say that suppose if we take up the human rights cause, it will not be universal human rights. So it may depend upon comparative study. Comparative study will be more relevant. Further, he says that plurality of competing principles. There cannot be one principle which will be sufficient. There cannot be utilitarian principle which will be sufficient. There cannot be the libertarian approach which will be sufficient, but there will be plurality of competing principles, and let the society have the choice to select that which will be the best principle. Further, allowing re-examination of the principles. If you do not allow, if you just say that no, socialist system is good and there will be no change, you are not having any right to re-examine and that which system is good or better, then this will not be a good society, this will not be a just society. Further, he says that the impartial resolutions are also important, and then he says that the interpretations can be diverse and the inputs can also be diverse, and that should be allowed. Further, he talks about articulation, that let the people articulate their concerns, their grievances, and let the people be thinking in a reasonable way. And therefore finally what he says, that public reasoning, public participation in the decision making, the reasons of the public, if you make the law, you should also take the public view of the public, that should be also taken while making the law. It should not be that only parliamentarians, they will make the law, but they should also seek the people's input while making a law. So what we have seen, that Amartya Sen was not satisfied with simply having the institutions and laws and having the libertarian approach, but further he was advancing his theory by focusing upon the capabilities approach. And what he was saying, that the justice as fairness will not be sufficient. Why capability? Because if you look at the capability, then that will enable the individuals to develop their capabilities and freedoms to flourish. If you make the poor people capable to go to the court, otherwise poor people will remain violated. If you will make a woman who is going to bear the child able, so that if you give leave to her, okay, that you take leave, and then when you come back, your things, your material things will not be disturbed. So that is called capabilities approach. Equality of opportunity, because that is important, so that the people will be pursuing their chosen way of life. And these are some of the important ideas of Amartya Sen, and therefore what he was saying, that look at the individual freedom and choice, you expand the agency of the persons. The agency, you give agency. Poor people are not having agency. Women may not have agency. The children, the disabled, they do not have agency. You should also, the just society will be that society where there will be this capabilities approach, where you will be able to give agency to those people so that they will decide they will have more freedom, only then they can do it. And then he was saying that development must be evaluated. It is not simply that, okay, you say that this much of GDP and that much of GDP, but what you will have to also evaluate that what is actually, whether hunger has been removed, whether poverty has been lessened, or whether employment or employability of persons have increased or not. So this is more important. Capability is more important, and that was Sen's thrust. That was Amartya Sen trying to tell us. Finally, he was also talking about human rights, and I have told you that ultimately these are all, human rights, to take care of the disabled, to take care of women, to take care of the children, to take care of the old people. This is about the human rights, and what he says, that human rights approach demands that the acknowledged rights of everyone must be given ethical recognition. An ethical understanding of human rights needed. Ethical understanding, not just legal understanding, that what will be the better way to protect the human rights. Just giving the human rights will not be enough. Just you say that civil rights are available to everyone is not enough, but we should also look at the capability of the human being, what he can achieve, how he can achieve, or how a person will achieve. And further he says, what about the second generation human rights, the economic rights, the social rights, the cultural rights? Can you not give them? And you will say that there will be institutions, laws have been made, and then the treaties are there. What he was saying, that exclusion of economic and social rights from the inner sanctum of human rights, keeping the space reserved only for liberty and other first generation rights, that attempts to draw a line in the sand which is hard to sustain. So he was also trying to address this concern that second generation human rights are forgotten by the libertarian approach. So Sen was close to the natural rights theory, that yes, we should have also human rights, but in the human rights he was little bit different, that within the human rights circles, the economic rights are also important. We should not forget the economic rights. When we come to India, I have although given you many examples. In India also, poverty, inequality, freedom of opportunities, healthcare facilities, education, environmental protection, all these things can be done by utilizing Sen's approach. Now we will come on to the criticism of Sen's approach, and we will see that he was vague on the idea of capability, and then on prioritization and measurement. It will be difficult to actually give a measurement criteria, and what is about implementation, how you can assess, how you can evaluate, this will be also difficult. However, the Sen's theory of justice must be understood in the way that there should be social choice. The choice should be given to the society. The choice should not be taken away by the people who are at the helm. The choice should always be there in the society. And then he says that society is not of one kind. Society is having people from diverse social backgrounds and economic backgrounds, and therefore the human rights approach, that is also very important. And it is the imperative that if we have a sense of justice, if we have a theory of justice, then it must look at individual agency.
Swayam Prabha. Digital India. Educated India.
This is a basic course devoted to the understanding of organizational and human resources management issues in the functioning of engineering systems. It assumes that the listener has had a basic understanding of the courses which are normally run in engineering institutions in the first or the second year, and has some understanding of what engineering systems are about. His orientation as an engineer would be of a person who operates a system. This course seeks to build upon that by developing his competencies as a person who operates an engineering systems to a person who puts the engineering systems to productive use, therefore making a better engineer of a good engineer. It seeks to build upon his basic strengths of the functioning of engineering systems, and then add to it concerns of decision making and problem solving from the perspective of organization of the systems and dealing with the human element thereof. It is well recognized that to operate any system, to operate any process, there has to be an organization behind it. The principles of organizing and putting together different elements is fundamental to civil life and fundamental to any productive operation. This concept is very often attributed to the coming in of modern management thought, which however is only a limited truth. Organization as a function is neither a modern phenomena, nor is it rooted in a post-industrial society. Developed civilizations have existed globally in different parts of the world and reached high levels of productivity and cultural and civilizational excellence even in the pre-industrial era. Typically, one can go to the river valley cultures of Nile, Tigris Euphrates, Sindhu, popularly referred to as Indus, Ganga, Yangtze Kiang, and the list is large. They all had a civil society which had as the underpinning principle a system of organization. Therefore, we begin this course by an appreciation of the fact that organization as a function or as a concept is as old as civil life on this planet. In fact, in the ancient texts, there is a statement, yojakasya tatra durlabha. Translated, it would mean that it's difficult to find a person who can organize. That is one of the classical truths captured in Sanskrit statement and holds valid today, just as many classical truths transcend time and space. The ability to organize is central to the successful operation of an activity, and it has elements of both analysis and synthesis which are difficult to master and requires discipline to operate. This course will be focusing on the organizational function of engineering systems, and as I mentioned earlier, will be also looking at the human elements which go into productive systems, and human elements would cover areas of basic human functioning like motivation, planning, the legal framework in which it operates. But whether it be the organizational aspect or the human resources aspect, the course will not be exhaustive, because as usual there will be limitations of time. But it is hoped that the course will be able to orient the listener and the student into a basic competency of appreciating the elements of organization, the need for organization, just as much as the elements of human resources management and the function it plays in handling engineering systems. The objectives which we seek to fulfill through this course are 5, and I would like to run you briefly through it so that your expectations from listening to these recordings may be put in perspective, and you and I can work together for fulfillment of those objectives. The first objective is to impart to the senior undergraduate engineering student, and engineering student here is open to people with a science background also, an understanding of the theory and principles of organization of engineering systems and human resources management. In other words, at an aspirational level, you will be able to appreciate the broad contours of the theory and principles of both organizing and the human elements in engineering systems. The course will also give to the listener the ability to perceive issues from an overall management perspective. Besides, the means to analyze developments in organization systems, functions and capabilities. It has 2 other objectives. The means to effectively understand organizational functioning and its human elements will be imparted to the listener, and he will be able to have some ability to become a performance oriented manager of systems, or to go back to what I said earlier, a person who puts the systems to productive use. It would be useful if the recordings are heard after some basic reading in the subject matter, because it helps to follow the flow of the argument, and it also enables one to critically integrate what one is hearing into one's cognitive system. The reference list is available. Please go through it, but it is not as if those are the only books which need to be read. They have been selected because of the way they relate to the course and the way they amplify upon some of the topics. But just in case those books are not available, it would be useful to read a book which generally orients a person into understanding what are the driving principles of managing, and to that extent established author dealing with organization, management and functional elements of productive systems, no matter under what title he captions his work, would be worth relating to. The course itself is divided into 3 modules. The 3 modules are Basics of Organizations and Human Resources Management, under which 5 elements will be covered. The second module is Effectiveness and Performance, and the third module is Human Elements of Functioning Organizations. It seems useful to recognize that each one of these topics is capable of independent and separate treatment, and in some of the postgraduate management programs, they do constitute the subject matter of a course, but in our case, these will be introductory elaborations preparing you for a higher level of learning. It seems to me important to establish 2 of the driving elements of the breakup of the topics, so that you can have a higher level of comfort in understanding the presentations as they are made. There is in management literature a specialization which deals with organization theory and practice. Organization theory and practice deals with concepts such as what constitutes a job, how you would do a job design, how you would pull jobs together to create an organization design, or indeed how you would structure the flow of work in any organization, going on to understand how the processes function in an organization. In other words, no matter which is the organization in question, there is bound to be a structure, there is bound to be certain tasks which put together will become jobs, there is bound to be a flow of work which is perhaps best captioned as organizational process. We will be touching upon all this in module 1. We will be also recognizing that none of this is possible without understanding the basic nature of an organization, because if the subject matter is focused on organization as a key concept, then it cannot be used in a general common sense use of the word, but there are bound to be certain technicalities. Given the medium of communication that we have adopted between us, it is not possible to get into large definitional elaborations which would inevitably encourage a debate which would need a personal iteration. But it is simpler to communicate if you decompose the content into its basic elements, which is what I will be doing in my next lecture with you. And also I will be drawing your attention to how human element does affect organization, much in the same way in which no matter what the mechanical system is, say typically in a two-wheeler or in a four-wheeler, repeated usage creates an impact on the mechanical system itself. For example, you will find that no two used cars will ever have their first, second, third or fourth gear, you name it, coming in precisely the same angle to be absolutely in a identical mode one to the other. Repeated usages would have affected the angle of the movement in a visible and identifiable manner. Now, if that is the impact which use makes even on the machine systems, then one can imagine how human element will be affecting the structure, the process, or indeed the design of work. Even if technically structures are common, usage gives to it a unique slant, and much of this will be clear as the elaboration goes on. Therefore, in the first module, you will be taken through 5 topics, and let me list them for you so that you get conditioned to listening to it in a more elaborate manner in the hours of listening to come. And the 5 topics to be covered under module 1, which you heard me say, is captioned Basics of Organization and Human Resources Management, are 1. Understanding organizations, 2. Concerns of organizing, engineering, business and systems, 3. Structure and process issues in running organizations, 4. Design issues in running organizations, and 5. Capping it all up, operating organizations. We believe that if you go through these 5 components of module 1, after having done some essential reading of the kind of book which I have described some time ago, then your ability to receive the inputs would be higher than if you were hearing all this for the first time. Having said that, we are going to emphasize the understanding component and referring to the applicational aspects. That is essentially how it is structured at an undergraduate level where this course is pitched. As and when and if you choose to pursue a management education at a postgraduate level, you will find that there will be increasing emphasis on the applicational aspects, because it will be assumed that the understanding of the elements and the appreciation of the elements has equipped you to look at the applicational aspects. For the present, however, if you have clarity on what to expect, then you will be in greater sync with what is being elaborated. The second module, if you will recall, is captioned Effectiveness and Performance. Any managerial system is devoted to pursuit of results. It is committed to be effective. Indeed, of the many definitions of management which abound, and several of them are not even worth repeating, say typically a statement that managing is getting other people to do your job is a definition which is not only palpably inaccurate, but not worth repeating or disseminating. That is a popular definition in many quarters is one of those ironies which can neither be affected nor changed here. Management as a subject, as a discipline, as an action-oriented cognitive effort is essentially focused on the making of a practitioner. The making of a practitioner can come through formal learning and through experience. Management education, therefore, is committed to the creation of this practitioner. In other words, reinforcing the competencies of individuals which make them better problem solvers and decision makers. Hence, it is possible to suggest that management deals with problem solving and decision making with clear-cut concerns of optimizing resources. Effective management cannot brook any wastage. So, you can clearly see that there are three components: problem solving, decision making, and optimization of resources. Management action should be able to put the three together. So, if we are dealing with problem solving, again it needs to be emphasized that in management discipline, problem as a word does not have an identical meaning to that of the word difficulty. Problem in management is not necessarily defined as a difficulty. It can be a difficulty, but problem is understood in management action as a situation. So, when you are dealing with problem solving, you may have a situation which is working fine, but which needs to be improved further, and that will be and can be called problem solving, which is why in many cases when the discussion takes place, and as you may be aware, case method is an important element in skill formation in management at the higher level, you may be asked to discuss a situation just to improve it to its next level of growth. As a decision maker in an organization, you may be having a perfectly functioning system, but as a manager in that position, you would be expected to raise the level of performance. So, that is the connotation of problem solving. Decision making is a choice amongst options, but to exercise the choice amongst options, first and foremost you must generate the options. Hence it is that management competency requires both a generation of options and an ability to eliminate options after having generated them by doing a strength and weakness analysis to zero upon the most appropriate course of action. But be it decision making or problem solving or however you put the sequence, an important touchstone is optimizing on resources. For those of you who are familiar with golf, or if you haven't, and when you have an opportunity, look forward to becoming familiar with golf, you will realize that it is possible to get a bad break with a good shot, or a good break with a bad shot. But irrespective, it means that you must play ball where it is. Management is therefore dealing with the art of the possible. You cannot wish a situation away. Those are the facts of life. Very often the facts of life are neither something you wished for or did anything to earn, but they are givens, which is what brings in the need to understand a longitudinal thinking in management. Be that as it may, management requires sound reality perception and doing the best you can where you are, which is why reference to resources. There are always limits to resources, and you have to function within those resources, and it is expected of a manager that he will optimize on those resources. So, now to share with you the content of the second module, which you heard me say is dealing with effectiveness and performance, and this elaboration was necessary so that you understand the logic of the selection of the components of the second module. They are cybernetics and systems framework, having some appreciation of engineering as a domain of learning. The assumption is that the word systems is not all that new to you, and you obviously would know that cybernetics is an important tool in systems framework. It is an important concept. We will be also dealing with socio-technical systems, which for many managerial decision making is a significant approach. The remaining 3 topics will be dealing with efficiency and excellence. Together they will constitute effectiveness. Dealing with man-machine relationships, and of course, as you would have anticipated, some reference to longitudinal thinking. This elaboration will help you to understand some of the basic building blocks of effectiveness and performance. This will be followed up by the 3rd module, which we have captioned human elements of functioning organizations. In this module, we recognize an inevitability in management action. No matter how well an organization is structured, no matter how clear the processes are, no matter how scientific they be, and no matter what simulation and programming went into doing up the job design, ultimately it is human beings which will run the system. It is human beings which will make a system work. Any of us who believe we are in an adult mode would have had the pleasant and unpleasant experiences of life. We would have been surprised where we least expected it, both in an unpleasant manner and in a pleasant manner. Indeed, human resources management have very limited predictive validity. In fact, the story goes that somebody was shooting a scene of an altercation and he was not getting it right. So imagine the busiest bazaar of your city, and imagine the director instructing the hero to walk down the pavement of that busy street and instructing that hero to accost the first couple which came down the road. And here is the story. After several shots of the altercation were spoilt, this director decided to convert it into a real scene, and before it got out of hand, explain to the people concerned what had happened, so that nobody was really hurt. But it would be a live scene. So the hero started walking down the pavement, and the first couple that he met coming from the other side, he accosted them, said hello to them, and the man asked, "Yes, what is it?" So the hero took a step back and he said, "Sir, as you came down the road, looking at both of you, I asked myself how a distinguished, elegant person such as you could ever be with such a wretched woman who is so ugly and certainly not fit enough to be your companion." Now, the hero was expecting the man to get infuriated at this kind of very uncouth and ugly reference to his wife or whoever the lady was with him. But instead, the man turned around to the woman who happened to be his wife and said, "You see, darling, now people on the streets are saying what I have been telling you all my life." As you can imagine, the shot again got spoilt, and the director was at his wits' end how to get a scene of physical altercation, either simulated or real, which would be convincing enough in the story, but that's another matter altogether. The purpose of this narration is to put across to you a simple realization which some engineers have difficulty and take time to grasp. There is no predictive validity in dealing with human beings. It is possible to be deterministic, and it is possible to forecast with a reasonable degree of tolerance when you are dealing with inanimate objects, when you are dealing with materials, when you are dealing with elements which do not drive themselves. But when you deal with live substances, when you deal with live beings, and certainly when you deal with human beings, there is no way in which you can control their behavior to a point which is entirely to your expectations, which is why management of human beings becomes such a tricky issue, and a lot of people who are precision oriented and who believe that act of management is an application of operations research theory to decision making options, and therefore must lead to some kind of an optimization of resources in a programmable manner, simply find it impossible to understand how on earth do you deal with human resources. And if you think that's the end of the problem, it is not. There are people within the domain of human resources who object to calling human beings a resource. Their take very simply is, human beings cannot be a resource. Human beings are ultimately the recipient of all human endeavors, and all human effort is meant to support human beings. So, how can human beings be converted into a resource? Therefore, the use of the phrase human resource is not something which they feel good about. Be that as it may, this is not the place where this debate can be resolved, but this is certainly the place where in an introductory lecture or conversation or presentation, you choose your word, you should be sensitized to what the concerns are, what the debates are, what the perspectives are, and what the treatment is going to be in the coming set of hours. So, the elements of the third module are concerns of recruitment, selection, skill formation and redeployment. Why do we begin with recruitment, selection, skill formation and redeployment? And here comes a yorker. The sooner it is internalized in decision making and problem solving, the better it is. Nobody is employed as a person or paid as a person, but a person is employed or paid for the skills which one brings to the tasks which he is supposed to accomplish. Therefore, the recruitment is of the set of skills you have, and your compensation is for the skills you have. Because if you are not a part of the productive process of the organization itself cannot function and will find it difficult even to find means of paying your wages. So, the emphasis on recruitment, you recruit for a set of skills, and when you recruit, you obviously will have to select. And so, the story goes on to cover skill formation, which is a continuous process. Skill formation is never one time. An average work career spans anywhere from 35 to 40 years. The environment changes, the technology changes, and if somebody is carrying only the skills which he came into an organization with, will clearly be obsolete quicker than he can even think. Therefore, it is important to realize that skill formation is a continuing business. To make skill formation a continuing business, there are interventions which reinforce learning and development. And finally, it is not only the skills which need review, but even the jobs get changed. For example, in telecommunications, when Stoger systems moved over to ESS2, it caused a need for a huge redeployment effort of the engineers who were recruited with a given set of abilities and competencies, but to stay alive in that domain, they would have to grow into a whole set of new competencies and new operations, meaning thereby that redeployment would need interventions and planned effort. We will then go on to looking at concerns of teams and leadership. Now, again, these two words are used in a technical sense, as they should be in the management domain, and teamwork is not just I like you, you like me, let us work together. Of course, if you like each other and you find it easy to work with each other, it is simpler to perform better. But facts of organizational life establish that very often you have to work with people whom you do not like. Very often people will deal with you in a manner which is palpably uncalled for. But as the doyen of Indian management Prakash Tandon used to say, you can't ask the world to stop rotating because you want to get off. It is important to realize that in a work situation there is a role relationship. The person behind that role, of course, is important, but ultimately you are there to do a task. If you do that task well, the organization remains healthy and effective. What I am trying to convey to you is that teamwork is for task accomplishment. Therefore, in any job, there are a set of receivables and there are a set of deliverables. If there is integration between receivables and deliverables, then your job is justified. And the relationship between receivables, your job, and the deliverables creates the constituents of a team, and I might go on to add a continuity for accomplishment of the targets and the quality standards which have been set. Similarly, leadership is not just exhortation. It has different components and we shall cover it in course of time. But for the present, leadership is gradually beginning to be recognized as a quality which is universally needed at all levels of an organization, in all manners, and whoever is doing a task is the leader there and then. So there is almost a pervasiveness in the concept of leadership. The remaining three elements in the third module will be understanding motivation, elements of human resources planning, and Indian industrial law, and managing industrial relations. That's where the course concludes. Obviously, nothing gets accomplished unless there is motivation to do it. One can get into an action of accomplishing a task with no involvement and in a manner which makes it impossible to breathe life into the action of the tasks. The quality of the outcome there will never be as good as it would be with deep motivation. Forget deep motivation. Even routine action requires some motivation. What is it that motivates people? There are a lot of quips in it. Some real, some in a light-hearted vein. Like for example, when are you motivated to go along with someone? It is not by being reminded of what that person has done for you, but by a feeling of what that person is likely to do for you in future. Now that's motivation. There is a subtlety about it. There is an irony about it. Skills lie in understanding the subtlety, in accepting the irony, and being able to cope with it to the best of your ability to keep yourself optimally operational. And that's being a good and an effective manager. This discussion will be followed by understanding human resources planning, because like in any other component of decision making and problem solving, you need to plan for human resources. What do you plan in human resources? You plan for the phasing out of the skills and the anticipation of the skills required in your line of production or business. You plan for methods of recruitment. You plan for providing amenities, facilities, growth options to your employees, to your decision makers, so that they have a level of comfort, so that they can focus on the actual action which is needed in the production and the decision making process of the organization, rather than being worried about nano details which have got nothing to do with the organization but which touch their real lives. You plan also for a carefully calibrated exit policy. The age factor in many organizations is changing. The average age in certain industries is becoming progressively lower. In certain other industries, it has not been lowered to the same extent. And there are any number of variations. You plan for a carefully calibrated impact on this process of separation. You plan for the salary and wages. In fact, just about any resource which touches human beings, you have to plan for that. And finally, this has to be done in the framework of the legal setup which exists in the land. There are labor laws, there are laws which touch finance, which touch economical operations, which touch retirement benefits, employee benefits, in fact just about any aspect of management would have some law in the land governing it. It is important to understand that a lot of management action requires an understanding of what the legal framework is all about. And then the ability to handle industrial relations is important to operating engineering systems, because industrial relations have to do with relationships with groups of people in the productive process. To sum up, therefore, this course on organization of engineering systems and human resources management will give you a broad bird's eye view of how appreciation of managerial principles and operations is important to be effective in an engineering system. Engineering is important, of course. It helps you to operate the system. To be a good engineer is critical. But to be a better engineer, you will require an appreciation of how engineering systems are impacted by decision making and problem solving, which is often captioned as management. This course focuses on organization of engineering systems and human resources management. Welcome to the elaborations, which I hope you will enjoy listening to.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP. You have your incidence of high BP, MAP, and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol, and incidence of high cholesterol. Now, before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with the 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So, the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data. So, I will be doing it according to age, by gender, and by your weight. So apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors, like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator, which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth, or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age, and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a women's health more. But this has been only seen as far as cholesterol is concerned. The various measures of cholesterol, like total cholesterol, good cholesterol, and your incidence of getting high cholesterol. Now, after this, we went in for a policy implication, and in the policy implication, we tried to find 2 policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average, 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP, and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has an impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators. And it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day. But fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.
Swayam Prabha. Digital India. Educated India.
Namaskar viewers and welcome to Swayam Prabha. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University with Delhi. I and my colleague Dr. Saurabh Rana are doing a course on procedural law on crimes, Bharatiya Nagarik Suraksha Sanhita 2023. Today, I will be delivering lesson 11 in which we will be talking about investigations. Section 175 is the provision given under Bharatiya Nagarik Suraksha Sanhita which talks about police officers' power to investigate cognizable cases. It says, any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter 14. So what is a cognizable case? What are cognizable offences? That is something which we have already discussed. However, to again repeat the same briefly, cognizable offences are more serious offences in which the police officers have the power to arrest even without waiting to obtain a warrant from the magistrate, because they are more serious in nature. So the police is supposed to compulsorily register an FIR and immediately start investigation, start collecting evidences, contacting witnesses so that a case can be built and the accused can be apprehended before he manages to escape from the jurisdiction. Now, section 175 is giving in detail the police officers' powers, what they have to investigate cognizable cases. So what it says, that even without the order of magistrate, a police officer can start investigating cognizable case in which he has the jurisdiction. Now, provided that considering the nature and gravity of the offence, the Superintendent of Police may require the DSP to investigate the case. Now, this is a new provision that has been added because there have been many substantial changes in our substantive law, which is the Bharatiya Nyaya Sanhita also, and new kinds of crime such as organized crime, terrorist act, they have been introduced in the BNS, wherein a discretion has been vested in an officer not below the rank of SP, who when he gets information as to terrorist act, then he would have to decide whether the case would be registered under the UAPA, which is the Unlawful Activities Prevention Act, or whether the case would be registered under the BNS. So many things have to be taken into consideration, and that is why sometimes a superior police officer might be asked to conduct investigations in the case. Then subsection 2. No proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. So in case the investigation has once been done, the investigation will not be called in question on some mere grounds, on some petty grounds. Then, any magistrate empowered under section 210 may, after considering the application supported by an affidavit made under subsection 4 of section 173, and after making such inquiry as he thinks necessary and submission made in this regard by the police officer, order such an investigation as above mentioned. And any magistrate empowered under section 210 may, upon receiving a complaint against a public servant arising in the course of his discharge of his official duties, may order investigation subject to receiving a report containing facts and circumstances of the incident from the officer superior to him, and after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. So you see, students, in this slide, all the points that have been highlighted in red, these are all new additions to the BNSS. These were not already there in the Criminal Procedure Code. Now we had to decolonize our laws. We needed to amend our laws to introduce new kinds of crimes and new kinds of procedure to deal with those crimes. And sometimes we also needed to strengthen our enforcement mechanism so that there is a feeling of security amongst our people, as is conveyed by the title, Bharatiya Nagarik Suraksha Sanhita. So towards that end, all these amendments, they have been introduced in the new law. Under section 175 subsection 3, which was the old 156 clause 3, now section 156(3) of CRPC, it is wide enough to include all such powers in a magistrate which are necessary for ensuring a proper investigation, and it includes the power to order registration of an FIR and of ordering a proper investigation if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police. Section 156(3), though briefly worded, in our opinion, is very wide, and it will include all such incidental powers as are necessary for ensuring a proper investigation. This is a 2020 judgment in the case of M. Subramaniam versus S. Janaki. Then there is a 2009 judgment, Dilawar Singh versus State of Delhi, in which the courts further clarified that even if an FIR has been registered, and even if the police has made the investigation, or is actually making the investigation, which the aggrieved person feels is not proper, such a person can approach the magistrate under section 156 subsection 3 of the CRPC, and If the magistrate is satisfied, he can order a proper investigation and take other suitable steps and pass such orders as he thinks necessary for ensuring a proper investigation. All these powers are enjoyed by a magistrate under section 156(3). Now let us understand the procedure for investigation. That has been laid down under section 176 of the BNS. The law says, if from information received or otherwise, an officer in charge of a police station has reason to suspect the commission of an offence which he is empowered under section 175 to investigate, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence upon a police report, and shall proceed in person or shall depute one of his subordinate officers not below the rank as the state government may, by general or special order, prescribe in this behalf, to proceed to the spot, to investigate the facts and circumstances of the case, and, if necessary, to take measures for the discovery and arrest of the offender, provided that when information as to commission of any such offence is given against any person by name, and the case is not of a serious nature, the officer in charge of police station need not proceed in person or depute a subordinate officer to make an investigation on the spot. If it appears to the officer in charge of a police station that there is no sufficient ground for entering on an investigation, he shall not investigate the case, provided further that in relation to an offence of rape, the recording of statement of the victim shall be conducted at the residence of the victim or in the place of her choice, and as far as practicable by a woman police officer, or in the presence of her parents or guardian or near relatives or social worker of the locality, and such statement may also be recorded through any audio, video, electronic means including mobile phone. Now see, we have already discussed this in the previous sessions, that when we talk about sexual offences against women, a victim of sexual offence, so when her statement is to be recorded, first she has to be made comfortable so that she can talk and she can express all that she has suffered and all that she wants to be conveyed to the authorities very comfortably without hesitation. And that is why whenever her statement is to be recorded, it needs to be recorded in the presence of a female police officer, or it has to be actually recorded by a female officer only, and that has to be done in the presence of her parents or guardians or anyone else in whose presence she feels safe, secure and comfortable, so that she may not miss out on any important points. Further, what the law says is that such information that needs to be videographed through any audio, video, electronic means, and that could be done even through a mobile phone. So this needs to be done so that time and again we don't bother her to again repeat all that and to relive the trauma that she had suffered. So in order to put an end to all those kind of problems which used to plague a rape victim earlier, we have tried to introduce these kind of provisions, which is a very sensitive and a sensitized measure. In each of the cases mentioned in clauses A and B of the first proviso to subsection 1, the officer in charge of police station shall state in his report the reasons for not fully complying with the requirements of that subsection by him, and forward the daily diary report fortnightly to the magistrate, and in the case mentioned in clause B of the said proviso, the officer shall also forthwith notify to the informant, if any, in such manner as may be prescribed by rules made by the state government. On receipt of every information relating to the commission of an offence which is made punishable for 7 years or more, the officer in charge of police station shall, from such date as may be notified within a period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect forensic evidence in the offence, and also cause videography of the process on mobile phone or any other electronic device. So you see, all these provisions they have been now introduced. That is in case of serious offences, where the punishment that has been prescribed is 7 years or more. So in cases of offences which are punishable with imprisonment of minimum 7 years, what is to be done? If required, they will cause the forensic expert to visit the crime scene, so that forensic evidence can be collected from the crime scene itself. And then also videography has been made mandatory. Suppose recording facilities are not available, so it can be recorded on mobile phones also, so that there is no excuse, there is no escaping the fact that maximum information, that whatever can be gathered, that has to be gathered. See, that is the reason why these laws, they needed to be made tech savvy. Nowadays we can do so much over our mobile phones. That is why the law also says that you can videograph the process on mobile phone or any other electronic device. It could be a tab, it could be a camera, it could be any kind of a device. The crux of the matter is that information that needs to be collected as early as possible and as much as possible. Then, provided that where forensic facility is not available in respect of any such offence, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. So you see, we can access facilities from any other state. What we are required to do is just make a notification in this regard, that till the time we do not set up or establish our own forensic facilities, that is the facility which will be available or which will be used by us for all these matters of investigation. Then how is the report to be submitted? Every report sent to a magistrate under section 176 shall, if state government so directs, be submitted through such superior officer of police as the state government may by general or special order appoint in this behalf. And such superior officer may give such instructions to the officer in charge of the police station as he thinks fit, and shall, after recording such instructions on such report, transmit the same without delay to the magistrate. Then power to hold investigation or preliminary inquiry. The magistrate, on receiving a report under section 176 may direct an investigation, or if he thinks fit, at once proceed or depute any magistrate subordinate to him to proceed to hold a preliminary inquiry into, or otherwise to dispose of the case in the manner provided in this Sanhita. Now, police officers' power to require attendance of witness. See, witnesses are the eyes and ears of the criminal justice system. Witnesses play a very important role, and witnesses, they have to be contacted, sometimes they have to be summoned to the police station, sometimes to the courts in order to collect information from them. So, can the police officer require the attendance of a witness? Section 197 of the Sanhita says, any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself or any person being within the limits of his own or any adjoining station who, from the information given or otherwise, appears to be acquainted with the facts and circumstances of the case, and such person shall attend as so required, provided that no male person under the age of 15 years or above the age of 60 years. Earlier under CRPC it was 65 years, and now what they have made it? Any male below the age of 15 years or above the age of 60 years, or a woman, for women there is no age limit, or a mentally or physically disabled person, or a person with acute illness shall be required to attend at any place other than the place in which such person resides. So now you see, children, aged people, women, those who are suffering from any mental or physical disability, they cannot be asked to go to any place in order to give their testimony. They have to be contacted at their residence itself. But then there is a proviso that has been added to this, which says, provided further that if such person is willing to attend at the police station, such person may be permitted so to do. And the state government may, by rules made in this behalf, provide for the payment by the police officer of the reasonable expenses of every person attending under subsection 1 at any place other than his residence. So whenever the police officer, they ask anyone to come and testify in their presence, that is, come and give them certain information as to what has happened, then in such cases they are also supposed to make provision for payment of the charges that the person might have incurred during his travel or any such thing. Now coming to the proviso, which is a new provision. See, earlier, if you asked any woman or child or a person suffering from physical or mental disability to come to the police station, now that was a punishable offence. You see, it was given under 166A IPC, now which is section 199 of the BNS. It said, whoever being a public servant knowingly disobeys any direction of law which prohibits him from requiring the attendance at any place of any person for the purpose of investigating into any offence or any other matter punishable with imprisonment from 6 months to 2 years and also fine. So earlier it was a punishable offence. Now this proviso says that if the person is willing to attend at the police station, such person may be permitted so to do. Now this could open a Pandora box. See what could happen. The police officer might tell the witness, who might be a woman or an aged person, that we would require you to come to the police station. Now, maybe the woman does not know that she has a right, that if she doesn't want, she will not be called there. They would have to come and record the information at her own residence. Majority of the people, they are not acquainted with what the law is. The police officer tells them, they go to the police station. Now later on they come to know that, see, it was not mandatory for us. We could have refused to go there. Later on they might cast some allegations that, see, we were asked to report at the police station and we did not want to go there. Now the police officer says that I had given them the option, but till the time there is no clarity in this regard, till the time the party is also not told that, see, it is not mandatory if you say I will come to your house to record the information. So till the time there is a lack of legal awareness amongst our people, this proviso, although it has been introduced, but till the time the people don't know the entire law, this could be problematic. Now coming to section 180, relating to examination of witnesses by police. See, any police officer making an investigation under this chapter, or any police officer not below such rank as the state government may, by general or special order prescribed in this behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. Such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than questions the answers to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. Now this is protected under our constitution. We have the rule against self-incrimination. So no person can be compelled to give an information which has the tendency to incriminate him or which goes against him. Now, the police officer may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make a separate and true record of the statement of each such person whose statement he records, provided that statement made under this subsection may also be recorded by audio, video, electronic means, and provided further that statement of a woman against whom an offence under section 64, section 65, section 66, section 67, 68, 69, 70, 71, 74, 75, 76, 77, 78, 79 or 124 of the BNS is alleged to have been committed or attempted shall be recorded by a woman police officer or any woman officer. A woman police officer is not available. Any other female officer in any other department, she might be asked to record the statement. Here we are talking about what offences? Sexual offences such as rape, gang rape, marital rape, which renders a woman in a vegetative state, or rape on the promise of marriage, or after promising some sort of a promotion, or by concealing his identity. So all these kinds of offences. In addition to that, it could be eve teasing, molestation, stalking, voyeurism, it could be disrobing, it could be molestation, it could be and also acid attacks under section 124. Then in all these cases, like we were talking about recording of first information report, which has been made mandatorily to be recorded by a female officer. If a female police officer is available, well and good, otherwise it could be any other female officer. Similarly, recording of statements under section 180, that is also to be done mandatorily by a woman officer or by a woman police officer in cases where an offence has been committed against a woman and the woman is giving her statement and the offence is of any of the kinds as I have just elaborated upon. Then statements to police and use thereof. Section 181 of the BNSS says, no statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it, nor shall any such statement or any record thereof, whether in a police diary or otherwise, or any part of such statement or record, be used for any purpose, save as hereinafter provided, at any inquiry or trial, in respect of any offence under investigation at the time when such statement was made. Provided that when any witness is called for the prosecution in such inquiry or trial, whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved, may be used by the accused and, with the permission of the court, by the prosecution, to contradict such witness in the manner provided by section 148 of the Bharatiya Sakshya Adhiniyam. And when any part of such statement is so used, any part thereof may also be used in the re-examination of such witness, but for the purpose only of explaining any matter referred to in his cross-examination. And nothing in this section shall be deemed to apply to any statement falling within the provisions of clause 1 of section 26 of the Bharatiya Sakshya Adhiniyam, or to affect the provisions of section 23 of that Adhiniyam. Now the explanation further clarifies, an omission to state a fact or circumstance in the statement referred to in subsection 1 may amount to contradiction if the same appears to be significant and otherwise relevant, having regard to the context in which such omission occurs, and whether any omission amounts to a contradiction in the particular context shall be a question of fact. So if it is a question of fact, it is something which would be decided on the basis of facts and circumstances in each and every case. So it has to be contextualized and the decision has to be taken in regards to any particular context. Then section 182 puts an embargo that no inducement is to be offered. What it says, no police officer or other person in authority shall offer or make or cause to be offered or made any such inducement, threat or promise as is mentioned in section 22 of the Bharatiya Sakshya Adhiniyam 2023. But no police officer or other person shall prevent by any caution or otherwise any person from making, in the course of any investigation under this chapter, any statement which he may be disposed to make of his own free will. So you see, a person should be free to say what a person wants to say. I mean, if we are asking any information, so you cannot pressurize them to say something which they don't want to say. Similarly, if they want to say something, we cannot stop them from saying that thing. See, further it says, nothing in this subsection shall affect the provisions of subsection 4 of section 183. Now let us see what section 183 says. Recording of confessions and statements. Any magistrate of the district in which the information about commission of any offence has been registered may, whether or not he has jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter or under any other law for the time being in force or at any time afterwards, but before the commencement of the inquiry or trial, provided that any confession or statement made under this subsection may also be recorded by audio, video, electronic means in the presence of the advocate of the person accused of an offence. Then the magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession, and that if he does so, it may be used as evidence against him, and the magistrate shall not record any such confession unless, upon questioning the person making it, he has reason to believe that it is being made voluntarily. So you see, this is a duty that has been now put on the magistrate, and he is duty bound to tell the person that, see, you are not bound to make the statement, and if you make that statement, it has to be made voluntarily. There should be no pressure of any kind on you to either make it or to withhold any kind of information. If at any time before the confession is recorded, the person appearing before the magistrate states that he is not willing to make the confession, the magistrate shall not authorize the detention of such person in police custody. Any such confession shall be recorded in the manner provided in section 316 for recording the examination of an accused person, and shall be signed by the person making the confession, and the magistrate shall make a memorandum at the foot of such record to the following effect. So what is to be done is, the statement has to be recorded, the person has to put his signatures, and thereafter the magistrate has to make a memorandum at the foot of that statement. What would be the text of the memorandum? It says, the magistrate will have to make it. I have explained to name, here name would be of the one who is making the statement, that he is not bound to make a confession, and that if he does so, any confession he may make may be used as evidence against him. And I believe that this confession was voluntarily made. It was taken in my presence and hearing, and was read over to the person making it and admitted by him to be correct, and it contains a full and true account of the statement made by him, and then it has to be signed by the magistrate. So what is the relevance of making such a memorandum below the confessional statement? Because when a magistrate says so, that, see, I have explained that it is not mandatory for the person to make a statement, and I have also ascertained from him duly that there is no pressure that has been exerted on him to either make such statement or to withhold any information, and I am satisfied that this information has been made voluntarily. Thereafter, what happens? That this confession, it becomes a good piece of evidence, and it can be relied upon by the courts. A confession which is made to a police officer has no relevance in the eyes of law, but a confessional statement which has been made to a magistrate after duly explaining to him that, see, it might go against you, you are not bound to make such a statement. Despite that, if a person voluntarily wants to divulge such information, that would be acceptable in the courts. Then, any statement other than a confession made under subsection 1 shall be recorded in such manner hereinafter provided for the recording of evidence as is, in the opinion of the magistrate, best fitted to the circumstances of the case, and the magistrate shall have power to administer oath to the person whose statement is so recorded. In cases punishable under section 64, 65, 66, 67, 68, 69, 70, 71, 74, 75, 76, 77, 78, 79 or 124 of the BNS, here again we are talking about sexual offences and acid attack, the magistrate shall record the statement of the person against whom the offence has been committed in the manner specified in subsection 5 as soon as the commission of the offence is brought to the notice of the police. So you see, when we are recording the statement of a person, of a woman who is a victim of acid attack, who is a victim of any sexual assault or rape, then it has to be recorded in the manner as is specified in subsection 5 immediately after the commission of the offence, and provided that such statement shall, as far as practicable, be recorded by a woman magistrate and in her absence by a male magistrate in the presence of a woman. So all these conditions, they have been introduced to make a woman feel comfortable so that she can fairly, frankly, without her withholding any important or significant piece of evidence, she can actually narrate what all had happened against her. Provided further that in cases relating to offences punishable with imprisonment for 10 years or more, or with imprisonment for life or with death, the magistrate shall record the statement of witness brought before him by the police officer. So you see, in serious offences where the punishment that is prescribed is 10 years or more, life imprisonment, death, then in such cases the statement of the witness has to be recorded by a magistrate. Then provided also that if the person making the statement is temporarily or permanently mentally or physically disabled, then the magistrate shall take the assistance of an interpreter or a special educator in recording the statement. So all these are new provisions in our Bharatiya Nagarik Suraksha Sanhita. Provided also that if the person making the statement is temporarily or mentally or physically disabled, the statement made by the person with the assistance of an interpreter or special educator shall, here it is mandatory, shall be recorded through audio, video, electronic means, preferably by mobile phones. A statement recorded under clause A of a person who is temporarily or permanently mentally or physically disabled shall be considered a statement in lieu of examination in chief as specified in section 142 of the Bharatiya Sakshya Adhiniyam, such that the maker of statement can be cross-examined on such statement without the need for recording the same at the time of trial. So once such a statement has been made in the presence of a magistrate, it has been made in the presence of a special educator or a translator, and it has also been videographed, then the person need not make those statements again during trial. His earlier statements would be treated as examination in chief, and directly we can go to the step of cross-examination. The magistrate recording a confession or statement under this section shall forward to the magistrate by whom the case is to be inquired into or tried. Now let us talk about confessions under section 183 BNSS through the lens of the judiciary. So what the courts have said about it. Subsection 1 of section 164 CRPC, that is the old provision, empowers any metropolitan magistrate or judicial magistrate to record any confession or statement made to him during the course of an investigation under this, irrespective of the fact whether or not he has jurisdiction in the case at any time afterwards, before the commencement of the inquiry or trial. The same provision additionally creates an embargo that no confession shall be recorded by a police officer on whom any power of a magistrate has been conferred under any law for the time being in force. So this is a statement that has to be necessarily recorded by a judicial magistrate. Then, confessions are considered highly reliable because no rational person would make an admission against his interest unless prompted by his conscience to tell the truth. Deliberate and voluntary confessions of guilt, if clearly proved, are amongst the most effectual proofs in law. This was observed by the Supreme Court in State of National Capital Territory of Delhi versus Navjot Sandhu. However, before acting on a confession, the court must be certain that it was given voluntarily, and a confession obtained through coercion, the promise of advantage, compensation or immunity, or through force, fear instilled by violence or threats of violence, cannot be used as evidence against the confession maker. So what is important in the case of confessions is the element of voluntariness. There should be no force, threat of violence, or any kind of fear, or any promise of immunity or compensation that should cause a person to give this confession. It should be given voluntarily. Now let us talk about medical examination of victim of rape. Section 84, it says, where during the stage when an offence of committing rape or attempt to commit rape is under investigation, it is proposed to get the person of the woman with whom rape is alleged or attempted to have been committed or attempted examined by a medical expert. Such examination shall be conducted by a registered medical practitioner employed in a hospital run by the government or a local authority, and in the absence of such a practitioner, by any other registered medical practitioner with the consent of such woman or of a person competent to give such consent on her behalf, and such woman shall be sent to such registered medical practitioner within 24 hours from the time of receiving the information relating to the commission of such offence. So you see, in the new BNSS we have this specified timeline. Now it doesn't say as early as possible. It has specified a deadline, that is, the woman should be sent for medical examination within 24 hours from the time of receiving the information relating to commission of the offence. See, this 24 hours is very, very crucial in order to get proper medical examination done, whether we are using forensics in this regard or other scientific techniques they are being utilized. But 24 hours after the commission of the rape, that is a very, very crucial period. Although here it is talking about 24 hours from the time of receiving the information, so that at least it can be specified that once information was received, after that no crucial time was lost. The registered medical practitioner to whom such woman is sent shall, without delay, examine her person and prepare a report of his examination giving the following particulars, namely, the name and address of the woman and of the person by whom she was brought. Second, the age of the woman. Third, the description of material taken from the person of the woman for DNA profiling. Fourth, marks of injury, if any, on the person of the woman. Fifth, general mental condition of the woman. And sixth, other material particulars in reasonable detail. The report shall state precisely the reasons for each conclusion that is arrived at, and the report shall specifically record that the consent of the woman or of the person competent to give such consent on her behalf to such examination had been obtained. See, consent of the victim is absolutely must. If she is not in a position to give consent, then someone else should be competent to consent on her behalf. Without her consent, her medical examination cannot be done. Then, the exact time of commencement and completion of the examination shall also be noted in the report. The registered medical practitioner shall, within a period of 7 days, forward the report to the investigating officer, who shall forward it to the magistrate referred to in section 193 as part of documents referred to in clause A of subsection 6 of that section. Nothing in this section shall be construed as rendering lawful any examination without the consent of the woman or of any person competent to give such consent on her behalf. Explanation: for the purposes of this section, examination and registered medical practitioner shall have the same meanings as respectively assigned to them in section 51. Now, regarding medical examination of a rape victim, that has to be done as easy as practicable, as early as practicable, but consent of the woman is very important. See, if she refuses consent, she does that at her own peril, because it is only through medical examination that vital evidence can be collected. So if the woman refuses to do so, she has to be told that, see, you are doing it at your own peril and your case would be difficult to establish before the court of law. In this regard, we have certain judgments also regarding the medical examination of rape victim. The two-finger test. It is an unconstitutional violation of right to privacy, bodily and mental integrity and dignity of rape survivor. See, this is an intrusive medical examination to determine the laxity of vaginal muscles. This is a per-vaginal examination which was done by doctors by inserting two fingers in the vagina of the woman to determine whether she was habituated to sexual intercourse or not. See, even if she was habituated to the same, that does not mean that she cannot be raped, and it would have no bearing whatsoever to the facts of case in front of the court. See, there have been judgments wherein the courts have said that these kind of statements, like she is a woman of easy virtue or she was already habituated to sexual intercourse, that would have no bearing whatsoever, because in rape trials what is important is consent. See, rape is a question of law. So if the woman has not consented to that particular act on that particular occasion, it would amount to rape. And making comments on the character of a rape victim, that is totally unwelcome and that is to be forbidden. So this two-finger test, it is actually an unconstitutional violation of the right of privacy, bodily and mental integrity and dignity of rape survivors. There was another judgment, State of Gujarat versus Ramesh Chandra Ramabhai Panchal, in which the court said that the two-finger test is an unscientific method of examination. In October 2022, the Supreme Court further reiterated the ban on the two-finger test, and the court observed the test is scientifically inaccurate, patriarchal, and an affront to the dignity of sexually assaulted women. The court further underlined that the probative value of a woman's testimony does not depend on her sexual history. The court also directed the union and state governments to ensure that medical professionals who continue to conduct the test be held guilty of misconduct. This is State of Jharkhand versus Shailendra Kumar Rai. This is a 2022 judgment by the Honorable Supreme Court of India. Now, let us go to section 87 that talks about procedure when investigation cannot be completed in 24 hours. Whenever a person is arrested and detained in custody and it appears that investigation cannot be completed within a period of 24 hours fixed by section 58, and there are grounds for believing that the accusation or information is well founded, the officer in charge of police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the diary hereinafter specified relating to the case, and shall at the same time forward the accused to such magistrate. The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15, such custody as such magistrate thinks fit for a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days. So at any time during the period of detention he can be detained, but not for a term exceeding 15 days in the whole. It could be continuous 15 days, it could be in parts, but that has to be done during the initial period of detention. Either it could be when he is detained for 40 days or 60 days out of the detention period of that 60 days or 90 days, but the term of detention would be 50 days in the whole, as the case may be, as provided in subsection 3, and if has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction. Then, the magistrate may authorize the detention of accused persons beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of accused person in custody under this subsection for a total period exceeding 90 days where the investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a term of 10 years or more, and 60 days where the investigation relates to any other offence, and on the expiry of said period of 60 days or 90 days as the case may be, the accused person shall be released on bail if he is prepared to and does furnish bail, and every person released on bail under this subsection shall be deemed to be so released under the provisions of chapter 35 for the purposes of that chapter. So this is a provision which is dealing with concept of default bail. So if investigation is not completed within the prescribed time period, the accused would, as a matter of right, be entitled to be released on bail, and this is in law popularly known as, although it is not mentioned in the statute, but it is known as default bail. Then no magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in the custody of the police. But the magistrate may extend further detention in judicial custody on production of the accused either in person or through audio-video electronic means. No magistrate of the second class, not specially empowered in this behalf by the High Court, shall authorize detention in the custody of police. For avoidance of doubts, it is hereby declared that notwithstanding the expiry of the period in subsection 3, the accused shall be detained in custody so long as he does not furnish bail. See, even if you are entitled to be released on bail, you are at least supposed to furnish the bail. Explanation 2. If any question arises whether an accused person was produced before the magistrate as required under subsection 4, the production of accused person may be proved by his signature on the order authorizing detention or by the order certified by the magistrate as to production of accused person through the audio-video electronic means as the case may be, provided that in case of a woman under 18 years of age, the detention shall be authorized to be in the custody of a remand home or recognized social institution. provided further that no person shall be detained otherwise than in police station under police custody or in prison under judicial custody or a place declared as prison by the central government or the state government. Notwithstanding anything contained in subsection 1 to subsection 5, the officer in charge of police station or the police officer making the investigation, if he is not below the rank of SI may, where a magistrate is not available, transmit to the nearest executive magistrate on whom the powers of a magistrate have been conferred a copy of entry in the diary hereinafter specified relating to the case, and shall at the same time forward the accused to such executive magistrate, and thereupon such executive magistrate may, for reasons to be recorded in writing, authorize the detention of accused person in such custody as he may think fit for a term not exceeding 7 days in the aggregate, and on the expiry of period of detention so authorized, the accused person shall be released on bail except where an order for further detention of the accused person has been made by a magistrate competent to make such order, and where an order for such further detention is made, the period during which the accused person was detained in custody under the orders made by the executive magistrate under this subsection shall be taken into account in computing the period specified in subsection 3. Provided that before the expiry of the period aforesaid, the executive magistrate shall transmit to the nearest judicial magistrate the records of the case together with a copy of the entries in the diary relating to the case which was transmitted to him by the officer in charge of the police station or the police officer making the investigation, as the case may be. Further, under subsection 7, a magistrate authorizing under this section detention in custody of the police shall record reasons for doing so. And any magistrate other than CJM making such order shall forward a copy of his order with his reasons to the CJM. If in any case triable by magistrate as summons case, the investigation is not concluded within a period of 6 months from the date on which accused was arrested, the magistrate shall make an order stopping further investigation into the offences unless the officer making the investigation satisfies the magistrate that for special reasons and in the interest of justice, the continuation of investigation beyond the period of 6 months is necessary. And where any order stopping further investigation into an offence has been made under subsection 9, the sessions judge may, if he is satisfied on an application made to him or otherwise, that further investigation into the offence ought to be made, then he may vacate the order made under subsection 9 and direct further investigation to be made into the offence subject to such directions with regard to bail and other matters as he may specify. Section 189 talks about release of accused when evidence is deficient. So, if upon an investigation under this chapter it appears to the officer in charge of police station that there is no sufficient evidence or reasonable ground of suspicion to justify the forwarding of accused to a magistrate, such officer shall, if such person in custody, release him on his executing a bond or bail bond, as the officer may direct, to appear if and when so required before a magistrate empowered to take cognizance of the offence on police report and to try the accused or commit him for trial. Then cases to be sent to magistrate when evidence is sufficient is given under section 190. 191 deals with complainant and witness not to be required to accompany police officer and not to be subject to restraint. Then a diary of the proceedings has to be mentioned under section 192. And under 193, the police officer has to submit a report on completion of investigation. So, investigation in relation to offence under these provisions, that is sexual offences, or under POCSO has to be completed within 2 months. So, they have specified this timeline for all sexual offences and POCSO. Thereafter, as soon as investigation is completed, the officer shall forward, including through electronic communication. So you see, the report is not merely to be sent in a physical form. It also needs to be sent in an electronic form. Then further, within a period of 90 days, the police officer shall inform the progress of investigation by any means, including through electronic communication, to the informant or the victim also. Okay. Then 194 contains provisions regarding police inquiry and report on suicide. Then inquiry by magistrate into cause of death is under 196. So students, we discussed provisions relating to investigation that is to be conducted whenever they receive information relating commission of cognizable offences, and when otherwise they are directed to conduct investigations in case of non-cognizable offences. So different steps relating to investigation have been discussed in this session. I hope you enjoyed this session. Thank you.
Swayam Prabha. Digital India. Educated India.
Welcome to lecture 2 of the module 1 that is on introduction aspect of this course. Now today we will be discussing on the evolution of electricity laws in this country, and in the evolution we will try to understand that how the legislative growth has taken place in India right from the beginning, and then we will discuss the salient features of 2003 Act, and then from there onwards we will move to the main discussion of this course, where we will have a discussion. We will try to understand that what are the major provisions of 2003 Act, how 2003 Act governs the power sector. Now for the study, we have divided the legislative framework in two parts. One is the development which was there in the pre-independence era, and the second one is the post-independence era. If you look at the pre-independence era, there were three legislations: Electricity Act of 1887, then there was an act in the year 1903, and then we have got an act in 1910. And then when you look at the legislations which were brought into existence after independence, we have a 1948 Act which deals with electricity supply, then 1998 Act which was of regulatory commission, and then we have this Electricity Act of 2003 which is the present law, and this law has subsumed all other earlier laws. Now when you look at the whole development of power sector in this country, you would find that initially the generation of electricity was primarily dependent upon the conventional sources, and to be very precise, hydro and thermal. Now the first supply of electricity on the commercial basis began in Darjeeling in 1897 from hydroelectric plant, and then 2 years later the urban electrification started taking place with the establishment of Calcutta Electric Supply Corporation. This corporation started generating electricity on the basis of conventional coal thermal sources, and then in the early part of the 20th century we have seen that the provinces, they started promoting hydro based electricity in this country. So in the beginning what was noticed is that along with the hydro, thermal was also one of the main sources of power generation in this country. And then we found that in order to deal with the generation of electricity, how it shall be available to common people, what shall be the framework for governing the operators who are involved in this sector. In 1887, there was a law enacted. This law was enacted primarily to address the issue of safety, because on the installation of electric lighting at the Crawford Market in Bombay, there was a need felt that we must have a legal protection from any kind of injury or risk arising from electric connection, electric sources, and therefore a law was enacted to protect person or property. And moving further from there, there was 1903 Act was enacted, because then the commercial use of electricity started taking place, and therefore need was felt to regulate the sector in a much better way. And thus the 1903 Act, which repealed 1887 Act, started acknowledging the presence of the generating units, and then in a very rubric way it started regulating the sector. But at the same time, 1903 law did not recognize the bulk sale of electricity. So that way the commercialization was not yet either considered to be a fit subject to be dealt under the law, and also along with that there was an issue with the jurisdictional conflict between the local government and the government of India, that who shall have what kind of jurisdictional power on the governance of this sector. And then in order to address this issue, 1910 a new law was enacted, obviously repealing the 1903 Act, and this law can very well be said to be the first law which attempted to regulate the players of the sector, particularly what shall be the way to give the license, what shall be the area of operation, what shall be the norms of transmission business, and if the licensee breaches the terms and conditions of the law set, or at any point of time goes against the public interest, then the power was given to the government to revoke the license. So 1910 law introduced license for bulk supply of electricity, and that is about generating company producing electricity to supply in large quantities and giving it to the licensees, so that licensees can sell it in the retail market under a separate license to the retail consumers. So 1910 Act formally gave the legal framework to standardize the licensing process and to also provide for rights and obligations of the licensee. Because prior to that, as I said, that the commercialization was not envisaged or intended, and therefore
the attempt was to deal with the issues in a very piecemeal manner. But one for 1910 Act, it dealt with supply and use of electrical energy in a comprehensive manner, whereby necessary legal mechanism was developed that who shall be allowed to be a licensee, and in this regard you find that 1910 Act acknowledges the participation of both private and public operators. In fact, it was more of a private participation which initiated the very need of having a legal framework to deal the sector. And it was categorically laid down under 1910 Act that licensee shall provide same terms and condition within the area of supply. They cannot have a discriminatory policy. And in fact, it has also been provided that if other licensee attempts to enter the market and start supplying the electricity where already license has been given to other operator, then that licensee has to give a defined sum to the licensee who has been authorized to supply electricity in that area. So, in a way the law has made an attempt to see that the licensee should not incur loss because of the change of the supplier of electricity. And as I said that commercialization of the generation of electricity, of the distribution of electricity started taking place, and therefore this law was enacted. Obviously, the law also addressed the issues of safety and technical functionality involved in the operation of the sector, and which certainly involves that how there shall be laying of wires and the related works, what shall be the mechanism to obtain the permission from the competent authorities, so that there shall not be any undue obstruction in supplying of electricity to the end consumer. And this act attempted to improve the accessibility of electricity. And one way of doing so was to provide for a non-discriminatory tariff, where it was suggested that the licensee should expect a reasonable return on the investment, but at the same time it shouldn't be leading to a sort of undue demand from the consumer. Though the law did not attempt for any tariff setting, but then certainly provided a sort of a statutory mandate to not to have discriminatory tariff practice between the end consumers. This 1910 Act which primarily deals with the licensing aspect of electricity sector, was seen not as a foolproof law to expand the reach of electricity to different parts of the country, and also after India got the independence, there was a need felt to expedite the economic growth, and for the economic growth there was requirement of electricity. There was need of drawing a balance between the resource rich states and the resource starved states, and thus right after gaining the independence, a law was enacted in the year 1948, whereby the earlier scheme of supply and use of electricity in a limited area was considered to be of archaic nature, and then it was suggested that let the government get involved in expanding the supply and use of electricity. So, what was earlier within the limit of cantonment area, within the limit of municipality under 1910 Act, was done away with under 1948 Act. So, Electricity Supply Act of 1948 brought into existence with multiple aims in mind, and one, as I said, to widen the reach of electricity so that benefit of this important commodity made available to rural and semi-urban areas, and that too in well coordinated manner by ensuring the efficiency in the sector. Now, in order to expand the availability of electricity in every region, there was a need felt to have a coordinated development of the sector, and thus this 1948 Act brought into the scheme of grid system, where one generating unit committing to supply electricity to not only nearby areas but far-flung areas also, including in the neighboring states, and that is what was attempted to be done through 48 Act. Now, the most prominent introduction, most prominent reform which has been done through 48 Act was the establishment of two important institutions, one at the state level and the other at the central level. And as I said in the last lecture that electricity falls in the concurrent list, and therefore both the state and the center enjoy jurisdiction over the subject. and Electricity Supply Act is a central legislation the central legislation was enacted with an aim to have a very coherent, coordinated development and growth of electric sector throughout the country. So, in order to provide necessary impetus to the sector, it was realized that along with enhancing the generating capacity, there is a dire need to bring in necessary infrastructural improvement in the transmission as well as distribution sector. And to fulfill this goal, electricity boards, state electricity boards was created in every state. The law provided that every state shall have this state electricity boards. The law also said that if any state decides to not to create the board, it can very well authorize the board of the neighboring state to carry out the function under the law. So, the board was established as an autonomous body which was given the responsibility to develop and to operate all the three segments of the sector: generation, transmission and distribution. And obviously, it was suggested that the board needs to ensure that it is being done in a very efficient and economical way. And board was also given this task of providing electricity in across the region, not only limited to the cities which were featured during colonial rule. And this is important. This is important for us to understand that why this very objective of taking the supply of electricity to semi-urban and rural areas, and that relates to the very argument which I was making in the last class on right-based understanding on access to electricity. That it was rightly thought that it is not only about the paying capacity and the responsibility to provide infrastructure in limited geographical boundary. Electricity is one commodity which must be seen not only from commercial perspective, but also to be seen from public perspective, where public element is also involved. It is not only about the commerce. Obviously, this may be a point of debate and deliberation that how to balance these two, because at the end of the day, generation involves cost. It is a cost intensive industry. So, how do we balance that interest of recovering the cost and also getting minimum profit on the one hand and serving the public interest on the other hand. Obviously, we will be discussing all this as the course progresses. Now, along with state electricity boards, which was envisaged to be there in every state with a responsibility to develop the sector, the law also provided for the establishment of Central Electricity Authority. And what was the responsibility of this authority? To develop a national plan and to formulate a national power policy, and to monitor the growth of the industry and report it to the legislature. Why reporting it to the legislature? Because of the very fact that the representative of the people must seek the accountability from the executive that how the mandate of the law is being carried out. And that's why we find that in many laws we do have this kind of provisions where regulatory bodies are required to prepare a report and place it on the floor of the House. The Electricity Authority was also entrusted with the responsibility to provide technical details, because with the improvement in the technology, there was need to upgrade the utilities, and at the same time necessary safeguards are to be adopted to ensure safety of the people, and that's why this body was being asked to provide the necessary technical assistance. Along with that, it was also expected that the authority will be trained as an arbitrator when the dispute arises between the state or the board or the licensees. But then, as the law has suggested that it was supposed to be a advisory body. Now, 1948, when this act was enacted, it was very much kept in mind that how we can augment the generating capacities and improve the other segments of the power sector to ensure quality supply of electricity. And furthering this aim, in 1956, there was a policy, industrial policy adopted by the government, wherein it was stated that the generation and distribution of electricity should almost be exclusive interest for the states. So you can very well find it out at this stage that we do have a positioning where monopoly of the state was introduced, and we, without disturbing those private entities which are already involved in the sector. This was very much in the line of the global practice at that point of time, because it was generally been thought that electricity is one such sector where it should be largely be under the control of the government. Now, as the time progressed, there was an assessment done on the functioning of the electricity boards, and on the basis of that, it was found that the electricity boards are not in a position to meet the demand of the market, and thus an amendment was introduced in the year 1976, whereby central government and state governments were being authorized to set up generating companies. And in fact, state-owned generating companies was constituting majority of the stake in the market in the sector. So what has happened is that electricity boards, they emerged as a vertically integrated entity. Whereby all the three segments of the sector, generation, transmission and distribution, fall under the sole responsibility of the electricity board. So electricity board became all powerful. All powerful in terms of controlling this sector and also in deciding the availability and accessibility to different reasons. Now, this very control of SEB did not improve the performance of the sector. In fact, it became a liability. It became a liability because of poor financial condition, because of mismanagement, because of other allied factors, because during that time the country started experimenting with green revolution and there was demand of supply of electricity in rural areas for irrigation purposes, and in order to meet that need, the government decided to charge a flat rate from the farmers, and we certainly made a dent on the revenue generation capacity of the board. Thank you very much for attending this session.
Hi, I'm Ch-26 Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP. You have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So the WHO went with a 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables, more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender and by your weight. So apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So, if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator, which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth, or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age, and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol, like total cholesterol, good cholesterol, and your incidence of getting high cholesterol. Now, after this, we went in for a policy implication, and in the policy implication, we tried to find two policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average, 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP, and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure, and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP, and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices, because it has an impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators. And it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day. But fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.
Hello and welcome to this piece of literary snippet. British humour doesn't have a very high standing in the world. When people talk about it, they usually do so with a certain degree of disparagement. Yet all this is, I think, rather unfortunate, because if I read out to you a certain section from Jerome K. Jerome's famous novel Three Men in a Boat, you will realize that not only is British humor genuinely funny, it is probably even better than some of the other samples of humorous writings that you might have read in the recent past. The story that I'm going to read out is told by Jerome, who thinks he is suffering from some kind of a malady. I remember going to the British Museum one day to read up the treatment for some slight ailment of which I had a touch. Hay fever, I fancy it was. I got down the book and read all I came to read. And then, in an unthinking moment, I idly turned the leaves and began to indolently study diseases generally. I forgot which was the first distemper I plunged into, some fearful, devastating scourge, I know. And before I had glanced half down the list of premonitory symptoms, it was borne in upon me that I had fairly got it. I sat for a while, frozen with horror, and then in the listlessness of despair, I again turned over the pages. I came to typhoid fever, read the symptoms, discovered that I had typhoid fever. Must have had it for months without knowing it. Wondered what else I had got. Turned up St. Vitus's dance. Found, as I expected, that I had that too. Began to get interested in my case and determined to sift it to the bottom, and so started alphabetically. Read up ague and learned that I was sickening from it, and that the acute stage would commence in about another fortnight. Bright's disease, I was relieved to find, I had only in a modified form. And so far as that was concerned, I might live for years. Cholera I had with severe complications, and diphtheria I seem to have been born with. I plodded conscientiously through the 26 letters, and the only malady I could conclude I had not got was housemaid's knee. I felt rather hurt about this at first. It seemed somehow to be a sort of slight. Why hadn't I got housemaid's knee? Why this invidious reservation? After a while, however, less grasping feelings prevailed. I reflected that I had every other known malady in the pharmacology, and I grew less selfish and determined to do without housemaid's knee. Gout, in its most malignant stage, it would appear, had seized me without my being aware of it. And zymosis. I had zymosis evidently from boyhood. There were no more diseases after zymosis, so I concluded there was nothing else the matter with me. I sat and pondered. I thought, what an interesting case I must be from a medical point of view. What an acquisition I should be to a class. Students would have no need to walk the hospitals if they had me. I was a hospital in myself. All they need to do would be to walk round me and after that take the diploma. Then I wondered how long I had to live. I tried to examine myself. I felt my pulse. I could not at first feel any pulse at all. Then all of a sudden it seemed to start off. I pulled out my watch and timed it. I made it 147 to a minute. I tried to feel my heart. I could not feel my heart. It had been beating, but now it had stopped beating. I have since been induced to come to the opinion that it must have been there all the time and must have been beating, but I cannot account for it. I patted myself all over my front, from what I call my waist up to my head, and I went a bit around each side and a little way up the back. But I could not feel or hear anything. I tried to look at my tongue. I stuck it out as far as ever it would go, and I shut one eye and tried to examine it with the other. I could only see the tip, and the only thing that I could gain from that was to feel more certain than before that I had scarlet fever. I had walked into the reading room a happy, healthy man. I crawled out a decrepit wreck. Our friend next visited a doctor, and there he got a prescription which said to eat well, to go for long walks, and not to worry his heads over things he didn't understand. See you in the next episode of Literary Snippets.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. I'm here to tell you a little bit about how we can think about globalization in a sociological manner. Now, one of the important concepts in the field of globalization, and particularly global studies, is that of global flows. It's a term that was developed by the sociologist and anthropologist Arjun Appadurai. He said that as the world is becoming a more and more global place, you increasingly see the movement of different types of things, both tangible and non-tangible, across multiple national borders. To begin with, you can look at how your day proceeds. I often need a cup of tea to actually start my day. Now, if you think about it, tea that we drink is not something that is that originated in India. It's actually a drink that comes to us from quite far away in China. And this is something that has happened not immediately, but it has happened 400 or 500 years ago. So this kind of movement actually happened with the movement of people. Now, this kind of movement of people and goods is one category of flows that Appadurai talks about. A second category of flows could be financial flows. And a good way to think about this is the kind of volatility that you can see in economic markets today. For instance, in 2008, the whole world experienced a very serious economic jolt. Developments in the country of Iceland had a huge repercussion across many, many countries in the world. Now that gives you an indication of the kind of financial flows that are a part of globalization. So we're not only talking about money flowing from place to place, but also financial decisions made in one place having an impact on other parts of the world. Appadurai also argues that there is a third category of flows which he refers to as the flow of images or media. Now this is something that I'm sure you're quite used to. Much of the programming that you watch on television today, for instance, you may actually be watching channels that have originated or programming that's originated elsewhere. More than that, it could also be that the programming that you see today is influenced by shows that have originated abroad. Similarly, you can have content that was made in India, which makes its way to other places in the world. For instance, we know that Bollywood films are extremely popular in many countries across Africa. So this kind of movement of media is, Appadurai considers it to be an important part of globalization. The fourth category that he talks about is the movement of ideas. So this means that ideas that are popular in one part of the world are not restricted to that part alone, but they actually travel across borders. So for instance, something that you may read about in the papers would be, say, events such as gay pride events. Now, gay pride events have their origin in places like New York. But the idea that there should be equality between people, irrespective of what their sexual preference is, that is an idea that has now become popular across the world. And so that's the fourth category of flows that he referred to. The fifth category of flows that Appadurai talks about is that of technology. An easy way to think about this is, let's say tomorrow there is news announced that Apple is going to release iPhone 7. As you can anticipate, there is going to be a lot of excitement in many parts of the world, and people are going to start queuing up, waiting for those products to actually come to their country. So, technology is something that is quite exciting and really moves across various national borders.
Swayam Prabha, Digital India, Educated India.
So hello dear friends, so welcome again to NPTEL online certification course on logistics and supply chain management. So I am Dr. Vikas Thakur, Assistant Professor, Department of Humanities and Social Sciences, IIT Kharagpur. So in the first lecture we discussed about the basic concepts related to logistics, and then what are the different elements in the logistics, right? And we try to we try to relate and we try to differentiate as well the logistics versus supply chain management. So today we'll continue. Next is the stakeholders in logistics, right? So this is all the elements and stakeholders included in the logistics. So you can see here, if we'll start with the one end where our suppliers are there. So this is not only the one layer of suppliers, right? Like I discussed about the very basic example from where we are getting the raw material for baking the bread, and then we ended up with the with one organization who is extracting ore from the core and maybe some mining industry, right? From where we are getting the steel, and then that steel is used as buyer in the tire manufacturing, and we are getting rubber, and we are getting all other engines and other kind of components we are using in the tractor, right? And so this is completely, if we'll say, so different, so many layers are there. So suppliers of suppliers are there in the logistics network, right? So from these suppliers, we need to actually we need to negotiate with these suppliers related to the product, related to the quantity, related to the price, related to the delivery, right? So these all functions are there when we are dealing with the suppliers, right? So as a manufacturing unit, I need to ensure that there are sufficient number of suppliers for supplying these different type of components. Now there is always debate is going on whether we should focus on single supplier versus multi suppliers. So basically but my personal opinion is, if we are going for too many suppliers for the same component, then also this is a problem. If we are focusing only on one supplier, then also there is a problem. So we'll discuss this in detail, but for now, if we are focusing on only single supplier, so let's say something goes wrong with that supplier. It's not only some disaster is happening, natural or man-made, sometime maybe the equipment are not working, sometime maybe there is strike, sometime different issues can be there. And if we are just relying on the simple very single supplier, so then there will be problem, right? Our raw material supply will be interrupted. So in that case, I should advise that we should have 2-3 vendors or 4 vendors depending upon the criticality of the raw material. If that raw material frequently facing some problem, issues related to quality, related to delivery, or maybe the raw material used for making that component is not readily available, or other issues are there. So maybe that number can increase to 5 to 7. But again, too many vendors, it's very difficult to retain all those vendors for a longer period of time. The first point is whether you are able to give them large number of orders, because if order quantity is also less, how you will negotiate with respect to price. If that quantity is not there, obviously they will not be able to target economies of scale. So obviously they will be least interested doing business with the kind of organization which is not feeding them large orders, right? So these are some of the issues with multi vendors. But then there are pros and cons. We'll discuss in detail in the later sessions, right? So this is, you need to maintain a relationship with the suppliers as a logistics partner. Then procurement. Then procurement obviously will happen with the suppliers. This is a process where you will be negotiating with respect to your order quantity, order frequency, volume and price, right? And then this is supplied to manufacturer, where the final assembly of your final product is happening. This is a kind of production line, you can say, or assembly line, where we are usually converting our raw material into FGs, finished goods. Okay, so as a manufacturer, this is not only one, again, like we have multi layers in suppliers, we can be having multi layers in manufacturer as well. There may be co-manufacturer, there may be manufacturer who are preparing sub assemblies for that, right? So let's say if I'm manufacturing any home appliances, right? Home appliances, let's say we are manufacturing AC. So we are manufacturing AC, so but we are not very good with the handling of electronic component, whatever motherboard we are inserting inside, programmable control array we are inserting inside, or electronic components whatever we are using inside, right? So because we are not good with that soldering process, embedding those electronic components on the board, so what we can do is we can outsource this to some co-manufacturer, and that will be producing the sub-assembly and will be giving one motherboard which we will be placing or fixing in the final casing of that AC, right? So there can be so many manufacturers in this. Finally, this is that beautiful thing for which we all are fighting, and we are struggling day and night and making this beautiful thing happen and readily available for the customers. So this product, again, how you are designing the features, so obviously that information is also coming from your logistics partner. depending upon the customer preferences. Then inventory you need to keep so that you can ensure the continuous supply to the market. Now this supply to market obviously depends upon demand as well. So somewhere you need to make the equilibrium between demand and supply, and because always there is gap, so you need to maintain the inventory. So although we are focusing on zero inventory, but yes, that is something is a big question, and where we can focus for zero inventory specifically, so that also we will discuss. Now the other player in the logistics management is your retail industry. Now Indian retail or other retail industry, foreign retail industry also, it's not always we are getting the organized retail sector, right? So we have organized retail industry as well, and we have the fragmented retail industry, small shops are there, right? So as a logistics partner, it is not important only that you are supplying to organized retail industry, because they are the major players carrying the maximum share. Indian market, they are not carrying the maximum share, because maximum share is taken by the fragmented retail shops, right? So but yes, you need to meet the demand of the both, right? Whether you are going for a local shop, through local shop, or you are going through some organized store. So multi-brand store, one-stop solution market kind of things are there. So next important thing which is contributing around 50 to 55% to your cost is your transportation. And when we will talk about transportation in detail, so we will be talking about different modes of transportation, whether you are going through air, whether you are going through road, or you are going through ship, or you are going through train, right? All these modes you will pick depending upon, first is availability of infrastructure. Then if all are available, then you will see ship is maybe efficient economically, maybe train is efficient economically, but then you need to have that much infrastructure, right? You need to ensure the delivery also, fast delivery. So then if you are talking about same day delivery, something air, which is very expensive, can be expensive, so you have to go by air as well. And road, because this is taking the maximum share, but it is not efficient. It is not efficient because of the two reasons, because the distance we are covering, obviously the fuel cost and all that if we will consider, that is also very high. But the other thing which is major point is, while we are going through road transportation, there are so many delays. There are so many planned, unplanned delays. We are depending upon the road condition, accidents are happening, weather conditions, and then there is for documentation or clearing the boundaries from one state to other state, all those documents you need to maybe tax structure and all that, very rigid tax structure is there. So you might have seen long queues of trucks standing on the border, right? So just waiting for clearance. So this road transportation, since taking the maximum share, but so many challenges are there as far as this transportation mode is concerned. Talking about distribution network, already I told you, whether you want your customer should visit to your retail shop, or you want to deliver your product directly to the customer doorstep. That is up to you, which model you are offering, which model your industry is offering. You have to be competitive in that way, so you have to take that way. So talking about these small terms, already I have discussed. Quickly we'll go through order placement, which customer will place the order, right, for goods or services highlighted on your website, your portal, or whatever interactive medium platform you are provided to the customer. Order is processed. As a seller, you will record the order and you will start processing the order. Then inventory management, obviously to avoid the stock out rate, and also the excess inventory is also avoided, right? And then whenever you are reaching that, let's say this is the inventory level, and then you start depleting your inventory because you are meeting the demand. So inventory will start depleting. So you need to decide which one is the safety stock. At this safety stock, again you need to place the order and you need to replenish the inventory at this level. So again inventory will start depleting. So then that means again you need to replenish this. So this cycle will keep on going, right? And will ensure that inventory is always there to meet the either your expected demand or unexpected demand. Warehousing is another very important element. Why I am saying, and because it is strategic location we are defining. How many warehouses should be there, right? So because we are storing that, and the other concept is we should locate warehouses maybe near to our final customer, so that we can easily and speedily deliver the end the product to the end customer, right? But then again, the efficiency is one part if we have so many different facilities. So cost will be there. In warehouses, instead of one, we have 5 warehouses. So obviously that much manpower is required. Obviously those many instruments are required. That much infrastructure is required. And obviously inventory level will also increase, because instead of maintaining inventory at one level, now we are maintaining inventory at 5 different locations. And why this is strategic location? Once you start investing into this kind of decision, this is a long-term decision. You cannot withdraw overnight, right? Because this includes huge investment is there in terms of when you are making investment into your fixed assets. Then picking and packing, obviously your order will be picked from the inventory and your distributing partner will be distributing to the end customer. So transportation of packed orders from warehouses to the destination will be ensured. And again, as I told you, mode of transportation are important. So delivery, that depends upon whether you are going for last mile delivery or customers are visiting your location, right? So as per whatever customers are recording their addresses, so usually you might have seen when we are going on Amazon website or Flipkart, so you can quickly check the availability, whether that availability is there in your pin code or not, right? So that is another service point which is being evaluated for any e-commerce player, whether you are giving your services in that area or not, right? So obviously they are trying to cover up as many pin codes as possible, but yes, so this is not one day game. So when these e-commerce websites they started operating in India, so firstly they started collaborating with the other players which are traditionally not into this kind of business, but they have the network, like Indian Post Office, because Indian Post Office is a kind of delivery, can be a kind of delivery partner which is having office in almost all the pin codes. They are covering all the pin codes, right? So if you want the delivery to every end customer, so then obviously the best maybe strategic decision, maybe you can collaborate. But then how much control you have, speed, quality, those all things are there. So these all e-commerce players, they started developing their own network, distribution network, right? So then order tracking is something. Now if you go for Indian postal services, they are also providing you tracking ID. Earlier it was not there, but now you can also track that. But you just imagine the tracking speed or the information provided with the Amazon or Flipkart or eBay or Mantra, any e-commerce player, or Zomato, when you are using your daily items from there, right? So though that much level you cannot expect from the very traditional kind of speed post services or the normal maybe post services, right? So order tracking is something these days is very important. The customers are just clicking the order, placing the order, and they just want to get the information whether the order has been accepted, whether the order has been processed, dispatched, if dispatched, where it is right now, because as a customer we have limited time and we are keeping the things for the last hour, and then for last hour only who are giving us all those services and making all those promises that will deliver you within 30 minutes, will go for only those players, right? And then customer service, I talked about all the services which are providing the product or services to your doorstep, but this is something after sales returns. So returns can happen because of 2-3 reasons. First is you simply did not like the product, and then again one click and you are sending it back. So this is a big challenge for us, but yes, with one click you can send it back. Another thing is, if the product is not functioning properly, so it is under warranty guarantee period, again we need to provide the spare parts, we need to pick the product, we need to repair the product, or maybe the engineer is visiting the customer site, right? Or the third thing is, which is leading towards sustainability. So what is happening, in the end stage of life. So end of life, what you are doing with that product. If you are promising something with the customer, at the end stage we will take your product, will be compensated in somewhere maybe, right? Or we will try to maybe again renovate that product, we will try to, because any product life, if you talk about AC, if you talk about refrigerator you are using, if you talk about fan, if you talk about all those appliances you are using, only majorly 3, 4, 5 components are there depending upon the product, which are age limited, right? Rest, if you talk about all other components, screw inside you are using, you can use for years together. The casing, body, plastic parts you are using, you can use years together. The wire you are using year to. So the only limited age product components you need to identify. Maybe the motor of the that appliances or whatever product you are using, maybe the capacitor, maybe the other very crucial components, right? So how you can extend the life of those components, or maybe you can simply replace those products who are failing because of their age. So you can simply replace those many components, may not be, again we can apply 80-20 rule. So those 20% of the components you can easily replace. Then feedback and improvement, you might have seen after every packet we are delivering to you. So again customers are being asked whether the delivery was okay, whether you were served the hot food, quality of food, all those things. Even if I am not responsible for the food quality, even then I will be rated for that, right? So that is something, some parameters are beyond control. But if I am taking only this as a logistic partner, right? If I am only the logistics means a delivery partner, right? If I am taking it this as complete system, so that complete feedback is important, right? So now the logistics management, if we'll talk about, it is the planning, implementation and control of the movement and storage of goods, services and related information. Already we discussed about it. And when we are talking about the movement, it should be efficient and effective flow of material. We have to ensure the smooth supply, right? And then it entails strategizing, executing and overseeing the flow and storage of goods and services and related information across the supply chain. So obviously in the end, once the system is set up, then we'll go for the optimization of this movement of goods or the flow of information, whatever we are capturing through that network. So logistics management plays a pivotal role in maintaining the seamless operation of supply chains and empowering business to attain their operational and strategic goals, right? So if quickly we'll talk about the advantages if we are managing our logistics effectively. First is efficiency. Obviously efficiency will be improved because we will, if we have proper planning, we have the plan A, plan B, plan C, we can reduce the impact of the interruptions. That interruptions can be in terms of disaster, natural disaster, floods, earthquakes, can be anything, or maybe man-made disasters like, or maybe shutdowns, right, because of recent COVID-19 pandemic. So those all things we can manage efficiently if we have that strong network of suppliers, manufacturers and the next stakeholders, delivery partners. So we can always reach to our customer efficiently. Cost reduction, obviously if I can optimize the transportation route, so best route as per traffic, best route as per distance, right, as per road condition as well. So if I'll pick the best route, obviously I will be cost efficient, I'll be saving time as well during the transportation. Then obviously warehouse operation and inventory levels. This warehouse operation and inventory levels, we'll discuss in detail about this, but now we are going towards where these warehouses will be totally man-free. There will be no human being involved in the warehouse operation. Robots will be working, will be maintaining the inventory, will be updating the inventory. So in that way we can utilize the maximum space within the warehouse, because that only space will be left out, the minimum space for the movement of those robots, right? Or we have the lifts, automatic lifts, right? So those we can use and we can reduce the cost, manpower cost as well. And 24/7 those machines can work. Obviously, customer satisfaction, if they are manually we are handling the products, we may damage the products, right? Always we are not able to take the precautions, right? If electronic components sometimes we are handling or fragile components we are handling, we may break. So that happens in the inventory also. This comes under material handling cost, where we are damaging, while handling we are damaging the products as well, right? So that is also cost, and sometimes these damaged products are finally shipped to the end customer. So then there is a big question for customer satisfaction, right? So with that quality of product, timely delivery of the goods, so efficient logistics management will lead to your customer satisfaction, and obviously if they are satisfied, they will be loyal customers to us and will help us providing the competitive edge over the others, because we are superior in terms of providing the services, we are providing the fastest delivery possible, and we are also very efficient, right? So these are some of the advantages. Then risk management, if we have the proper planning, logistics management, we have inventory in the warehouses, so that risk of stockouts we can avoid. Transportation delay, if raw material is coming on the way, something goes wrong, right? So even we have that safety stock, we can still continue the production line. We don't want that 500 workers who are working on that one production line, they will just sit idle just because of we are not having one screw, or maybe we are not having the other component, glass we are using inside the car, steering wheel we are not having, or gearbox we are not having. Maybe the component is very small, but until we will plug that component in the final product, we cannot say that this is finished, right? And if it is a kind of product kind of layout is there, so if let's say we are falling short of inventory at 15th stage, so all the stages after 15th stage will be interrupted, because if we will not perform that operation, we cannot go for the next one, because all other are depending on the preceding one. So that way also we can avoid the risk. And then resource optimization, will go for proper management, we can resources in terms of vehicles, because now we have proper routing plans, so we can optimize the vehicles in the proper way. Warehouse space we can manage, we have automation kind of system. Manpower we can optimize, these resources we can optimize efficiently and profitability. So the next point is market expansion. So market expansion is one thing, if you are going for your product, is only possible when you have logistics distribution network up to that market. This is as simple as that. If you don't have shop to the end point, there is no point of expanding the market or maybe advertising your product to that particular market, because those people don't have the access to your product. So first, to advertise that product in a particular area, you should have your distribution network. That's why so many collaboration in India also happened, just because of foreign companies, they came here, they wanted to set up their manufacturing hubs here, but because because huge network is required to distributing the product to the end customer, that's why the reason is the collaboration between Hero Honda, Maruti Suzuki. So Honda was very good with the technology in two-wheelers. Hero already, they were into Hero cycles, so they were having vast network to cover almost all regions in India. So Honda thought it's good opportunity, we can collaborate with Hero, we can just exploit their or utilize their distribution network. So this is how you can go for the market expansion. So then comes the part of logistics designing and management. So again, when we are saying designing and management, so obviously we need to take care of the first stakeholder, who are suppliers. How many suppliers you want is the first point. Then how many manufacturing plants will be there. Let's say we are having 2 manufacturing plants. Now maybe the same model, whatever model M1 we are manufacturing here, we are manufacturing M1 here as well, right? So whatever raw material for M1 is required, let's say this raw material is coming from supplier 1. So this raw material will go to from supplier 1 will go to your plant 2 as well, right? So that means you need to design the distribution network, you need to take care of your the first two stakeholder, first is your supplier, and which supplier is going to supply which plant. Plant means the manufacturing facility. Once you are ready with your finished goods, now they are ready to be shipped. So here you are loading those final product, and now they are ready to ship to the final destination, and final destinations are your warehouses. Now again, this distance how you will cover is important, right? This distance, which mode you will pick to cover this distance will define your cost function, your quality, your speed, everything we discussed earlier. So now these are the warehouses. Again, because strategic location we have done for deciding the warehouse facilities, and not only the location but also the capacity of that warehouse, because again we want to utilize the maximum capacity. So maximum capacity utilization we need to ensure, right? So what is the customer potential in the different markets? Depending upon that, we will assign that these location will be served using this warehouse, right? So this is overall distribution network, but again we have separate session on designing distribution network. We will take care of all the elements in that, right? So logistics design and management again involves the strategic planning, coordination and execution of various processes within the supply chain to ensure the efficient flow of goods, information and resources from the point of origin to the point of consumption. It encompasses the activities such as inventory management, warehousing, transportation, order processing and distribution. So effective logistics design we will say only when we are able to minimize the cost, customer satisfaction is maximized, and we are taking care of the sustainability parameter, and we can mitigate all the risks, right, on the way. Already we discussed little bit about what can be the risks, right? We need to analyze the demand patterns, and accordingly we need to decide the transportation mode. We need to define the inventory level at different warehouses, because that demand patterns will help us to find out how much inventory we need to place at particular storage location. And obviously tracking, when you are tracking and monitoring continuously, you will come up with the feedback kind of thing, and then we can go for the further improvement in the overall supply chain. So now logistics design and management, let us explore some key core elements in that. So already we talked about strategic planning, because it's a long-term planning, how you will set up your facilities, warehouses, mode of transportation, that all is a call for your top level management, and you need to align your business strategies, whether you are going for expansion. If you are going for expansion, so you need to expand your warehouses, your facilities, right, in that way. So inventory management is another key element in that we already discussed about. We need to balance the supply and demand. How we can do that? We need to forecast properly, and we'll see what are the different forecasting techniques in the subsequent sections, and we'll try to optimize and be cost effective in managing your stock. Obviously warehouse management, we need to manage the capacity of the warehouse more efficiently, and maximum utilization of the capacity should be ensured. And transportation, depending upon infrastructure, depending upon the mode of delivery, how much fast delivery is required for particular item, how much cost you can bear for that, quality level required, so that will decide your transportation. Order processing, once you enter the order from the customer side, you will start processing, and you will start distributing to last mile delivery using your fastest network and minimizing the cost, right? And then obviously to ensure that you should be equipped with the latest technology, and in that you will talk about RFID. This is a huge intervention, technological intervention, RFID, where you can quickly scan the product barcode, and then you can just locate where the item is, whether the item is depleted on the inventory shelf or you need to produce more, so that you can easily track with the help of technology. So I talked about UAVs, unmanned aerial vehicles, where you can deliver your packets through airspace, and within 30 minutes that is possible using this, and then GPS enabled services to optimize, to monitor the movement of your goods through the network. So continuous improvement, obviously when we will talk about all these parameters, elements, factors, we will develop some KPIs, and then we can identify those KPIs and we will work on those KPIs. There are some modern logistics concepts, so we will not discuss in detail in this session, but yes, just a brief introduction about that we can go for. First, very important is, and obviously requires our detailed observation on that, but quickly, lean logistics is one concept where we will try to reduce the waste in the logistics part. Waste of extra transportation, waste of inventory, waste of extra movement of the material, waste of over processing, waste of overproduction, waiting time. So anything, these kind of waste we'll discuss in detail, and then we'll try to make our logistics as lean as possible. Only will minimize the waste, will add directly to the profit. This is for sure. The second concept is, which is not very new, quite old now, just in time, but again we need to define what are those items for which we can go for just in time kind of system, right? Maybe if there are small components and the price is not very high, you can store those components, right? But if components are very costly, right, and adding maybe only those 20% components which are adding, again 80-20 rule, which are adding towards 80% of the cost, right? So then you can go for, up to some extent you can go for just in time. So for ensuring just in time, you need to align your suppliers near to your manufacturing unit, right? And in that way your demand prediction should be very accurate, and then only you can design kind of system, right, where you are not thinking of keeping any inventory. The next concept is agile logistics, which is again the evolution of your logistics function, where we are talking about the flexibility and responsiveness, right? So we need to have dynamic supply chains. How we can have dynamic supply chain? When we are continuously feeding the information to the supply chain stakeholders who are taking the decisions based on that information, only then we can quickly respond, right? If anything goes wrong at the customer end, we should record it. Why the customer received the damaged packaging? Why the customer is not happy with the product delivered? Why the customer is not happy with the returns, right? So this is only possible when we have quick system of information sharing, right? And any disruption is happening, we have the second plan, right? So only then we can say we can explore the opportunities and we can grab those opportunities. The next concept, the modern concept, is green logistics, because the customers now, there are some restrictions from the so many regulatory authorities are there who are continuously focusing on going for green products, green supply chain and green logistics, and obviously we need to minimize the carbon footprint. That is the sole purpose, right? So in that campaign, many customers, the common man is also finding themselves very relevant. Only then they can contribute towards reducing the total carbon footprint, right? So they also want to minimize. This is the latest one case study I have gone through, where if you talk about European market, US market, developed nations, customers are preferring the delivery partners or the e-commerce players who are doing the last mile delivery using any electronic vehicle or cycles. So they are placing more orders with those kind of players, right? So in that way we have to be maybe eco-friendly when we are using fuels, vehicles, maximum utilization should be there, and renewable energy sources we should be using. The next thing is collaborative logistics. So obviously, because so many interaction points are there between different stakeholders, like we explored the supply chain of bread, right? How you are manufacturing bread. So this only possible when you are having collaborative logistics network, right? So that is another point. Cooperation can only be ensured when you have very strong relationship with the suppliers. Not only suppliers, but all the stakeholders in the supply chain, right? For that, you should be having very quick in sharing the information. So one complete channel of information sharing should be shared with all the stakeholders. Omni-channel logistics, there we cannot say that we will sell our product using our own website, right? So if Indigo will say this, that we will sell our tickets through only Indigo website, that thing will not work, right? So Indigo is selling through Make My Trip, Indigo is selling through GoAvivo, through Ixigo, through their personal website, through IRCTC, through so many different platforms, right? So when demand is so segregated coming from anywhere, right? So in the end, as service provider, you are limited with the capacity. Maybe seats are 130 seats are there in one plane, right? How you are then meeting the demand coming from different channels. So in that way, your information system has to be very, very strong, right? How you are tracking the things should be very, very strong. So this will happen only when you have the input from the market, you have proper inventory with you, seats, number of seats you have, and then you have flexible fulfillment options, right? And these are ensured through synchronized logistics process. Then reverse logistics is next concept when the customers are not happy with the products, so they can return. And I told you the 2-3 things. They can return just because they are not liking the product, they can return because it is damaged, or maybe it is not working properly, or once it is used fully, they want to recycle, remanufacture or reuse that. So in that way, how you can help that so that it can be as a maybe circular economy kind of concept we can implement for that. In the end, we'll talk about the supply chain visibility, and towards the end of this whole course, we'll be seeing that there are so many different platforms and latest technological developments which we need to be updated with those with those technological interventions. Only then we can survive in the market, right? So for getting quick information, if you have that latest information, you can manage all your logistics all around, right? You can manage your distribution part, your transportation part, how much you need to store in the warehouse, which model you need to store, right? What are the preferences if you talk about the regional basis, if you have that information, close connection with the customer. And then once you start supplying the product, that visibility throughout the supply chain, customer wants. They want to track where my packet is right now, right? So that visibility you can only offer if you have the latest technological intervention within you. So in the end, we can conclude that logistics design and management is a dynamic field requiring meticulous planning and execution to facilitate the smooth flow of goods, information and resources among the various stakeholders. So all the stakeholders we need to take care, we need to integrate, and then we need to ensure that not only the resources or product is passing through smoothly through all those stakeholders, but that information should also pass so that we can take the information supported decision for making the further deliveries. So these are some of the latest development when we talk about logistics management, and I have tried including one session on each of this because it is very important as far as the latest trends in the industry concerned, and as well as the research going on, right? So these are some of the reference books you can refer, and already I have named these books, and the content has been prepared from these slides. So thank you very much.
Hello and welcome to this piece of literary snippet. British humour doesn't have a very high standing in the world. When people talk about it, they usually do so with a certain degree of disparagement. Yet all this is, I think, rather unfortunate, because if I read out to you a certain section from Jerome K. Jerome's famous novel Three Men in a Boat, you will realize that not only is British humour genuinely funny, it is probably even better than some of the other samples of humorous writings that you might have read in the recent past. The story that I'm going to read out is told by Jerome, who thinks he is suffering from some kind of a malady. I remember going to the British Museum one day to read up the treatment for some slight ailment of which I had a touch. Hay fever, I fancy it was. I got down the book and read all I came to read. And then, in an unthinking moment, I idly turned the leaves and began to indolently study diseases generally. I forgot which was the first distemper I plunged into. Some fearful, devastating scourge, I know. And before I had glanced half down the list of premonitory symptoms, it was borne in upon me that I had fairly got it. I sat for a while, frozen with horror, and then in the listlessness of despair, I again turned over the pages. I came to typhoid fever, read the symptoms, discovered that I had typhoid fever. Must have had it for months without knowing it. Wondered what else I had got. Turned up St. Vitus's dance. Found, as I expected, that I had that too. Began to get interested in my case and determined to sift it to the bottom, and so started alphabetically. Read up ague and learnt that I was sickening from it, and that the acute stage would commence in about another fortnight. Bright's disease, I was relieved to find, I had only in a modified form. And so far as that was concerned, I might live for years. Cholera I had with severe complications, and diphtheria I seem to have been born with. I plodded conscientiously through the 26 letters, and the only malady I could conclude I had not got was housemaid's knee. I felt rather hurt about this at first. It seemed somehow to be a sort of slight. Why hadn't I got housemaid's knee? Why this invidious reservation? After a while, however, less grasping feelings prevailed. I reflected that I had every other known malady in the pharmacology, and I grew less selfish and determined to do without housemaid's knee. Gout, in its most malignant stage, it would appear, had seized me without my being aware of it. And zymosis. I had zymosis evidently from boyhood. There were no more diseases after zymosis, so I concluded there was nothing else the matter with me. I sat and pondered. I thought, what an interesting case I must be from a medical point of view. What an acquisition I should be to a class. Students would have no need to walk the hospitals if they had me. I was a hospital in myself. All they need to do would be to walk round me and after that take the diploma. Then I wondered how long I had to live. I tried to examine myself. I felt my pulse. I could not at first feel any pulse at all. Then all of a sudden it seemed to start off. I pulled out my watch and timed it. I made it 147 to a minute. I tried to feel my heart. I could not feel my heart. it had been beating, but now it had stopped beating. I have since been induced to come to the opinion that it must have been there all the time and must have been beating, but I cannot account for it. I patted myself all over my front, from what I call my waist up to my head, and I went a bit around each side and a little way up the back. But I could not feel or hear anything. I tried to look at my tongue. I stuck it out as far as ever it would go, and I shut one eye and tried to examine it with the other. I could only see the tip, and the only thing that I could gain from that was to feel more certain than before that I had scarlet fever. I had walked into the reading room a happy, healthy man. I crawled out a decrepit wreck. Our friend next visited a doctor, and there he got a prescription which said to eat well, to go for long walks, and not to worry his heads over things he didn't understand. See you in the next episode of Literary Snippets. Hello and welcome to this piece of Literary Snippet. Today we are going to read a section from Virginia Woolf's novel, Orlando. And the section that we are going to listen to today is perhaps one of the finest descriptions of the winter season in English literature. It is also a very fine piece of what we call fantasy writing. I have made a few changes to the original to adapt it for the purpose of reading. The Great Frost was, historians tell us, the most severe that has ever visited these islands. Birds froze in mid-air and fell like stones to the ground. At Norwich, a young countrywoman started to cross the road in her usual robust health and was seen by the onlookers to turn visibly to powder and be blown in a puff of dust over the roofs. The mortality among sheep and cattle was enormous. Corpses froze and could not be drawn from the sheets. It was no uncommon sight to come upon a whole herd of swine frozen immovable upon the road. The fields were full of shepherds, ploughmen, teams of horses, and little bird-scaring boys, all struck stark in the act of the moment. One with his hand to his nose, another with a bottle to his lips, a third with a stone raised to throw at the ravens, who sat upon the hedge within a yard of him as if they were stuffed birds. The severity of the frost was so extraordinary that a kind of petrification sometimes ensued. It was commonly supposed that the great increase of rocks in some parts of Derbyshire was due to no eruption, for there was no eruptions. Rather, it was supposed that they were due to the solidification of unfortunate wayfarers who had been turned literally to stones where they stood. The church could give little help in the matter, and though some landowners had these relics blessed, the most part preferred to use them either as landmarks, scratching posts for sheep, or when the form of the stone allowed, drinking troughs for cattle, which purpose they serve admirably for the most part to this day. But while the country people suffered the extremity of want and the trade of the country was at a standstill, London enjoyed a carnival of utmost brilliance. The new king directed that the river, which was frozen to a depth of 20 feet, should be swept, decorated, and given all the semblance of a park or pleasure ground, with arbors, mazes, alleys, drinking booths, all at his expense, of course. Frozen roses fell in showers when the queen and her ladies walked abroad. Colored balloons hovered motionless in the air. Here and there burnt vast bonfires of cedar and oak wood, lavishly salted so that the flame were of green, orange, and purple fire. But however fiercely they burnt, the heat was not enough to melt the ice, which, though of singular transparency, was yet of the hardness of steel. So clear, indeed, was the ice that there could be seen, congealed at a depth of several feet, here a porpoise, there a flounder. Shoals of eels lay motionless in a trance, but whether their state was one of death or merely of suspended animation which the warmth would revive, puzzled the philosophers. In short, nothing could exceed the brilliancy and gaiety of the scene by day. But it was at night that the carnival was at its merriest. The nights were of perfect stillness. The moon and stars blazed with the hard fixity of diamonds, and to the fine music of flute and trumpet the courtiers danced. See you in the next episode of Literary Snippet.
Hi, I'm Ch-26 Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP. You have your incidence of high BP, MAP, and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol, and incidence of high cholesterol. Now, before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with a 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables, more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender and by your weight. So apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors, like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator, which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are not non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now after this, we went in for a policy implication, and in the policy implication we tried to find 2 policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has an impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators. And it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day. But fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.
Swayam Prabha. Digital India. Educated India.
Welcome to the course on medical law. This lecture will be about do's and don'ts for legal practitioners. The concepts covered in this lecture are professional ethics of lawyers, consequences of professional misconduct, duties of lawyers, do's and don'ts for legal practitioners. The keywords of this lecture are legal representation, medical malpractice, patient confidentiality, healthcare fraud and regulatory compliance. In healthcare industry, lawyers have a major role to play. The lawyers will majorly focus on the legal rights and of patients and medical practitioners. Such lawyers are usually referred to as medical attorneys or medical lawyers. So their main role will be to handle the legal matters related to the healthcare industry. So they will advise clients on various legal matters. So their clients will be either the patients who are taking some services from the healthcare industry or the providers of service in the healthcare industry like various clinics, hospitals or the doctors themselves. They will represent their clients in the court. So if there is a legal dispute either between the clients, that is the patients, or the professionals in the healthcare industry, such disputes will be handled by the lawyers. So they will be appearing on behalf of their clients in the court. They will provide advice to medical professionals, hospitals and other establishments. They will make sure that the negligent healthcare provider will face the appropriate criminal charges. They will assist the hospitals in running their business. So the lawyers also have a significant role to play in the healthcare industry by handling all the legal matters related to the industry. So the professional ethics is an important aspect with regard to legal profession. Professional ethics could be defined as a collection of written or unwritten principles that govern the behavior of advocates while they are practicing in the court or in their relationship with the client. So they have to take care of several ethical principles while they deal with the client's matters, either during the discussion with the client or when they are practicing on behalf of their client in the court. Consequently, the ethics of legal profession comprise of the collection of practices and standards that govern the professional conduct of bar members. Upon becoming a lawyer, an individual's interaction with others are generally governed by the general principles of law. Nevertheless, advocates are bound by bar's exceptional principles of professional ethics. So advocates are bound by the written and unwritten principles of professional ethics. So they have to maintain the decorum and decency in their legal profession. Maintaining an amicable relationship between the bench and the bar and preserving the dignity of legal professionalism are the principal goals of ethics of legal profession. One of the principal legislations that deals with professional ethics of lawyers is the Advocates Act 1961. The Advocates Act 1961 was enacted based on the recommendations of All India Bar Committee as well as the Law Commission. The Bar Council of India is established under Section 4 of the Advocates Act. The principal duty of the Bar Council of India is to maintain the professional ethics among the legal practitioners. So according to the profession, Section 1 Clause B, it is the duty of the Bar Council to establish guidelines pertaining to professional behavior and etiquette expected of advocates. Section 49(1)(c) confers the Bar Council of India the authority to establish regulations pertaining to delineation of the expected level of professional conduct to be adhered by the advocates. So advocates throughout their profession has to maintain the decency and ethical standards as prescribed by the Bar Council of India. So they are expected to maintain the highest level of discipline in their relationship with their clients as well as during their arguments in the court of law. They have duties towards the courts. The duties of advocates to courts encompass the obligation to keep demeanor characterized by respect and dignity towards the judicial system. It is imperative to refrain from exerting any unlawful or inappropriate methods to influence the decision-making process of the courts. So the advocates must strive to exert their utmost effort in order to prevent their customer from engaging in unfair activities. So they have to maintain the highest level of discipline while they are in the court. They have to take adequate measures to protect the interest of their clients, but at the same time they should not engage in any inappropriate methods to influence the decision making by the court. In order to attend court proceedings, they are bound to follow the established dress code and present oneself in a manner which is considered appropriate and respectable for a practicing advocate. The wearing of bands and gowns is typically reserved for courtrooms and ceremonial events. So when they interact with their clients or while they are in their office, they can maintain the normal dress code. But while they are in the court, they are to follow the prescribed dress code. The advocates are prohibited from making any plea in any case in which they have a personal stake. So this is another important matter. So in case if the advocate is having any personal stake in the matter, then they are completely prohibited from making any plea in such cases. So if the client is having any personal relationship or business relationship with the doctor or the hospital or the clinic in the healthcare industry, then they cannot take up that matter as an advocate. Similarly, if they are having any personal relationship with the client, which is a patient. In such cases also, they are completely barred from making any plea in such cases. If an advocate has a position on the executive committee of an organization or a company, so that means if the advocate has some role in the management of the business of the healthcare industry, then they are completely prohibited from participating in any judicial proceeding or appearing before any other authority to advocate the interest of the said organization. The advocate also have specific duties to their clients. The responsibilities of an advocate toward their client include obligation to refrain from withdrawing from acts or engagements without justifiable cause. It is imperative to refrain from accepting or participating in legal matter if there is reasonable belief that one may serve as a witness. So the advocate also have direct responsibilities towards their client. They are in a fiduciary relationship with the clients. In case advocate is expecting that he may have to serve as a witness in the dispute, in such cases he has to refrain from participating as a legal counsel. In order to ensure transparency and integrity, it is essential for the advocate to fully disclose any affiliations or vested interest they may have with the relevant parties before they start any engagement. So if the advocate is having any direct relationship with any client or the opposite party, then they have to completely disclose all their interest before they take up the matter. They are already barred from taking cases in which they have any personal interest. But even in case there is no direct personal interest, they have to disclose if there is some matter which will affect their decision making while appearing on behalf of the client. The lawyers must advocate for the interest of their client through ethical methods. So lawyers are expected to take all efforts necessary to ensure protection of the interest of their client. But at the same time, they are expected to maintain highest level of ethical standards. In order to provide a fair and unbiased assessment, it is imperative to refrain from exerting undue influence on any matter, material or evidence that may potentially establish the innocence of the accused. So they also have to ensure that they will refrain from exerting any undue influence on any material or evidence that may potentially establish the innocence of the accused. So they have to be fair and unbiased in their assessment about the guilt of the accused. They have to take earnest care to protect the interest of the accused on whose behalf they are appearing. But at the same time, they have to maintain fair and unbiased stance in the matter. The attorney is obligated to maintain confidentiality and refrain from disclosing any messages or discussions made by their client to them. So they have to maintain confidentiality with all the communications they had with their client. So communications may be oral communications that happened during the advocate and the client meeting, and it can also be the materials which were provided by the client to the advocate. The advocate must not intend to impose fees for their services based on the outcome of situation being addressed. So the fees of the advocate should not be based on the outcome. They have to tell the fees well in advance, and it should not be based on the positive or negative outcome of the dispute. The fees payable to the professional by their client is not adjusted against professional's liability to the client. So the fees has to be kept separately from any damages that the client may receive after the decision is given by the court. In order to maintain accurate financial records of funds received from the clients and to furnish clients with copies of statement, it is necessary to adjust the charge in the event of proceeding being cancelled. So advocate also have to maintain accurate financial records with regard to all their transactions with the clients. The individuals in question is unable to execute payments on behalf of clients or provide financial assistance for legal actions. So advocates cannot give any financial assistance for legal action, or they cannot make or execute any payment on behalf of their client. Advocates are prohibited from doing all these actions. If an individual has provided advice to a political party on initiation of a legal proceeding, they are precluded from representing the opposing party in relation to the same case. So, in a case, an advocate has appeared or provided advice to a particular political party, then in such cases they are prohibited from representing the opposing party in the same legal dispute. The consequences for professional misconduct by an advocate is provided under Section 35 of the Advocates Act 1961. So, Advocate Act 1961 is the legislation that deals with the conduct and professional matters of advocates. According to Section 35 of the Advocates Act, in the event that an advocate is found to have engaged in professional misconduct, the matter will be directed to a disciplinary committee. The committee will then schedule a hearing and serve a notice to the advocate involved. The disciplinary committee of the State Bar Council will proceed to hear the arguments presented by both the parties. So, matters or disputes involving the professional misconduct of an advocate is dealt under Section 35 of the Advocates Act 1961. So, if any person has any complaint regarding the professional misconduct carried out by an advocate, they can give a complaint to the State Bar Council. On receiving the complaint, the Bar Council will hand over the matter to a disciplinary committee constituted under the Bar Council rules. The disciplinary committee is empowered to hear the arguments presented by both the parties and take a decision in the matter. The disciplinary committee can either dismiss the complaint if they feel that the complaint or the matters which are averred in the complaint is not correct. In case they find that the advocate has engaged in a behavior which could be considered as professional misconduct, they can either reprimand the advocate, or they can suspend the advocate from practice for a temporary period, or they can direct for removal of the name of the advocate from the state rolls of advocates. So, the disciplinary committee can recommend an action based on the nature of professional misconduct and its degree. The do's and don'ts of lawyers, which is going to be dealt in this lecture, is segmented under 4 categories: the duties of advocates with regard to patients, the duties of advocates with regard to doctors, their duties with regard to hospitals, and their duties with regard to the government. First, we will start with duties of lawyers with respect to patients. Their preliminary duty with regard to the patient is providing advice on all legal matters. Medical lawyers offer their clients guidance and advice on a variety of medical related issues, which will include medical malpractice, insurance disputes, and other healthcare regulations. According to Section 29 of the Advocates Act, advocates are primarily recognized group of individuals who possess the eligibility to offer legal advice. So, they are professionally trained to give legal advice to their clients. So, their primary responsibility is to provide accurate advice to their clients, which can include patients, professionals, and even establishments in the healthcare industry. They will also do legal representation on behalf of their clients. Medical lawyers argue on behalf of their clients before the courts and tribunals. Additionally, they might bargain settlements on behalf of their clients. So, they can also engage in settlement of disputes between the parties on behalf of their clients. They will also draft legal documents which will include contracts, pleadings, and motion, and then make sure they abide by all relevant rules and laws. So, all the documents including contracts, pleading and motions all has to be come in compliance with all the rules and regulations applicable to the scenario. So, medical lawyers will be professionally competent to handle such legal documents and draft them. They will also interpret the medical records and other matters. Medical attorneys research and analyze medical records and other pertinent documents in order to build strong cases for their clients. They also inquire the claims made and gather evidences in support of their client and speak to their witnesses. So medical attorneys are professionally trained to handle various kinds of documents and interpret them. They should also have some scientific knowledge about the medical records in order to analyze them and build strong cases for their clients. They will also negotiate on behalf of their clients. So they will settle cases without going to trial, and they will also bargain on behalf of their clients. They have to keep up along with the latest developments in law. They will provide their clients with the best legal representation possible. Medical attorneys stay up to date about the developments in medical law and healthcare legislations. The attorneys also have direct responsibility towards doctors. In case of medical malpractice, lawyers have a very important role. Medical malpractice is a legal claim that the healthcare provider violated the standard of care, causing harm to the patient. Medical lawyers represent the physicians in malpractice lawsuits. In medical malpractice litigation, medical lawyers can help physicians combat claims of carelessness or other forms of professional misconduct. So, in case of medical malpractice, the lawyers will have to advise their clients and appear on behalf of them. So, in case the advocate is appearing on behalf of a patient, then he will have to analyze all the medical records and find out evidences that will be supportive of the arguments for his client. And if the matter is taken to the court, then the medical attorney has to appear on behalf of his client. In case the lawyer is appearing on behalf of the establishment or the hospital or the clinic, then he will have to go through all the documents and find materials which will be supportive of defending the claim of medical malpractice. Representation in disciplinary proceedings. Apart from their traditional role of handling legal disputes and appearing in courts, medical attorneys also have a role in representing their clients before various medical boards and other regulatory bodies. So, as they are specifically trained to handle matters with regard to a particular type of industry, they will appear before medical boards or other regulatory bodies and protect the licenses and goodwill and reputation of their clients. They will also engage in negotiation of contracts and agreements. To protect the rights and interests, medical attorneys can assist physicians in negotiating agreements with hospitals, insurance companies and healthcare providers. So, healthcare industry involves various contracts and agreements between various stakeholders. So, the patients will be having some kind of contractual relationship with the doctors or the clinics or hospitals, and within the hospital establishment itself there will be several contracts between various stakeholders. So, all these are legal documents which can be drafted only with the expertise of a trained professional. So, medical attorneys have the role of negotiating these contracts and concluding agreements. Maintaining patient confidentiality is a very important duty with regard to every lawyer. Medical attorneys can provide guidance to physicians on maintaining patient confidentiality and other privacy laws. So, they have to maintain 100% confidentiality with regard to oral communications as well as materials which were transacted between the client and the advocate. In Kamarjit Singh versus State, the Supreme Court decision in 2000, the Supreme Court decided that the right to information does not encompass the ability to request the disclosure of attorney-client professional communications and documents. So, attorney-client professional communications and documents are coming within the privilege of advocates. So, they cannot be forced to disclose any information which was communicated by their client or any document which was given to them by their clients. Supreme Court has upheld this right as a very important aspect with regard to legal profession. So, there is another very interesting decision in Kalikumar Pal versus Rajkumar Pal, which was in 1931 by the Kolkata High Court. It decided that the attorney-client privilege will persist even after the termination of employment. So, even after the attorney-client relationship ends, the attorneys are responsible of maintaining confidentiality with regard to any communication that they came across during their relationship with the client. So, all the oral communications and any other document which was given by the client has to be maintained with 100% confidentiality by the advocates. So, even after their relationship with the client ends, they cannot disclose this information to anyone else. The prohibition of disclosure will also apply to individuals serving as interpreters, clerks or assistant to attorney. So, the privilege will also apply to any person who is working in the advocate's office. Advice on healthcare reform is another important duty of medical practitioners. Medical lawyers shall keep abreast of the changes in healthcare regulation and legislations. They can counsel physicians on how these developments might affect their practices. They also have a responsibility with regard to healthcare fraud. Medical lawyers represent healthcare providers in investigations and enforcement actions involving healthcare fraud and abuse. They also have duties with regard to pharmaceutical and medical device liability. So, this is another interesting aspect with regard to medical attorney practice. In cases involving the safety and effectiveness of prescription medications and medical devices, the medical lawyers represent both the plaintiff and the defendants. So, apart from the traditional cases like medical malpractice or medical negligence, now medical attorneys are also appearing in cases involving pharmaceutical and medical device liabilities. The lawyers also have duties with respect to hospitals. Guidance on healthcare regulatory compliance is a booming profession in India. Medical lawyers are knowledgeable about the intricate laws that govern the healthcare industry and help the hospitals and physicians comply with them. The hospitals, physicians and other stakeholders in the healthcare industry have to comply with various regulatory laws. Medical lawyers will help them in ensuring compliance with these regulatory requirements. These healthcare regulatory requirements are laws in place to ensure that hospital facilities are built after a thorough registration process and they are safe for public to use, and that the bare minimum infrastructure for the type and volume of workload anticipated, and they are subject to periodic inspections to ensure compliance. So, all these regulatory compliance will be taken care by medical attorneys. They will also draft, review and negotiate contracts involving healthcare providers, payers and suppliers, such as managed care contracts, hospital physician contracts and group purchasing agreements. So, there are several contracts which are entered between various stakeholders in the healthcare industry. Medical lawyers will be the ones who will draft, review and negotiate such contracts. They will also study medical law, healthcare legislations and pertinent case law to develop strong legal arguments for their clients. Medical lawyers assist the hospitals in designing and administering employee benefit plans such as health and welfare benefits, maternity benefits and retirement plans. When it comes to employment, intellectual property and tax laws that are relevant to healthcare industry, it is the medical lawyers who can provide guidance to physicians. So apart from the normal traditional legislations that apply to healthcare industry, there are also intellectual property and tax legislations which will apply to various stakeholders in the healthcare industry like patients, practitioners and professionals in the industry. It will be the medical lawyers who will guide the various stakeholders with regard to these matters. Lawyers also have direct responsibility towards government. They will assist the government in various healthcare programs. Lawyers specialized in healthcare and medical law can work closely with governments also. They also help the government by reporting true state of affairs with regard to healthcare infrastructure. They assist the government in developing various policies. Healthcare attorneys and medical lawyers help the government to formulate laws and policies, keeping in mind the needs of healthcare industry. To conclude, the primary responsibility of an advocate is to protect the interest of their clients. So they will be responsible for a variety of tasks that help the client to win his claims. Generally speaking, lawyers are expected to have both the soft skills that are useful for maintaining the required professional behavior in the courts and also strong legal and technical foundation which will help them to protect the interest of their clients. A lawyer can provide advice on the best course of action to take and help the client understand their legal rights and options. This might also help them navigate the complex legal and medical concerns and defend the clients in the court. The references of this lecture can be seen here. Thank you very much for listening to the lecture. I hope you are enjoying the course.
I am A.K. Sharma and I teach sociology at IIT Kanpur. I am going to address the question, what is the relevance of statistics in sociology? In India, there is some confusion about role of statistics in sociology, and most of the students of sociology suffer from what I call phobia of statistics. But actually, if you look at history of sociology or the kind of works that are being done in sociology or which are published in prestigious academic journals, you find that there is a lot of use of statistical methods, and not simple methods, very advanced methods. All of you know, as students of sociology, you know that one of the founding fathers of sociology, Comte, or another founding father, Emile Durkheim, they said that sociology is one subject which differs from other subjects in the questions that they try to answer, but they use the same method, the method of science. And that in sociology, those who believe in this kind of approach, they are called positivists. Emile Durkheim called them positivists. They believe that social issues must be studied by using observations, experiments and other modes of collection of data. Now, statistics can help sociologists in three ways. Because if sociology is about social facts or patterns, not individuals, patterns of thinking, patterns of feeling, patterns of acting, behaving, and they can be measured, they can be quantified, and that explanation of one social fact can be given only in terms of other facts. We need statistics, because statistics can measure these facts. Statistics can describe these facts. So, one branch of statistics, we can call it descriptive statistics, can help us in summarizing data, in measuring facts, like you are all familiar with simple statistical things like mean, mode, median, or methods of dispersion, standard deviation, range, variance. These are descriptive measures. They can also be used to measure skewness or symmetry or asymmetry in the data. Other types of statistical methods, which are called inferential statistics, are used to test hypotheses. We know that any science, including sociology, if we follow that positivistic tradition, is about testing hypotheses using scientific methods. And for testing hypotheses, like for comparative purposes, comparing means of two samples or comparing variances of two samples or comparing correlation coefficients or regression coefficients, we need inferential statistics. And if you are familiar with some of them, t-test, z-test, chi-square test, f-test, these are the tests which come under inferential statistics. We use statistics for drawing inferences about two or more samples. And thirdly, statistics can also be used for posing new questions. I remember that a few months ago I read an article in Population and Development Review in which the authors Cole and Gramajo, they tried to explain homicide rates and variations in homicide rates across countries in the entire world. And they found, based on statistical analysis, logistic regression and all, they found that one factor which explains variations in homicide rates in the world is female education. Not culture, not governance so much, not even male education, but female education. Now, if facts are showing this, so you have a new sociological question. Why is it that rise in female education leads to higher homicide rates? And Cole and Gramajo then gave certain hypotheses. You may not agree with those hypotheses. You may conduct this study on your own or test these hypotheses given by Cole and Gramajo using statistical methods. But the point I am making that in addition to describing data, drawing inferences, statistical methods can also be used for raising new questions in sociology. And of course, you are all familiar that whenever the issue of prediction comes, predicting population of India, predicting urbanization, predicting per capita income of India 20 years from now, 50 years from now, there also statistical methods are of great help. And finally, statistical methods have been used in monitoring and evaluation of development policies run by various governments and NGOs. Thank you very much. Hello, I am A.K. Sharma and I teach sociology in IIT Kanpur. I am attempting to answer a simple question, what is sociology? Now friends, one simple answer would be that sociology is a study of human behavior. And this study of human behavior has a history. Actually, due to growth of science, technology, and due to industrialization and economic development in the West, initially there was a hope that by application of science and technology, the face of this world can be changed to the advantage of mankind. But what was found or what was observed, that this did not happen. And despite economic development, urbanization, industrialization, surveys showed that poverty had increased, unemployment had increased, even health conditions became worse. And today you will be surprised to know that there was a time when death rate of urban areas was higher than the death rate of rural areas. cities or the places of development, industrialization and education and enlightenment became consumers of rural population. So people started asking, why is it so? And some philosophers, engineers, mathematicians who contributed to emergence of a discipline like sociology started thinking that perhaps we need a new subject in which we will apply the same tools and techniques which are being used by scientists, mathematicians, physicists, chemists, but we will study human behavior. In other words, we will try to discover if there are laws of human behavior, and by applying those laws, perhaps in the future the condition of mankind can be improved. This is how sociology developed. Initially Auguste Comte called this social physics. He also used terms like social statics and social dynamics, the usual division of mathematics, and he believed that social statics will study relationship between different parts of society and social dynamics will study relationship between parts of society and total society, change in total society. Now you may ask that if sociology is the study of human behavior, there are many other branches of social sciences which study human behavior, economics, anthropology, psychology, etc., etc. The difference between sociology and these disciplines is that while in these disciplines we study one specific aspect of human behavior, like economics will study production and distribution of wealth, psychology will study cognitive processes or mental models or personality, social psychology will study personality, anthropology will study culture. Now somebody has to relate one aspect of human behavior with the other aspects, or one social fact with the other. These are all social facts for us. And if somebody tries to link cognitive processes with economic conditions or urbanization or caste system or religion, or somebody tries to relate urbanization with human psyche, or somebody tries to correlate cultural context with economic behavior, then it becomes sociology. So sociology combines different areas which are individually studied by different disciplines. And sociology also studies new questions which are not studied by any existing subject so far. So like these days issues of waste disposal, entropy, environment, safety, urban places as new geomorphological systems come up, and we want to correlate one aspect of urbanization, say percentage of population living in urban areas, and risk, environmental risk, carbon dioxide, this emission, that emission. Now which will be the first discipline to take interest in these things? Because sociology. So sociology not only combines facts from different aspects of society, sociology also addresses new questions. And I can also say that one central feature of sociology is to explain individual behavior or individual psyche in terms of properties of larger society. In simple terms, if you imagine that there are two aspects of human behavior, individual and society, then while other disciplines like psychology are focusing more on individual, we study characteristics of individuals in terms of certain characteristics of larger society. This is what sociology does. Sociology is very useful for planners. Sociology is useful for answering new questions, as I said, which have not been answered by any existing discipline. And I would say that sociology is especially helpful for self-enlightenment or for developing empathy, because sociology only tells you that there are no right or wrong answers of social issues. It is not physics, it is not mathematics, it does not have fixed answers to issues, because questions can be looked at from variety of perspectives. So, role of perspectives, thinking, interest, power, etc., also come up in answering social questions. And it is this aspect that something can be looked at from variety of perspectives, that something can be looked at from the perspective of government, the same thing can be looked at entirely differently from the perspective of people, or from the perspective of NGOs, or from the perspective of experts. So, this realization, this takes us to self-enlightenment and empathy. Thank you.
Hello and welcome to this piece of literary snippet. British humour doesn't have a very high standing in the world. When people talk about it, they usually do so with a certain degree of disparagement. Yet all this is, I think, rather unfortunate, because if I read out to you a certain section from Jerome K. Jerome's famous novel Three Men in a Boat, you will realize that not only is British humour genuinely funny, it is probably even better than some of the other samples of humorous writings that you might have read in the recent past. The story that I'm going to read out is told by Jerome, who thinks he is suffering from some kind of a malady. I remember going to the British Museum one day to read up the treatment for some slight ailment of which I had a touch. Hay fever, I fancy it was. I got down the book and read all I came to read, and then, in an unthinking moment, I idly turned the leaves and began to indolently study diseases generally. I forgot which was the first distemper I plunged into, some fearful, devastating scourge, I know. And before I had glanced half down the list of premonitory symptoms, it was borne in upon me that I had fairly got it. I sat for a while, frozen with horror, and then in the listlessness of despair, I again turned over the pages. I came to typhoid fever, read the symptoms, discovered that I had typhoid fever. Must have had it for months without knowing it. Wondered what else I had got. Turned up St. Vitus's dance. Found, as I expected, that I had that too. Began to get interested in my case and determined to sift it to the bottom, and so started alphabetically. Read up ague and learned that I was sickening from it, and that the acute stage would commence in about another fortnight. Bright's disease, I was relieved to find, I had only in a modified form. And so far as that was concerned, I might live for years. Cholera I had with severe complications, and diphtheria I seem to have been born with. I plodded conscientiously through the 26 letters, and the only malady I could conclude I had not got was housemaid's knee. I felt rather hurt about this at first. It seemed somehow to be a sort of slight. Why hadn't I got housemaid's knee? Why this invidious reservation? After a while, however, less grasping feelings prevailed. I reflected that I had every other known malady in the pharmacology, and I grew less selfish and determined to do without housemaid's knee. Gout, in its most malignant stage, it would appear, had seized me without my being aware of it. And zymosis. I had zymosis evidently from boyhood. There were no more diseases after zymosis, so I concluded there was nothing else the matter with me. I sat and pondered. I thought, what an interesting case I must be from a medical point of view. What an acquisition I should be to a class. Students would have no need to walk the hospitals if they had me. I was a hospital in myself. All they need to do would be to walk round me and after that take the diploma. Then I wondered how long I had to live. I tried to examine myself. I felt my pulse. I could not at first feel any pulse at all. Then all of a sudden it seemed to start off. I pulled out my watch and timed it. I made it 147 to a minute. I tried to feel my heart. I could not feel my heart. It had been beating, but now it had stopped beating. I have since been induced to come to the opinion that it must have been there all the time and must have been beating, but I cannot account for it. I patted myself all over my front, from what I call my waist up to my head, and I went a bit around each side and a little way up the back. But I could not feel or hear anything. I tried to look at my tongue. I stuck it out as far as ever it would go, and I shut one eye and tried to examine it with the other. I could only see the tip, and the only thing that I could gain from that was to feel more certain than before that I had scarlet fever. I had walked into the reading room a happy, healthy man. I crawled out a decrepit wreck. Our friend next visited a doctor, and there he got a prescription which said to eat well, to go for long walks, and not to worry his heads over things he didn't understand. See you in the next episode of Literary Snippets. Hello and welcome to this piece of Literary Snippet. Today we are going to read a section from Virginia Woolf's novel, Orlando. And the section that we are going to listen to today is perhaps one of the finest descriptions of the winter season in English literature. It is also a very fine piece of what we call fantasy writing. I have made a few changes to the original to adapt it for the purpose of reading. The Great Frost was, historians tell us, the most severe that has ever visited these islands. Birds froze in mid-air and fell like stones to the ground. At Norwich, a young countrywoman started to cross the road in her usual robust health and was seen by the onlookers to turn visibly to powder and be blown in a puff of dust over the roofs. The mortality among sheep and cattle was enormous. corpses froze and could not be drawn from the sheets. It was no uncommon sight to come upon a whole herd of swine frozen immovable upon the road. The fields were full of shepherds, ploughmen, teams of horses, and little bird-scaring boys, all struck stark in the act of the moment. One with his hand to his nose, another with a bottle to his lips, a third with a stone raised to throw at the ravens, who sat upon the hedge within a yard of him as if they were stuffed birds. The severity of the frost was so extraordinary that a kind of petrification sometimes ensued. It was commonly supposed that the great increase of rocks in some parts of Derbyshire was due to no eruption, for there was no eruptions. Rather, it was supposed that they were due to the solidification of unfortunate wayfarers who had been turned literally to stones where they stood. The church could give little help in the matter, and though some landowners had these relics blessed, the most part preferred to use them either as landmarks, scratching posts for sheep, or when the form of the stone allowed, drinking troughs for cattle, which purpose they serve admirably for the most part to this day. But while the country people suffered the extremity of want, and the trade of the country was at a standstill, London enjoyed a carnival of utmost brilliance. The new king directed that the river, which was frozen to a depth of 20 feet, should be swept, decorated, and given all the semblance of a park or pleasure ground, with arbors, mazes, alleys, drinking booths, all at his expense, of course. Frozen roses fell in showers when the Queen and her ladies walked abroad. Colored balloons hovered motionless in the air. Here and there burnt vast bonfires of cedar and oak wood, lavishly salted so that the flame were of green, orange, and purple fire. But however fiercely they burnt, the heat was not enough to melt the ice, which, though of singular transparency, was yet of the hardness of steel. So clear, indeed, was the ice that there could be seen, congealed at a depth of several feet, here a porpoise, there a flounder. Shoals of eels lay motionless in a trance, but whether their state was one of death or merely of suspended animation which the warmth would revive, puzzled the philosophers. In short, nothing could exceed the brilliancy and gaiety of the scene by day. But it was at night that the carnival was at its merriest. The nights were of perfect stillness. The moon and stars blazed with the hard fixity of diamonds, and to the fine music of flute and trumpet the courtiers danced. See you in the next episode of Literary Snippet.
Hi, I'm Ch-26 Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP. You have your incidence of high BP, MAP, and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol, and incidence of high cholesterol. Now, before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So the WHO went with the 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if there exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender, and by your weight. So apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors, like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So, if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator, which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance body imbalance that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age, and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol, and your incidence of getting high cholesterol. Now, after this, we went in for a policy implication, and in the policy implication, we tried to find two policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average, 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has an impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators. And it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day. But fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.
When Copernicus said the earth revolves round the sun, it was considered blasphemy. When Galileo said the earth was round, we thought he was mad. When Darwin said that monkeys are the ancestors of man, we thought he had lost it. When the ecologists said this was the end of the world and the human race, we didn't believe them.
Swayam Prabha. Digital India. Educated India.
Namaste. Welcome to the course. Human resource management as a function has evolved through many stages in last 150 years. If we look at the very early signs of the human resource management function in the business organizations or in the workshops and factories, we can look at the examples of the welfare offices, hiring offices, safety bureau, time offices. They were set up at the time of Industrial Revolution 1 and Industrial Revolution 2. These offices were mainly related to ensuring the safety measures or some of the important facilities important for the workers or employees in any organization. In 1900, hiring became, and it was recognized as a very important function, and for that hiring offices started to get established in factories, workshops and offices. In 30s, we see that as an aftermath of the Bolshevik revolution and emergence of the labor as a very powerful force in a society, we see the emergence of the trade unions. So in the 30s, the job of dealing with the trade unions also fell in the lap of a function today which we call human resource management. There were some major changes and development in the form of introduction of equal opportunity regulation in 1960s. That was very important, that came as a very important responsibility of HR function, because now it was the very important duty of HR function to ensure that there is no discrimination in the recruitment process in offices, in factories and at workplace. In 70s, the strategic management and the concern for getting competitive advantage in the increasing globalizing world became a prominent concern. As a result of that, HR function, at that time it used to be called administrative function or industrial relation function or sometime called personnel management, for them it became an important responsibility to keep the employees engaged in their work and committed to their work and organization. That was the moment in the 70s. In between, behavioral science movement also played a very important role in emergence of human resource management function. With the hackathon experiment conducted under the leadership of Elton Mayo, we came to know the importance of relationship, importance of giving autonomy, importance of giving facility, and importance, most importantly, importance of giving attention to the employees. And that was a significant landmark step in the movement called human relation movement, which emphasized on the humane aspect related to relationship, aspect related to care, concern and attention, and their importance at workplace, because those were found to be very significantly affecting the productivity of the employees. From Elton Mayo, we have the work of Maslow, who worked on the motivation, Argyris, who worked on the learning, Hirschberg, who again gave hygiene motivating and hygiene factors of motivation. These were the important thinkers who influenced in the 60s. These were the important thinkers who influenced the emergence of human resource management in 1960s. Application of the behavioral sciences and the tools and techniques emerging from that is the basis of organization development. the field of organization development, though it started with the path breaking work of Kurt Lewin, who looked at the who systematically studied the group dynamics in the National Training Laboratory and the Group Dynamics Center, but Bennis systematized the field of organization development, and that also contributed immensely in the development of human resource management function. In the mid 70s, Flemhodes started a significant process of bringing human resources under the ambit of some form of accounting. It was not typical financial accounting, but the Flemhodes effort was aimed at giving the monetary value to the human resources. After Flemhodes, after the work of Flemhodes, there were many other human resource accounting model developed, like Chow and Lai model or Jaggi model of human resource accounting, but that also gave a push to look at the human resource management function and their impact in more tangible ways. So this is how the emergence of human resource management function has come to the current stage, which is actually a combination of the personal management, strategy HRM connection, administrative function of the business organizations, and industrial relations. We need to understand what is the meaning of strategic perspective of HRM, because of late strategic perspective of HRM has gained a significant currency, and in fact the importance and the contribution of HRM is now expressed in the form of strategic benefit or strategic advantage. So we will look at the strategic advantage and the strategic benefits of the HR function and how to examine that more and how the strategy and HR are closely connected. But before that, we need to understand what are the other different roles HR function can take up in different organizations or in the same organization, maybe in the different stages of its development. This typology was given by Ulrich. What he suggested that HR function can have very operational focus and it can have a strategic focus. HR function can also have more emphasis on the people and can have more concern for people, or it can gear up more to sustain and maintain the system in organization. At the cross section of these two continuum, we get 4 roles of HR function. What are those roles? First of these roles can be called administrative expert. The administrative expert role of HR is the combination of the focus of HR function on creating system and having operational focus. Employee champion role emerges with the combination of the focus on the people or concern for people and maintaining the focus at the operational aspects of business. Operational aspects are more related to efficiency and strategic aspect are more related to effectiveness. Operational focus or operational aspects are more related to short term objectives, and strategic focus or strategic concerns are more related to long term objectives. At the cross section of strategic focus and people focus, we get another role of HR which is called change agent. Importance of HR in terms of preparing organization to meet its strategic objective, we see the role of change agent. Change agent as a HR function as a change agent focuses on the development of people to embrace the change, to innovate, to change their behavior, to build the new knowledge base, to meet the new challenges emerging in the business environment. Fourth role is called strategic partner. Strategic partner role of HR emerges at the cross section of strategic focus and system focus. HR function as a strategic partner looks at the long term objectives of the business organization. In fact, it geared up to achieve the business objectives in the medium and long term, and accordingly it takes the stance. Policies and processes of HR are defined, designed and implemented in view of the medium and long term focus and with the objective of developing and maintaining systems and processes within the organization. So, we come across these 4 roles of HR. Which one do you think is the most important role? The answer is no one role is the most important role. At different stages of the organization life cycle and according to the demand of environment, different roles can be more sought after in business organizations. For example, in the very beginning, when an organization is just setting up a HR function to manage its personnel, they need to identify processes, systems and make rules and regulations. In that stage, administrative expert role is more important. As organization grows, many a time rules and regulations become obstacle on the pathway to give best by their employees. In that situation, HR has to come to the forefront and take care of the employees, and it has to champion the cause of the employees. That time employee champion role becomes very prominent and very important. When organization has been set up, when the function operations have begun and organization is looking at the long term of meeting the long term objectives, it is aiming at getting the competitive advantage, or it is aiming at harnessing its competitive advantage. When it is aiming at coming ahead of the competition in the market, then HR has to support the business by being a strategic partner. As a strategic partner, they need to help the business to translate the long term objectives into HR processes and systems. They also have to develop the HR processes and system which can help the business to achieve its long term objectives. They need to develop systems and processes so that the transaction cost involved in the day to day transaction between the employer and employees can come down, and they help in making the organization a solid, well functioning, well oiled machinery which can move towards the desirable objective. That role is played by the strategic partner. In the process of development, in the process of functioning, an organization can achieve its objective, can grow, but all organizations meet roadblocks or they face competition. Many a time their functioning become less efficient, and many a time organizations are not able to cope up with the changes in the technological, political, social or global environment or business environment. In order to make the organization cope up the challenges and to regain or gain its efficiency and effectiveness, HR has to play the role of change agent. In the role of change agent, they need to help the leadership to develop, they also need to help the business leadership to prepare their employees, prepare their team members to look at the challenges, to understand the challenges and meet those challenges with full vigor and employ the most optimum competency to regain or gain the competitive advantage. So, you can see that according to the business environment and according to the life stage of the organization, the role of HR can change from a strategic partner to change agent to administrative expert to employee champion. Ideally, HR has to play all the roles at the same time. In last few years, at least in particularly in 2 decades, the HRM function has transitioned and is supposed to transition from being reactive to proactive. That means, they may not keep looking at the lagging indicators, they need to look at the leading indicators and proactively suggest the ways of enhancing productivity or enhancing the engagement of the employees to the management, to the business leader more proactively. HR cannot just remain prescriptive, they need to actually set up the systems and processes and help the business to set up the systems and processes according to the nature of the people working in the organization. HR function has to also transition from being administrative, where the job is more giving instruction, to executive, where the job of HR function is more hands on, wherein they look at the systems and processes and work in close contact with the other functions of organization.
Swayam Prabha. Digital India. Educated India.
Now, we will look at the strategic human resource management, because it is closely connected to HR function. To understand the strategic management, we must first look at what is a strategy. The word strategy originates from strategos, that means a general who organizes, leads and directs his forces to the most advantageous position. So, the main emphasis of a strategy is to enable an organization to achieve a competitive advantage with its unique capabilities by focusing on present and future direction of the organization. In a classical strategic management process, we start with establishing a mission statement. What is the mission statement? Mission statement is the statement of the reason for the organization to exist. Here we must distinguish mission statement and vision statement as well. Mission statement is the statement of the reason to exist, wherein vision statement is about how an organization sees itself in the long term. Vision may not get implemented in the near future or even foreseeable future. vision by definition has to be inspiring. Mission also has to be inspiring, but this gives the reason for existence, and mission is more related to regular engagement of the organization with its various stakeholders. So, after establishing mission and vision statement, organization need to keep analyzing the external environment. They need to conduct an internal organizational analysis. Many of you must have come across terms like SWOT analysis or BCG matrix or G 3x3 matrix or McKinsey's 7S framework. These are some of the examples of doing internal organizational analysis. Based on the internal organizational analysis, we set the specific goals. Goal setting thing setting a specific goal has been understood very well in the movement of management by objective. The movement was started by Peter Drucker in 60s and 50s. There was lot of emphasis on mutual goal setting, translating the strategic goals into the operational goals, and translating the organizational operational goals to the departmental goals, and so on and so forth at the level of employees, and that has to be done with the mutual agreement and negotiation between the different levels of organization, different hierarchical levels of the organization. So, after doing the organizational analysis, business organization need to set the specific goals, then examining the possible strategic choices. A thing cannot be called strategy if that does not involve choice. There has to be certain choices for a disposition to be called a strategy. What are those most general, what are the most prominent choices a business organization faces? We are going to look at in a short while, but adaptation and implementation of choice is the very next step after the setting and specific goals, and then this process has to be supported by regular monitoring, regular evaluation. Mission, vision, strategic option, long term objectives, if they are set up and the follow up is not taken regularly, if the matrices are not developed to regularly check the movement of the organization, departments, functions, teams and employees, that strategy cannot get implemented. So, the regular evaluation is equally important aspect of a strategic management process. In the real life, you might have come across in many business organizations, if you ask what is your strategic document, many organizations may not have a strategic document, but organizations generally have a long term objective and they have a tentative theory based on which they wish to achieve those objectives. A strategy actually emerges in response to evolving situation, and as a result of that, one document may not remain relevant for a very long time, but there is an essential feature which is the interaction of the business and environment at the interface of which strategy evolves. Effective strategies combine deliberation and control with flexibility and organization learning. What it means? It means there is a equally important aspect called reflection at the organizational level along with action for strategy formulation. Organization once set up this strategy need to keep scanning the environment and should be flexible enough to change the course of action. Organization also have to keep learning like individual which learn in order to cope up with environment, which learn in order to respond to the external stimulus or external stimuli. Organizations also have to learn. like individual, where learning may start with intuition or concrete experience and may lead to abstraction, conceptualization and experimentation. Business organizations also can look at the learning in the form of their insights, in the form of observations of those insights, application of some of the actions arising out of those insights, and institutionalization of some of the systems processes within the organization. So, strategy is a dynamic process that includes reflection, learning, and has to have flexibility. A long term business strategy must be based on core idea about how the firm can best compete in marketplace. So, popular term for this core idea is called generic strategy. Generic strategies are generally of three types. You look at this slide column wise. So, there are three types of generic strategies proposed in the literature: the cost leadership, differentiation and niche. According to the generic strategy, management processes and system are differently designed and implemented in any business organization. According to generic strategies, organizations and people working in those organizations require different sets of competencies and resources. So, now we will look at the different management processes, systems, competency and resource required to implement three different generic strategies. First is cost leadership. An organization following the cost leadership claims or aims at providing goods or services at the cost which no other competitor can provide in a particular market. So, naturally, the processes, the management processes and system in the organization following the cost leadership has to be efficiency driven. These organization operates on the economies of the scale, and in these organization following the processes masterfully, efficiently following the processes is the essence of the management system. So, we can also imagine what is the kind of competencies required in the management in an organization which is following the cost leadership. So, the first and foremost, the organizations following cost leadership has to operate at the tight cost control. They have to have a tight management control system as well to ensure to lock any pilferage in the resources. Generally, organizations following cost leadership has to have structured organizational responsibility. There has to be a predictability to enhance efficiency in any system, and that predictability comes with the clear structure of the organizational responsibility. It is also must be noted that organizations following the cost leadership generally measure their performance in the form of very objective and measurable parameters. In order to have objective and measurable parameters, organization responsibility have to properly structured and communicated. Second generic strategy is called differentiation. An organization following differentiation strategy aims at providing services or product which no other competitor can offer in the marketplace. So, naturally these organizations are innovation driven, they are generally driven by unique capability. Many of you might be thinking about Apple as an example which is following the strategy of differentiation. These are organizations which are generally engineering excellence. You see in the Apple products, they are engineering marvel as well as design marvel. When an organization is aiming at providing services or product which no other business organization is capable of providing in the marketplace, naturally they have to have a strong emphasis on R&D, but that R&D cannot be for the R&D sake. That R&D or research and development cannot be for just knowledge creation. It has to result into some product and services which customers must value. Because of this requirement, the R&D department of the organizations following differentiation strategy has to work in the very close collaboration with marketing department. They provide incentives to their managers and employees not on the efficiency, but they provide most valuable incentive to their managers and employees for value adding innovations. They have to be very flexible and have to develop agile organizational system. Third generic strategy is called niche or focused. When an organization is providing a service or product which is uniquely entertained, which is uniquely desirable by a niche of a market segment, just a slice of a huge market, we can call organization following the niche strategy. Niche strategy emerges at the combination towards a particular segment. So, whatever is most desirable for a particular segment, they closely build the association with the customers. That is why the customer intimacy is a very important feature of organization following the niche strategy. They consistently offer unique product, and within that segment they keep improving the product as well. Many of you might be thinking about some product like Harley Davidson, or in India Bullet. If you look at the total market size of the Harley Davidson in comparison to the general all motorbikes, that may not be very high, but their customer segment is very committed for that product, and this company, the Bullet or Harley Davidson, closely work with their customer segment in order to create the events, in order to build the community among themselves, etc. So, these are the examples of organizations following the niche generic strategy. Looking at this description, you can see how HR function will be very different in organizations following different generic strategy. For example, recruitment. Recruitment in an organization following cost leadership will look at the efficiency oriented parameters and competencies amongst its prospective employees, whereas a recruitment process in an organization following differentiation strategy will look at the innovativeness, will look at the high qualification and experience of developing novel things, thoughts, services or product in any new recruit in the organization. Organization following the niche strategy will aim at recruiting people who have a strong knowledge base about that particular niche or that particular product which organization is servicing or offering. Similarly, we can look at how the training and development function will be different in the organization following different generic strategy. So, if we take the example of training and development in the organization following cost leadership will be focused on efficiency, following the systems and processes, making people aware of the best practices, etc. Whereas in the differentiation, the emphasis of training and development of the employees in the organizations will be about helping them to innovate more, helping them in creative thinking, etc. Whereas the training and development function in an organization following the niche strategy will be aiming at making the employees more well versed and bring the employees closer to the preferences and needs of their segment which they are very specifically serving. Similarly, we can look at the functions like compensation management, time management, performance management system, etc., how they will be different in the organizations following different generic strategy. What are the deliverables of the HR function? We need to understand the deliverable for production function is to produce as many product as possible in as less time as possible. So here we park our discussion on the connection of strategy and HR function.
Swayam Prabha. Digital India. Educated India.
The next question is, if we have to assess the contribution of HR function to the whole organization, what will be the parameters? What are the deliverables of HR as a function? Like marketing deliverable is to market the product, like production department has a deliverable to produce the product and services in the most efficient way. In the same manner, what are the deliverables of HR function? So deliverables for HR function are considered to be mindset, technical knowledge of the employees, and behavior of the employees. Mindset is the combination of attitude, belief, commitment, motivation, morale of the employees. Technical knowledge is related to the specific technical knowledge and general technical knowledge required to function in an organization. And technical knowledge is not only related to the production or innovation, it can also be related to following the safety norms, or it can be also about following the simple processes and systems. Then comes the behavior. Organization member should behave in a way which is good for the team and for the organization. The role of HR is being influenced by some of the major changing elements in our environment. These changing elements or trends can be clubbed in the four broad streams: globalization trend, technological trends, trends in the nature of work, and workforce demographic changes. Globalization, we all know, is about sales or manufacturing of the services and product in the country outside of the country where the company was established. We know that globalization has been a major change force in last 80 years. A World Trade Organization was formed to promote globalization or global trade. Intellectual property is also part of this global trade. There are some regional blocks also constituted to promote the inter-country trade and exchanges, like North American Federation or European Union. Globalization has increased competition and has given immense choices to the customers. As a result of that, customers are becoming more and more demanding, and that is putting pressure on the employees to offer their best and better always next time. Then there are some technological trends. Today's time is perhaps most interesting time in terms of technological developments and how the different technological developments are affecting all spheres of life. So naturally, HR function is also bound to be affected by the technological trends. Just one example, few decades ago, or say just 1 decade ago, most important source for recruitment used to be the manpower consultant or recruitment consultants. Now can you think about who is the most reliable sourcing consultant for the organizations? That is not an animate organization, that is LinkedIn. LinkedIn has become one of the most sought after source, one of the most reliable source for identifying the potential recruits. Similarly, artificial intelligence and robotics are changing all aspects of the HR function. We can take example of an Indian company called Zing HR. They offer the cloud based HR services to their clients, and now they have also connected their function through based on AI and robotics. As a result of this, they are creating a self-learning system. These are just examples of some of the technological trends which are affecting all aspects of the HR function, whether it is related to performance management system, recruitment, training and development, compensation management, etc. Nature of work is also changing in conjunction with the change and development of technology. Organizations like Ola, Uber, Allianz, these are the organizations of the so called employees which are not employees in a conventional sense. These employees choose the working hours for themselves, and they are loosely connected to the core organization. This is the change of the trends in the nature of work. Now we see so much emphasis on working from home, using technology, particularly the information technology, to work from home. We are also seeing the workforce demographic trends are changing. In any society, population follows a particular trend. Currently, India is a young society. The average age of India is about 28 years, but it is not going to remain same. In next 7-8 decades, the average age will be much more of India in comparison to what it is today. In that situation, we will require a different kind of HR systems and processes to support the aging workforce. This situation is already there in Japan, in many European countries. This is one kind of the change in the demographic trend, which will keep coming in few decades, or which will keep coming in different forms in different societies. Currently, we are also talking about generation X, generation Y, or called millennials, and their entry into the workforce. They are different in terms of their aspirations, in terms of their exposure, and as a result of that, their expectation from workplace and supervisors are different from the people of the earlier generation. This can be understood as a challenge or must be understood as a inevitable trend in the workforce. So, these are the important trends which are affecting the human resource management function. I would like to point out some of the questions, some of the pointed questions, and each HR has to answer these questions to put up what value they are bringing to the business organization. Do employees know and understand the firm's strategy? This is first question HR must answer to itself and to the business leadership. Do employees know and understand the status of the firm's success with respect to the pursuit of that strategy? Do employees know and understand the firm's value proposition and how that is delivered in the marketplace? Do employees know and understand what they are to do, what is expected from them? Do employees believe they have the skills and knowledge necessary to do their job? Are employees provided the managerial support and support system to do a job to the best of their ability? We all know that India is enjoying the demographic dividend, meaning having a large pool of skilled large pool of the youth population, a working population, but that is not sufficient. The youth population also have to have strong skill sets which are relevant in the marketplace. HR has to keep asking within the organization, do people have appropriate skills and competencies to deliver what is expected from them? Last but not the least, what level of competency is necessary in strategic resource positions now? How many truly A players are in the A positions? Do we have the best people populating the most critical positions in the organization? Are our leaders behaving in the way that elicit followership? Nothing inspires more to the employees than leaders' behavior. So, HR need to look at the leaders as well as employees in terms of their behavior, their mindset, and the competencies.
Swayam Prabha. Digital India. Educated India.
Friends, towards understanding the evolution of delegated legislation in India, we would take a two-pronged approach. We will understand the evolution in a two-phased manner, wherein we would first study the evolution of delegated legislation in the pre-constitutional period, that is prior to 1950, and the evolution of delegated legislation subsequently, after the adoption of the constitution. In this context, it is pertinent to note two various cases which were decided prior to the adoption of the constitution. This leads us to a discussion of R versus Burra, a matter decided by the Privy Council. The case before the Privy Council was an appeal which was from the High Court of Calcutta as it then existed. Now, the appeal before the High Court of Calcutta was filed by persons who were convicted of murder and sentenced to death. Now, in this manner, the reason as to why they were sentenced to death was because the courts which were there in Khasi, Jaintia and Naga Hills were removed from the jurisdiction of the civil and criminal courts that were established in the country, and thereby which the Lieutenant Governor was allowed for extension of those particular laws, which was essentially applicable to the Garo Hills by virtue of an 1869 legislation. The power to extend the laws to other territories was the question before the honorable courts to determine whether such delegation of power was an excessive delegation or not. It is pertinent to observe that the High Courts of Calcutta were predominantly oriented as to how the judicial minds in UK were trained. They regarded that the Indian provincial governments were a subordinate to that of the UK Parliament, and as such, a further delegation by the Indian Parliament to the Lieutenant Governor would be treated as an excessive delegation, and such sub-delegation is not permissible under law. On appeal, however, the Privy Council reversed the decision of the Calcutta High Court and held that the Indian legislature was not a delegate of the Imperial Parliament and had plenary powers of its own legislative powers, and the same was on similar lines as that of the Imperial Parliament itself. Although it did agree that the Governor General could not by legislation create a new legislative power or create any other subsequent authority, but however, if the power was given to the Lieutenant Governor to extend the applicability of certain laws that were passed by the provincial legislature, the said power was a competent delegation of legislative power, and as such delegation is a valid delegation. Similarly, in Jatindranath versus Bihar, the question arose with regard to the Bihar Maintenance of Public Order 1948. In this case, the question arose as to the extension of the law for a further period than for which it was made for. Under this law, a particular provision allowed for the extension of the act for a further period beyond 1 year, which was essentially passed by the legislature. In this case, the majority of the federal court held that such an extension of a period is unlawful and is an invalid delegation of power. However, friends, I would like you to note that in this case, Justice Fazal Ali gave a dissenting opinion, in the sense he gave a contrary view, and he was a minority bench in this, wherein he observed that the particular extension is correct and the particular extension is a valid delegation of power. And this particular observation is the correct observation that was made by Justice Fazal Ali. And as such, these two cases predominantly created the validity of delegated legislations in India. On adoption of the Constitution in 1950, India adopted a democratic model, and the powers of the sovereign were vested in three bodies, which is the legislature, executive and judiciary, thereby embarking a separation of the sovereign power in these three bodies. Pave way for understanding that the separation of judiciary from the executive and the legislature is essential for having a successful democratic model. In this context, the In Re Delhi Laws Act matter, which arose before the Supreme Court, becomes relevant to understand to what extent the legislative power can be exercised by the executive. The matter concerning the Delhi Laws Act of 1912 was the first case on delegated legislation that was determined by the Honorable Supreme Court of India. The matter concerning the Delhi Laws Act was brought before the Supreme Court by means of a reference that was made by the President of India under Article 143 of the Constitution. The query that was put before the Honorable Supreme Court was with regard to the power of the central government under Section 2 of the Delhi Laws Act, which allowed for extension of the particular laws that were applicable to Part A states to states that were enumerated under Part C of the particular Act. With the adoption of the Constitution, the states were reorganized and Part A, B and C states were created, and various states were enumerated depending upon their administrative capacity. Now, under the Delhi Laws Act of 1912 and the Ajmer-Merwara Act of 1947, there were a particular aspect of regulatory regime that was created by virtue of which the central government was authorized under the said act to extend to any Part C state such legislative provisions with such modification and restrictions as the central government may deem fit, so long as such enactment is similar to that nature which is already in force in a Part A state. The provision was so enumerative and exhaustive that it gave complete freedom to the central government to make any modification to any existing law that prevailed in such Part C state. The Supreme Court was to determine the legality of this provision. It is to be observed that all 7 judges who determined this matter gave separate opinion on this particular topic. The question pertinently was whether the legislature in India could be permitted to delegate its legislative power, and if yes, to what extent. It is to be observed that the majority of this judgment observed that delegation of legislative power in India is a valid delegation, but however, it is subject to 2 foremost limitations. Firstly, an executive cannot be authorized to repeal a law which is already in force, and thus under the particular legislatures, that is the Delhi Laws Act and the Ajmer-Merwara Act, the provision which empowered the central government to repeal an existing law in force which was there in Part C state was held to be wrongful in nature and as such void. And secondly, it was also observed that while exercising such delegated power of modification, the legislative policy should not be changed. In the sense, the particular subordinate legislation which is brought forth should always be in consistence with the parent legislation which is there in force. As such, substantive alteration or modification is something that cannot be allowed by virtue of delegation of this legislative power. And to this day, we follow this particular premise wherein wherever there is a legislative action that is taken by virtue of a delegated legislation, and if the same is not in consonance with that of the parent law or the supreme law, then in those circumstances, the subordinate law or the child law is held to be bad in law and as such void. The pertinence of the Delhi Laws Act matter is something that has taken the foremost manner of discussion and deliberation to understand the evolution of delegated legislation in India. While on one hand, the judiciary observed that delegation of legislative power is permissible to the executive, on the other hand, it clearly allowed for a particular framework or a particular manner in which a demarcation for the extent on which such power can be exercised by the executive, and as such bringing the contours on which delegation is permissible in India. With this, we move on to the next aspect, which deals with the functions that can be delegated to executive authorities. You may have observed that in every statute there is a particular clause which is known as the appointed date clause, wherein it empowers the relevant central government or the state government to appoint a particular day on which such act can come to force. In those circumstances, is this a particular provision that can be given across for delegation of such powers? The courts on numerous instances have held that appointed date clauses are valid. Take the cue of the Legal Services Authorities Act of 1987. This law, although it was passed in the year 1987, was only brought into force in the year 1997 after a long gap of about a decade. Now, if you notice this, one of the reasons as to why this power has been extended to the government to bring in across the implementation of the law is because implementation of legislative acts require certain administrative setups that is to be made. And as such, appointed date clauses, which allows for the central government or any other state government the power to notify as to when the act becomes applicable, is a valid delegation of power. The second aspect wherein the functions that are generally delegated by in the form of delegated legislation is with regard to supplying of certain details. The legislature gives the broad framework on which the law becomes applicable, and as such the central government is given across the further delegated power to supply for essential details as to how the law is to be implemented. In this context, a case concerning the particular manner in which the legal profession is to be governed is essential to be discussed. The matter pertains to Hansraj L. Chulani versus the Bar Council of Maharashtra and Goa. Now, in this case, the facts were of such nature that the State Bar Council had framed a rule upon the aspect of right to practice legal profession. And under this rule, it disqualified persons if they are engaged in any other occupation. The matter arose as to whether a person who is carrying on the medical profession in the form of as a doctor can carry out the legal profession or not. The delegated rule, which was formed by the State Bar Council, was challenged before the courts of law. The Honorable Court clearly stipulated that this was not an excessive delegation and the rule was valid because the entire scheme and purpose of the act was stipulated by virtue of supplying details which was done in the rules. Essentially, practicing a legal profession requires that the person does not engage in any other alternate occupation that requires his full time and devotion. A second aspect of understanding as to how supplying details is essential for creation of delegated legislation can also be observed while looking across to the Minimum Wages Act. Under the Minimum Wages Act, the central government is given the power to essentially determine to which particular industries the Minimum Wages Act becomes applicable. In Edward Mills Company versus State of Ajmer, the query arose on the same Minimum Wages Act of 1948, wherein the power of the appropriate government to add other industries to the schedules to which Minimum Wages Act is applicable was challenged as an excessive delegation of power. It was held that the opinion of the government was given the foremost importance under the legislative mechanism, and there was no said bridled powers on the basis of which the central government was authorized to decide the matter as to whether an industry should be included in the schedule or not. Please note, friends, the Supreme Court, taking into the nature on the basis of which the legislation has been formulated, which is the welfare of workers, clearly stipulated that such a delegation of power is a valid delegation of power, and the Supreme Court upheld the validity of the Minimum Wages Act. The further function that may be delegated to the executive is that of inclusion and exclusion. As observed in the Delhi Laws case and the case concerning the Minimum Wages Act, it is quite essential that the power to include is something that is a valid delegation of legislative power. Now, this allows for various aspects as to how the legislative policy can briefly be set up, and the government is empowered to extend the applicability of such legislative policy to suitable mechanisms which can be provided by way of inclusion or exclusion of certain industries. In this context, it is pertinent to observe the matter concerning Hamdard Davakhana versus Union of India, which was one of the particular instances where a central law, which is essentially the Drugs and Magic Remedies Objection Advertisements Act of 1954, was held to be invalid on the ground that it allowed for excessive delegation of power. Now friends, when we spoke about the aspect of the power of inclusion or exclusion, please note that this power should always come across with around the aspect of provision of flexibility to the executive to allow for legislative policy implementation. But however friends, it comes with the rider that such power to allow for flexibility should always be curtailed by certain restrictions that is placed under the Act. Now under the Hamdard Davakhana case, the Drugs and Magic Remedies Act allowed for enlisting various lists of diseases under the particular schedule by the central government. It was held by the Supreme Court that the said provision to include the list of various diseases did not have any particular principles, criteria or standards that was laid down for identification of such particular diseases, and as such it was held that this is an excessive delegation of power. A further aspect of delegation of power is the power of suspension. Few of the enactments allow for the appropriate government to suspend or relax the applicability of a certain legislative provision to a particular entity, subject matter or territorial jurisdiction. In those circumstances, it is to be observed that the power of suspension is an essential function that can be delegated, because there may be certain exigencies that may arise whereby the following the legislative procedure may result in an untoward incident or may be something that cannot be done in the scheme of things as to how the facts and circumstances unfold. For instance, under the Banking Regulation Act of 1949, the central government, on representation that is made by the Reserve Bank of India, the supervisory central bank of India, that the applicability of the particular provisions under the Banking Regulation Act required to be suspended, the central government may, for a period of up to 60 days, suspend the operation of all or any of the provisions of the Banking Regulation Act from being applicable to any specified banking company. Now, this particular power involves in itself the power for suspension of the application of the Act, and as such it is a valid delegation of power, because the circumstances of some nature may have arisen whereby the banking company is unable to fulfill the requirements of the Banking Regulation Act. But however, the failure of any banking institution may relate or lead to the collapse of the entire financial system, as that happened in 2008-2009 in US, where two major banking institutions collapsed. Now such power, which is provided under the Banking Regulation Act of 1949, may prevent a scenario that had occurred in 2008 in India. The next function that can be delegated to an executive authority is the application of an existing law. We have already looked across of this particular power of delegation in the Delhi Laws Act of 1912. So it is quite clear and evident that by extending the application of the existing law to other states, there is no excessive delegation or wrongful delegation of legislative power. But however, so long as the delegation or the legislative policy is not in inconsonance with that of the Constitution, whereby an excessive delegation structure is created, where there is a power that is given across to the executive to make across the application with, say, such amount of changes whereby the exact legislative policy itself is being abdicated. In those circumstances alone, the extension of application of existing laws will be held to be an excessive delegation. But otherwise, where the legislative policy is remained intact and has the necessary controls or checks and balance for exercise of such application of existing laws, such a delegation is a valid delegation. The next power, modifying existing statutes to suit the application requirement. We have already discussed in the Delhi Laws Act case that the power to modify is something that should be exercised with abundant caution. The legislative function, in order to ensure flexibility to the executive, cannot be given with unbridled powers to modify the exact legislative policy or scheme that the legislation tries to achieve. Modification is essential to come with bridled powers of checks and balances, and so long as such checks and balances are there, the same shall be treated as a valid delegation. Two factors need to be considered at the time of determining whether the modification is a valid delegation or not. Firstly is the need for such delegation, and secondly, it is the danger or risk of misuse of such power by the executive. The next aspect of functions that is delegated is generally that of the power to prescribe punishments. The power to prescribe punishments, generally of punitive nature, is given to either the central government or the state government or any other authority that is created by virtue of a statute. Generally, this power involves a delegation to the executive for punitive actions. It is essential to note that under this particular power, while exercising the same, it is essential that the statute contains the contours to the maximum punishment that is required to be provided, and where a delegation is given to any particular governmental authority who is created by a statute, there is a particular government approval that is provided for a check and balance to ensure that the power is not misused. An illustration of such delegated power is contained under Section 37 of the Electricity Act of 1910, whereby the Electricity Board has been empowered to prescribe punishments for breach of the Electricity Act of 1910. Further, similarly, under Section 59 of the Damodar Valley Act of 1948, the power to prescribe punishment has been delegated to a statutory authority without a maximum limit fixed under the said Act. Now, these are two contrasting examples for your comparison. Further, it is essential to note that whenever such a power is given, something that is of similar nature to that of the Electricity Act is essential to be followed. The next function, which is also often delegated under various statutes, is that the power of framing of rules. Now, if you look at it, we have already discussed this when in the initial discussion about delegated legislation, that in most legislations you will find that either the central government or the state government has been given the power to prescribe rules. In few other instances, the power to make such rules has also been delegated to a statutory authority or a particular professional body. In this context, the discussion that we had earlier in Hansraj L. Chulani versus Bar Council of Maharashtra and Goa is pertinent to be observed. And as such, so long as the rules are in line with the parent enactment, so long as the delegated legislation is in consonance with the particular supreme legislation, the said rules is valid and has to be observed. Where the said contours of the particular validity of the rules is to be challenged, it is essential to prove that the rules are not in consonance with that of the supreme law, or that it is in a manner that is against the fundamental rights. The last form of delegated legislation that you fall out as a function is generally the removal of difficulties clause that is found in a legislation. Friends, it is the removal of difficulties clause is also called the Henry VIII clause to indicate the manner in which the Henry VIII, who was the earlier king of England, who during his regime had an autocratic manner of governance. He would ensure that his will was enforced and all his difficulties were removed by ensuring the instrumentality of a parliament that was extremely weak in nature during his regime. The various critiques of delegated legislation and that of the staunch proponents of the doctrine of separation regard the removal of difficulties or the Henry VIII clause as the most preposterous of delegated legislation or delegated functions. It is provided that such clauses which provide for removal of difficulties must be bridled with extreme caution and worded extremely carefully so as to allow for the narrow interpretation of the same and not provide for a widest interpretation of the said clause. It is pertinent to note that although the critics against the Henry VIII clause or the removal of difficulties clause, it is essential that such a clause prevails in a legislation. It is so because the legislature cannot always foresee what the outcomes of implementing a legislation can be. It may so happen that upon implementing the particular legislation or statute, there may be several difficulties that may come across as that of opening of a Pandora's box. And in order to ensure that the opening of such Pandora's box does not arise in implementing the legislative scheme or policy, the Henry VIII clause or the removal of difficulties clause is essentially inserted into a legislation. Under these particular manners, the appropriate authority, which could be either be the central government or the state government or a prescribed authority, is given the power to either pass the rules, regulations or orders or certain bylaws in order to ensure the smooth functioning of the legislative policy. To illustrate this, we would refer to section 37 of the Payment of Bonus Act of 1965, whereby under subsection 1 of section 37, it was provided that the central government was empowered to make such orders not inconsistent with the purposes of the Act. Further, it was provided under subsection 2 that the order of the central government, which was passed under subsection 1, would be final. Although subsection 1 looks to provide across a particular narrow worded clause, subsection 2 made it an unbridled power because there were no questions that was to be laid to any action that was taken by the central government under section 37 subsection 1. It was challenged in Jalan Trading Company versus Mill Mazdoor Union, wherein the Supreme Court was called upon to question the legality of section 37 of the Payment of Bonus Act 1965. The Supreme Court, by a majority of 3:2, held that section 37 was ultra vires the Constitution of India on the ground of excessive delegation. It was provided that the central government was made the sole judge of whether any difficulty or doubt would have arisen in the particular implementation of the legislation. And as such power was an autocratic form of exercise of delegated legislation, hence the same was invalid. Although the majority took a view that section 37 of the Payment of Bonus Act was amounting to an excessive delegation, it is pertinent to also understand the view of the minority. The minority in this matter took a liberal interpretation of the aspect of delegated legislations and observed that the powers and functions that were delegated to the central government by in no means were a legislative function, but rather it was something that was in order to devise the legislative policy in implementation. In words of Justice Hidayatullah, who later on went on to become the Chief Justice of India, Parliament has not attempted to set up another legislature. It has stated all that it wished on that subject of bonus in the Act, apprehending, however, that this application of the new Act, doubts and difficulties may arise, and not leaving their solution to the courts with the attendant delays and expense, Parliament has chosen to give the power to the central government to remove doubts and differences by a suitable order. It is to be observed that the minority in this particular matter, that is Jalan Trading Company, took this liberal perspective on the basis that the Payment of Bonus Act was more of a welfare legislation, wherein there was a stance that the welfare of the laborers could be affected because of the interference of the judicial system. And as such, the finality clause that was given to the orders that was passed by the central government was said to be justified. It is said that generally, Henry VIII clauses have to be bridled with power. But the view of the minority is also something to be observed and cherished. In this circumstance, it is essential to understand that not all removal of difficulties clauses would amount or tantamount to an arbitrary exercise of power. The purpose of the statute needs to always be looked at before coming to a conclusion whether such a delegation of power is excessive or not. With this, we come to the end of the discussion of various functions that may be delegated by way of a legislation.
Swayam Prabha. Digital India. Educated India.
Friends, towards understanding the evolution of delegated legislation in India, we would take a two-pronged approach. We will understand the evolution in a two-phased manner, wherein we would first study the evolution of delegated legislation in the pre-constitutional period, that is prior to 1950, and the evolution of delegated legislation subsequently, after the adoption of the constitution. In this context, it is pertinent to note two various cases which were decided prior to the adoption of the constitution. This leads us to a discussion of R versus Burra, a matter decided by the Privy Council. The case before the Privy Council was an appeal which was from the High Court of Calcutta as it then existed. Now, the appeal before the High Court of Calcutta was filed by persons who were convicted of murder and sentenced to death. Now, in this manner, the reason as to why they were sentenced to death was because the courts which were there in Khasi, Jaintia and Naga Hills were removed from the jurisdiction of the civil and criminal courts that were established in the country, and thereby which the Lieutenant Governor was allowed for extension of those particular laws which was essentially applicable to the Garo Hills by virtue of an 1869 legislation. The power to extend the laws to other territories was the question before the honorable courts to determine whether such delegation of power was an excessive delegation or not. It is pertinent to observe that the High Courts of Calcutta were predominantly oriented as to how the judicial minds in UK were trained. They regarded that the Indian provincial governments were a subordinate to that of the UK Parliament, and as such a further delegation by the Indian Parliament to the Lieutenant Governor would be treated as an excessive delegation, and such sub-delegation is not permissible under law. On appeal, however, the Privy Council reversed the decision of the Calcutta High Court and held that the Indian legislature was not a delegate of the Imperial Parliament and had plenary powers of its own legislative powers, and the same was on similar lines as that of the Imperial Parliament itself. Although it did agree that the Governor General could not by legislation create a new legislative power or create any other subsequent authority, but however, if the power was given to the Lieutenant Governor to extend the applicability of certain laws that were passed by the provincial legislature, the said power was a competent delegation of legislative power, and as such delegation is a valid delegation. Similarly, in Jatindranath versus Bihar, the question arose with regard to the Bihar Maintenance of Public Order 1948. In this case, the question arose as to the extension of the law for a further period than for which it was made for. Under this law, a particular provision allowed for the extension of the act for a further period beyond 1 year, which was essentially passed by the legislature. In this case, the majority of the federal court held that such an extension of a period is unlawful and is a invalid delegation of power. However, friends, I would like you to note that in this case, Justice Fazal Ali gave a dissenting opinion, in the sense he gave a contrary view, and he was a minority bench in this, wherein he observed that the particular extension is correct and the particular extension is a valid delegation of power. And this particular observation is the correct observation that was made by Justice Fazal Ali. And as such, these two cases predominantly created the validity of delegated legislations in India. On adoption of the Constitution in 1950, India adopted a democratic model, and the powers of the sovereign were vested in three bodies, which is the legislature, executive, and judiciary, thereby embarking a separation of the sovereign power in these three bodies. Pave way for understanding that the separation of judiciary from the executive and the legislature is essential for having a successful democratic model. In this context, the In Re Delhi Laws Act matter, which arose before the Supreme Court, becomes relevant to understand to what extent the legislative power can be exercised by the executive. The matter concerning the Delhi Laws Act of 1912 was the first case on delegated legislation that was determined by the Honorable Supreme Court of India. The matter concerning the Delhi Laws Act was brought before the Supreme Court by means of a reference that was made by the President of India under Article 143 of the Constitution. The query that was put before the Honorable Supreme Court was with regard to the power of the central government under Section 2 of the Delhi Laws Act, which allowed for extension of the particular laws that were applicable to Part A states to states that were enumerated under Part C of the particular Act. With the adoption of the Constitution, the states were reorganized and Part A, B, and C states were created, and various states were enumerated depending upon their administrative capacity. Now, under the Delhi Laws Act of 1912 and the Ajmer-Merwara Act of 1947, there were a particular aspect of regulatory regime that was created, by virtue of which the central government was authorized under the said act to extend to any Part C state such legislative provisions with such modification and restrictions as the central government may deem fit, so long as such enactment is similar to that nature which is already in force in a Part A state. The provision was so enumerative and exhaustive that it gave complete freedom to the central government to make any modification to any existing law that prevailed in such Part C state. The Supreme Court was to determine the legality of this provision. It is to be observed that all 7 judges who determined this matter gave separate opinion on this particular topic. The question pertinently was whether the legislature in India could be permitted to delegate its legislative power, and if yes, to what extent. It is to be observed that the majority of this judgment observed that delegation of legislative power in India is a valid delegation, but however, it is subject to 2 foremost limitations. Firstly, an executive cannot be authorized to repeal a law which is already in force, and thus under the particular legislatures, that is the Delhi Laws Act and the Ajmer-Merwara Act, the provision which empowered the central government to repeal an existing law in force which was there in Part C state was held to be wrongful in nature and as such void. And secondly, it was also observed that while exercising such delegated power of modification, the legislative policy should not be changed. In the sense, the particular subordinate legislation which is brought forth should always be in consistence with the parent legislation which is there in force. As such, substantive alteration or modification is something that cannot be allowed by virtue of delegation of this legislative power. And to this day, we follow this particular premise wherein wherever there is a legislative action that is taken by virtue of a delegated legislation, and if the same is not in consonance with that of the parent law or the supreme law, then in those circumstances, the subordinate law or the child law is held to be bad in law and as such void. The pertinence of the Delhi Laws Act matter is something that has taken the foremost manner of discussion and deliberation to understand the evolution of delegated legislation in India. While on one hand, the judiciary observed that delegation of legislative power is permissible to the executive, on the other hand, it clearly allowed for a particular framework or a particular manner in which a demarcation for the extent on which such power can be exercised by the executive, and as such bringing the contours on which delegation is permissible in India. With this, we move on to the next aspect, which deals with the functions that can be delegated to executive authorities. You may have observed that in every statute there is a particular clause which is known as the appointed date clause, wherein it empowers the relevant central government or the state government to appoint a particular day on which such act can come to force. In those circumstances, is this a particular provision that can be given across for delegation of such powers? The courts on numerous instances have held that appointed date clauses are valid. Take the cue of the Legal Services Authorities Act of 1987. This law, although it was passed in the year 1987, was only brought into force in the year 1997 after a long gap of about a decade. Now, if you notice this, one of the reasons as to why this power has been extended to the government to bring in across the implementation of the law is because implementation of legislative acts require certain administrative setups that is to be made, and as such appointed date clauses, which allows for the central government or any other state government the power to notify as to when the act becomes applicable, is a valid delegation of power. The second aspect wherein the functions that are generally delegated by in the form of delegated legislation is with regard to supplying of certain details. The legislature gives the broad framework on which the law becomes applicable, and as such the central government is given across the further delegated power to supply for essential details as to how the law is to be implemented. In this context, a case concerning the particular manner in which the legal profession is to be governed is essential to be discussed. The matter pertains to Hansraj L. Chulani versus the Bar Council of Maharashtra and Goa. Now, in this case, the facts were of such nature that the State Bar Council had framed a rule upon the aspect of right to practice legal profession. And under this rule, it disqualified persons if they are engaged in any other occupation. The matter arose as to whether a person who is carrying on the medical profession in the form of as a doctor can carry out the legal profession or not. The delegated rule, which was formed by the State Bar Council, was challenged before the courts of law. The Honorable Court clearly stipulated that this was not an excessive delegation and the rule was valid because the entire scheme and purpose of the act was stipulated by virtue of supplying details which was done in the rules. Essentially, practicing a legal profession requires that the person does not engage in any other alternate occupation that requires his full time and devotion. A second aspect of understanding as to how supplying details is essential for creation of delegated legislation can also be observed while looking across to the Minimum Wages Act. Under the Minimum Wages Act, the central government is given the power to essentially determine to which particular industries the Minimum Wages Act becomes applicable. In Edward Mills Company versus State of Ajmer, the query arose on the same Minimum Wages Act of 1948, wherein the power of the appropriate government to add other industries to the schedules to which Minimum Wages Act is applicable was challenged as an excessive delegation of power. It was held that the opinion of the government was given the foremost importance under the legislative mechanism, and there was no said bridled powers on the basis of which the central government was authorized to decide the matter as to whether an industry should be included in the schedule or not. Please note, friends, the Supreme Court, taking into the nature on the basis of which the legislation has been formulated, which is the welfare of workers, clearly stipulated that such a delegation of power is a valid delegation of power, and the Supreme Court upheld the validity of the Minimum Wages Act. The further function that may be delegated to the executive is that of inclusion and exclusion. As observed in the Delhi Laws case and the case concerning the Minimum Wages Act, it is quite essential that the power to include is something that is a valid delegation of legislative power. Now, this allows for various aspects as to how the legislative policy can briefly be set up, and the government is empowered to extend the applicability of such legislative policy to suitable mechanisms which can be provided by way of inclusion or exclusion of certain industries. In this context, it is pertinent to observe the matter concerning Hamdard Dawakhana versus Union of India, which was one of the particular instances where a central law, which is essentially the Drugs and Magic Remedies Objection Advertisements Act of 1954, was held to be invalid on the ground that it allowed for excessive delegation of power. Now, friends, when we spoke about the aspect of the power of inclusion or exclusion, please note that this power should always come across with around the aspect of provision of flexibility to the executive to allow for legislative policy implementation. But however, friends, it comes with the rider that such power to allow for flexibility should always be curtailed by certain restrictions that is placed under the Act. Now, under the Hamdard Dawakhana case, the Drugs and Magic Remedies Act allowed for enlisting various lists of diseases under the particular schedule by the central government. It was held by the Supreme Court that the said provision to include the list of various diseases did not have any particular principles, criteria or standards that was laid down for identification of such particular diseases, and as such it was held that this is an excessive delegation of power. A further aspect of delegation of power is the power of suspension. Few of the enactments allow for the appropriate government to suspend or relax the applicability of a certain legislative provision to a particular entity, subject matter or territorial jurisdiction. In those circumstances, it is to be observed that the power of suspension is an essential function that can be delegated, because there may be certain exigencies that may arise whereby the following the legislative procedure may result in an untoward incident or may be something that cannot be done in the scheme of things as to how the facts and circumstances unfold. For instance, under the Banking Regulation Act of 1949, the central government, on representation that is made by the Reserve Bank of India, the supervisory central bank of India, that the applicability of the particular provisions under the Banking Regulation Act required to be suspended, the central government may, for a period of up to 60 days, suspend the operation of all or any of the provisions of the Banking Regulation Act from being applicable to any specified banking company. Now, this particular power involves in itself the power for suspension of the application of the Act, and as such it is a valid delegation of power, because the circumstances of some nature may have arisen whereby the banking company is unable to fulfill the requirements of the Banking Regulation Act. But however, the failure of any banking institution may relate or lead to the collapse of the entire financial system, as that happened in 2008-2009 in US, where two major banking institutions collapsed. Now, such power which is provided under the Banking Regulation Act of 1949, may prevent a scenario that had occurred in 2008 in India. The next function that can be delegated to an executive authority is the application of an existing law. We have already looked across of this particular power of delegation in the Delhi Laws Act of 1912. So it is quite clear and evident that by extending the application of the existing law to other states, there is no excessive delegation or wrongful delegation of legislative power. But however, so long as the delegation or the legislative policy is not in inconsonance with that of the constitution, whereby an excessive delegation structure is created where there is a power that is given across to the executive to make across the application with, say, such amount of changes whereby the exact legislative policy itself is being abdicated. In those circumstances alone, the extension of application of existing laws will be held to be an excessive delegation. But otherwise, where the legislative policy is remained intact and has the necessary controls or checks and balance for exercise of such application of existing laws, such a delegation is a valid delegation. The next power, modifying existing statutes to suit the application requirement. We have already discussed in the Delhi Laws Act case that the power to modify is something that should be exercised with abundant caution. The legislative function, in order to ensure flexibility to the executive, cannot be given with unbridled powers to modify the exact legislative policy or scheme that the legislation tries to achieve. Modification is essential to come with bridled powers of checks and balances, and so long as such checks and balances are there, the same shall be treated as a valid delegation. Two factors need to be considered at the time of determining whether the modification is a valid delegation or not. Firstly is the need for such delegation, and secondly, it is the danger or risk of misuse of such power by the executive. The next aspect of functions that is delegated is generally that of the power to prescribe punishments. The power to prescribe punishments, generally of punitive nature, is given to either the central government or the state government or any other authority that is created by virtue of a statute. Generally, this power involves a delegation to the executive for punitive actions. It is essential to note that under this particular power, while exercising the same, it is essential that the statute contains the contours to the maximum punishment that is required to be provided, and where a delegation is given to any particular governmental authority who is created by a statute, there is a particular government approval that is provided for a check and balance to ensure that the power is not misused. An illustration of such delegated power is contained under section 37 of the Electricity Act of 1910, whereby the Electricity Board has been empowered to prescribe punishments for breach of the Electricity Act of 1910. Further, similarly, under section 59 of the Damodar Valley Act of 1948, the power to prescribe punishment has been delegated to a statutory authority without a maximum limit fixed under the said act. Now, these are two contrasting examples for your comparison. Further, it is essential to note that whenever such a power is given, something that is of similar nature to that of the Electricity Act is essential to be followed. The next function, which is often delegated under various statutes, is that the power of framing of rules. Now, if you look at it, we have already discussed this when in the initial discussion about delegated legislation, that in most legislations you will find that either the central government or the state government has been given the power to prescribe rules. In few other instances, the power to make such rules has also been delegated to a statutory authority or a particular professional body. In this context, the discussion that we had earlier in Hansraj L. Chulani versus Bar Council of Maharashtra and Goa is pertinent to be observed. And as such, so long as the rules are in line with the parent enactment, so long as the delegated legislation is in consonance with the particular supreme legislation, the said rules is valid and has to be observed. Where the said contours of the particular validity of the rules is to be challenged, it is essential to prove that the rules are not in consonance with that of the supreme law, or that it is in a manner that is against the fundamental rights. The last form of delegated legislation that you fall out as a function is generally the removal of difficulties clause that is found in a legislation. Friends, it is the removal of difficulties clause is also called the Henry VIII clause to indicate the manner in which Henry VIII, who was the earlier king of England, who during his regime had an autocratic manner of governance. He would ensure that his will was enforced and all his difficulties were removed by ensuring the instrumentality of a parliament that was extremely weak in nature during his regime. The various critiques of delegated legislation and that of the staunch proponents of the doctrine of separation regard the removal of difficulties or the Henry VIII clause as the most preposterous of delegated legislation or delegated functions. It is provided that such clauses which provide for removal of difficulties must be bridled with extreme caution and worded extremely carefully so as to allow for the narrow interpretation of the same and not provide for a widest interpretation of the said clause. It is pertinent to note that although the critics against the Henry VIII clause or the removal of difficulties clause, it is essential that such a clause prevails in a legislation. It is so because the legislature cannot always foresee what the outcomes of implementing a legislation can be. It may so happen that upon implementing the particular legislation or statute, there may be several difficulties that may come across as that of opening of a Pandora's box. And in order to ensure that the opening of such Pandora's box does not arise in implementing the legislative scheme or policy, the Henry VIII clause or the removal of difficulties clause is essentially inserted into a legislation. Under these particular manners, the appropriate authority, which could be either be the central government or the state government or a prescribed authority, is given the power to either pass the rules, regulations or orders or certain bylaws in order to ensure the smooth functioning of the legislative policy. To illustrate this, we would refer to section 37 of the Payment of Bonus Act of 1965, whereby under subsection 1 of section 37, it was provided that the central government was empowered to make such orders not inconsistent with the purposes of the act. Further,